Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber. I'm going to be with you for the next 3 hours as we take a deep dive into the double murder trial of rapper YNW Melly. Now, this defendant, whose birth name is Jamell Demons, faces 2 counts of first-degree murder in the deaths of his 2 friends, Anthony Williams and Christopher Thomas Jr. The victims, who went by the names YNW Sakchaser and YNW Juvy, were both aspiring rappers themselves. The Murder on My Mind rapper and his co-defendant Cortlen Henry were in the car with the 2 victims when they claimed that a drive-by shooting occurred. But for them, unfortunately, evidence later suggested that the gunshots took place from inside the vehicle, and this was a staged drive-by shooting. Day 6 is slated to start up any minute now. I'm going to keep a very careful eye on that courtroom feed. But as we wait, I want to go back to something that happened yesterday. So we heard a lot of forensic cell phone evidence yesterday, but at one point there were arguments over certain data that the defense didn't find permissible. So to kind of get you a better idea of what that was all about, let's take a little listen about the arguments from yesterday.
Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sakchaser Howard. Sakchaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamell Demons. It was retrieved from Jameson Francois, not Jamell Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that, definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter, all the information they're seeking to put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before.
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that goes back to this defendant.
Okay, let's break this down a little bit. I'm joined right now by law enforcement instructor Sonny Slaughter, along with criminal defense attorney and civil rights attorney Tyler Bailey. Great lineup. Look at my guest this morning. Fantastic. It's great to have you both here. Sonny, I'm going to start with you because here's the big takeaway from yesterday, in my opinion, right? Is that you didn't really hear anything about what this cell phone contents were, or even if it's directly tied to YNW Melly. It seems to me that there is a cell phone that could have been used by him, but might have been circulated by multiple people. Do you get the same sense there?
And that's exactly what I was thinking. I was wondering, is this like a community phone? What relevance does it have to the particular incident? Is there some information that the prosecution can tie directly to this incident that says that these individuals committed this crime, or there was some kind of conversation, and because the cell phone was used and the data that that the defense is talking about has to do with information that happened after he was arrested and incarcerated, even though he had the PIN number to open the phone, it's all questionable and speculative when you look at what they're asking for and what they're trying to do with it. I think we need to stay closer to the date of the incident, what happened, and if there's anything that they can tie to this particular crime being planned out. specifically.
Yeah, Tyler, let me throw it to you, right? So as we were just saying, the state wants to use this cell phone data from a phone that was still in use after the defendant was arrested. Doesn't make sense. Is it his or not? I mean, that seems like a pretty good basis for an argument from the defense, who, by the way, has been of the opinion that this investigation was botched and that law enforcement had tunnel vision and only focused on YNW Melly because he's famous. What's your take on it?
Well, first addressing the issue with the cell phone, I mean, the stakes are very high for the defense here. YNW Melly's life is technically on the line. I think the state is considering the death penalty. At the bare minimum, he would do life in jail. So to admit this cell phone evidence when there's a lot of fingers pointing to others using this phone, even when he was in jail, although he has a PIN number, I think the stakes are really too high for them to allow the cell phone evidence when it's highly prejudicial to Melly, and there's a lot of evidence pointing to others using the phone. In addition, defense lawyers, you have to zone in on biased law enforcement. When you're somebody like a star, like the defendant is here, it makes sense to paint a picture that the state has zeroed in on him for the jump, that he is guilty, listen to his songs and look at his demeanor. I think the state is kind of leaning on those things, but this evidence with the cell phone is really too unreliable and highly prejudicial. And hopefully the judge does the right thing. But if not, this is definitely an issue for appeal.
Well, let's talk about what the judge
they'll
did.
use in the future.
Yeah, and let's talk about what the judge did. The judge ultimately denied the defense's motion to leave this data out, but let's listen to his reasoning.
My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's not the methodology is and basically a Daubert issue on it. It's not clear. It's not been established. All those types of things that should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z. There, you're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial and probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying it's something's more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it.
All right, Sonny, I'll start with you. You agree with the judge?
Yes, I do. I think until they can connect the dots, this case is really about connecting the dots and not being all over the place. This is the reason why law enforcement investigative processes, along with the prosecution team, really matter. Making sure that they're not flying all over the place and that they have a straight line through with a conversation and a narrative that not only makes sense, but that is full of investigative and probative value to the jury, because that's what the jury is going to be looking at. What makes sense, what matters, and did they tie everything together? And in this particular incident, I don't think they have.
All right, going to turn over to you, Tyler. What do you think?
Well, I think the judge made a fair call. He noted the objection. The defense made their argument. At the end of the day, I think it gives the defense something to argue on appeal. Things don't go well for them at the trial court level if he's found guilty. I understand the judge's reasoning, saying that he does not necessarily know what's on the cell phone. At this point, they're just trying to keep the cell phone evidence out altogether. I'm sure they'll raise an objection when this evidence is offered to the jury, and they'll preserve it for the record.
Yeah, that's a big point, because we talked about it yesterday, too, how the defense lost their motion for a mistrial when it came to the testimony of Felicia Holmes, who was the defendant's ex-girlfriend's mother, and some questionable testimony that came in that the jury heard. The defense said that this was improper. The jury shouldn't have heard this. The judge denied that motion for a mistrial. But again, if their client is ultimately convicted on appeal, they can raise that issue. That is preserved on the record. Let's take a break. When we come back, we're waiting to jump live in this courtroom for a continuation of the YNW Melly trial. Stay with us. back, everybody. Thanks for coming back to our coverage of the YNW Melly double murder trial here on Law and Crime. Today is going to be day 6 of the trial against Jamell Demons, who faces 2 counts of first-degree murder in the shooting deaths of his 2 friends. Proceedings should be starting up any minute now. I'm keeping a careful eye on that courtroom feed. But in the meantime, we're going to go to the Broward County Courthouse because we have a very special guest. We want to introduce our boots on the ground, who is right outside of that courthouse, Law and Crime's very own Terry Austin. Good morning, Terry. Actually, I don't know if you're inside or outside the courthouse right now, but what's the atmosphere like?
Well, today we are inside the courthouse, right down from the courtroom, and it is really a little bit quiet right now. They haven't started up. I did see the witness from yesterday. That's FBI Special Agent Brendan Collins. He got on the stand yesterday. He's from the CAST unit, which stands for the Cellular Analysis Survey Team, and he just talked about his background information. He's going to get back up on that stand today. I will tell you that yesterday it was fairly intense. The jury was paying very close attention to these forensic analysis experts. Although they did not do much analysis, they did mostly just the collection and extraction. So we'll see what happens today with the FBI agent.
That's a little surprising to me. I thought that when you hear this kind of data, the jury might zone out a little bit, but it's good to hear that they're paying attention to it, because if you talk about yesterday, we talked about this before, excuse me, we heard a lot of the cell phone data evidence, and at one point the defense argued that that certain data shouldn't be permitted into evidence because one of the reasons was that multiple people had access to the iPhone even after the defendant, Mr. Demons, was incarcerated. What can you tell us about that?
Well, I know that there were 2 experts who were on the stand. Susan Johnson, she extracted the cellular data. And I do think that the defense was objecting because there were people who had custody and control of those cell phones, and it wasn't easy to authenticate that information. Plus the fact that she didn't analyze it at all. And on cross-examination, we did hear her say all she did was collect the data. And the exact same thing happened, Jesse, to the second witness who collected information. He collected that health data, and the objection from the defense as far as that was concerned is this information is not trustworthy.
We all ready to proceed?
If we could just approach briefly, Your Honor, I'd like to bring things to the court's attention.
I know I took one of the point is I get that back. Please. This is news to me. That's friends.
I'll double check. I don't think
So I don't think counsel was suspicious that the attorneys had anything to do with that. I don't know if that was you asking me to do it, so I appreciate it.
I certainly will.
And Sig and Gary come over. Do you have any information you need? Can you make sure they're squared down? Concerned about some of the
I'll call the sergeant now.
Is there an estimated schedule for the remaining trial? How many weeks left? That's the question.
Christmas. No. About the state's presentation, what do you guys expect?
that after she finishes her direct, if we could
I can't hear you, I'm sorry.
Sorry. If after she finishes the direct, if we could have a brief break so I can set up with the computer. All right, perfect. Thanks, Judge.
When Mr. AOC comes back, there's just one issue I want to raise.
I'm sorry.
May we approach very briefly? Come on, Pastor. There's nothing on the outside, but I asked the officers to start coming and just give me a signal. And I need to go outside and advise them that if you want to go to get over. Good.
You want to bring something up, Mr. Howard?
Yes, Your Honor. It needed to be sidebar, but the state just advised. If the court recalls yesterday, I was inquiring with the witness whether or not Miramar Police Department had any other software to test the results of their Cellbrite download on. He said no, wasn't done. The state advised me half an hour ago that there was another one done on another software in June of this year, which the state did not disclose, purportedly because we asked for discovery to be closed, even though the state opposed the closing of the discovery and the court denied closing discovery. Nonetheless, the state indicates that it failed to meet that discovery obligation because we were asking to close discovery, but wants now to introduce through another witness the fact that another analysis was done in June of this year. And we would object to that admission based upon the discovery violation and the ambush that would ensue.
So you're alleging there's a discovery violation, so when you allege that, I need to do Richardson here and just find out whether what you're saying is true and not true, and whether it's inadvertent or intentional, and make some decisions. You heard what the counsel suggested, so what are you telling me?
So Your Honor, in terms of there was an additional evaluation that was done, this was done, and the only reason why it's even coming up is because of counsel's questioning. So based on counsel's questioning and asking if there was additional or other ways to prove it, a different witness, Detective Moretti, did a second analysis of the cell phone. Because at the time when Detective Zeller had it and did this, they did not have an additional software program called Graykey. Miramar Police has then subsequently obtained the license for Graykey. So the state's position is that based on questioning by defense, the state then would instruct the witness to go and do an additional download of the phone on that. So that was done in June of 2023. On that, the phone and everything is the same. And the only difference is there's additional location data that is on the new download that was not on the prior download. So there's any more information on that. None of that is exculpatory or does anything to say that the defendant was not at the scene of the homicide and not there on that. The state doesn't have it in their possession yet. My understanding is it will be dropped off later this afternoon.
So is it fair to say then that defense requested whatever downloads there were, and a download, the Cellbrite download, was turned over to them?
Yes.
The first one?
Yes.
But there had been a second download done, And that download was not sent to them?
It's not yet even been turned over to the state. I'm waiting for it from the detective. He's going to be bringing it later this afternoon.
Okay, and when did this second happen?
That would have been about a week or 2 weeks ago. I'd have to double check on the date. I haven't seen it for the exact time.
So subsequent to the trial starting, you still were having downloads done?
In terms of if there was any other information, anything that was exculpatory, then I'd have to make sure that that was fully explored and turn that over to defense.
And so that it has been turned over to them, so the defense doesn't know anything about it. Mm-hmm. And then defense counsel asks questions about other possible programs that they might have had, because he doesn't know if there are any or not. And the witness, Zellner,
Yes.
answers that they don't have it. And so something that he doesn't know, that prior to his testifying, you've already run a second program through a different detective, Moretti, on a different system.
Yes, so the defense didn't depose Detective Zeller because then they could have asked questions such as, does Muir now have additional software that this could be done on? So they chose not to do so on that.
Question comes back to is when this second download was done on different software, that was just 2 weeks ago.
Yes.
When did you found out about it?
I still don't have a copy of it. I was talking with the detective last night on it. In terms of the download being done, I'd have to look and see exactly on the date and if it was being communicated to me about the results.
And who asked for the download to be done?
It was discussed with the detective in the pre-trials as to if there was any other information, if there was any updates to the Celebrate program, as Detective Zeller testified to, that sometimes downloads are redone once there is updates to the software.
So this is new information that Detective Zeller doesn't know about.
Correct.
And Detective Moretti hasn't been deposed about.
Correct.
And it's something that's new to you that you just came up with in your pre-trial. How long ago was that?
I'd have to look on the exact date on when that was.
Yeah, tell me what the date
sometime
was.
the week, I believe, of May 21st or 23rd, sometime at that, during the course of that week. As to when the actual analysis was done, I couldn't tell you right now because I don't have it yet. But, this is analogous to, for example, if defense were to cross-examine a witness about evidence that was tested or not tested. If they open that door, then the state would be able to go forth and send additional items for testing on that.
And to your knowledge, there's no cutoff on this record.
Correct.
Thank you. Anything else?
Yes, Your Honor. There were two questions that the court just asked the state, which I noticed were not answered. The first was, who asked for it to be done? The second was, when did you, Ms. Bradley, find out that it was done? Neither question was directly answered. Both answers were evasive. If I asked a question that precipitated the state going and doing further investigation, one, we again keep arguing that that is an ambush that affects the fairness of the trial, and that's why there needs to be a discovery cutoff. But also, that's not what occurred here. The state's discovery obligation is triggered by the rules, not by questions I put to a witness during trial. So if the state was aware of the existence of the fact that another download was done, whether the report was not, and that we are in trial, and then puts a witness on the stand to say, well, we're going to turn it over to you now because you asked a question, I don't think is a good faith response. One, we need a discovery cutoff, and we need one to be put in place now so that this propensity for ambush is not enabled. also, that's not the case in this instance. There was an analysis done. Ms. Bradley knew about it. She knew of her obligation to turn it over. She didn't turn over the fact that it was done, nor did she turn over the report. Apparently the report she is now claiming has not yet been finalized. If the analysis was done, it's a download. If the download was done, then the material from that download exists. This isn't a test that's done. It's a download. So if this download was done a few weeks ago, that is the material that should be turned over. And it was not. And we would object to any reference to it. And the defense team is going to discuss what other, we'd also for the court to inquire of the state if there's any other discovery out there about which they know to exist and have not turned over. And we're going to discuss whether or not we're going to seek any further relief. But we would ask that the state be prohibited from engaging in this ambush. I've had it for over a month now?
No, it's close. So I think I have to look at the notes on that and answer on, so if Your Honor wants me to respond on those, I can go and check exact dates on emails.
That's fine. You can check the dates and that type of thing. Right now, I'm deferring ruling on it. Detective Moretti's not anticipated to testify today, is he?
No.
So we'll talk about that later in the day.
Sure.
Okay?
The Honor, we also move for a discovery.
Understood. I heard it. I defer ruling on it. All right.
Thanks.
Let's bring the jury in, please.
If we can have the witness resume his seat.
Sure.
Are there any people?
You bring the jury in.
There's no family.
They'll take care of it.
Jury entering.
Ladies and gentlemen, thank you. Please be seated. The record once again reflecting the presence of the defendant, Mr. Demons, his counsel, and assistant state attorney, the ladies and gentlemen of the jury, our witness, Special Agent Collins, remains on the stand. Good morning, sir. Please have a seat. I just want to remind you, you remain under oath. Agent Collins. Ladies and gentlemen, I did get a question, and I was just discussing it with the attorneys regarding the scheduling, and my understanding from speaking with the attorneys is that they anticipate the trial would conclude before the end of July. Trial is a fluid process. You don't always know exactly what the next witness is or who the witness is going to be. Can you hear me?
So how they working
I apologize. So let me start over. I received a question about when the schedule of the trial, it's anticipated to conclude. I spoke with the attorneys. They advised me they believe the trial would be over before the end of July. I want to remind you also that because the attorneys reminded me, I forgot that there's the week of July 3rd, 4th, 5th, 6th, and 7th. That week we're not going to be in session. We'll finish out the end of June and then pick it up again on July 10th. The week commencing Monday, July 3rd, we're not going to be in session. But the attorneys think the trial will conclude by the end of June. All right? So, ladies and gentlemen, when we were last here, Special Agent Collins was on the stand as a witness. He remains under oath. And, Counsel, you want to finish with your direct examination?
Yes, Your Honor, if I may.
You may.
Okay, Detective Collins, we had just discussed about your training and experience, so remind the ladies and gentlemen of the jury, in what field do you work?
I'm testifying here today in my role as a CAST asset, so cellular analysis survey team, a group that specializes in historic cell site analysis and device location analysis.
And have you used historical records to locate fugitives and missing persons before?
Yes.
Did you conduct historical cell site analysis in this case?
Yes.
Okay. Did you prepare demonstratives to help show and explain to the ladies and gentlemen of the jury what your analysis is and how it is completed?
Yes.
Okay. I want to start with and go over the cell site records. Are those records provided to you?
Yes.
Okay. And so what's been previously admitted into evidence as states 63 and 64. Thank you. Starting with state 63. I'm going to open up some of the records and if you would be so kind to follow along. So starting with what is in state 63, going to the tracking number 2058127. And so it's clear. I want to also publish state 28. This phone number 772-713-9807. Is that one of the phone records that you analyzed in this case?
Yes.
Okay. And states 28 is a pawn slip. Have you ever seen that one before?
No, I haven't.
So going back to the same phone number, 772-713-9807. Can you explain to the ladies and gentlemen of the jury what we're looking at in these phone records?
Sure. So this is a report from T-Mobile. It's an engineering report, and you may also hear it as referred to as a true caller quantum data or timing advanced data. But essentially what this is it's records of, from the network's perspective, location where the phone likely was during particular times. So you'll see a series of columns on here. At the top it explains what is contained in each column, and then you'll have a series of entries. All that is associated with a particular time. So column A in this case is end latitude, and column B is ending longitude. It says what the confidence level is, the IMSI, column E, and the INDI. Those are numbers that are assigned to the device. So the IMSI is sort of like your SIM card. It's a subscriber number that authenticates on the network, so that when you have a cell phone communicating with the network knows that your customer is paid and they can give you network resources. The INDI is about the device that you have in your hand.
It's been a little while since geography, so could you please explain what latitude and longitude are?
Yeah, those are coordinates on the Earth. So if you wanted to know where a particular person was at a certain point in time or whatever, like those latitude and longitude coordinates correspond to a specific spot on the Earth. So we could plot those in any mapping software, like we could copy and paste this in Google Maps right now, and it would drop a pin in Google Maps, for instance, and say, okay, that's where latitude 25.984685, longitude minus 80.375979 is here.
And is that what you use to do your analysis, just those latitude and longitude?
No, I use other information on this sheet.
So you talked about the IMSI, IMEI, and so I'm going to go scroll over, and just if you could explain. So the next column is, so we said roaming group, I think model and make would be the next columns that for you to explain.
Yeah, so the roaming group, it's T-Mobile records, the phone that records apply to, you can see the model and make. It's an Apple phone, it's an iPhone 10. We'll skip to column. You can see in column K, it will say what type of record this is for, so data, which would be whatever, some sort of internet connection, whether you're using email or social media, or it will say voice and data. Voice is obviously if you're making like a voice call.
Okay, so going down to row 91, is that an example of the voice and data?
Yes.
Okay. Make it a little bit bigger. Zoom in so it's easier to see for the ladies and gentlemen of the jury. Okay, continuing up at the top again so that you can explain the columns. Which specific column are you looking at when you are analyzing these records and the data in that?
So usually one of the most important ones is the time and the date, and that's column F, because often when you're doing a case, and in this specific case I was asked, are the records consistent with certain things that the detectives had wanted to know based on the investigation that they had done separately. So you need this time and date.
And it's, when you're looking at this time and date, what is that telling you?
The time of the record.
Okay.
So when column, or excuse me, row 2, when you see October 26, 2018 at midnight 000, you will know that the latitude and longitude points attribute to that in columns A and B, or a little further down the spreadsheet, we'll see that a distance measurement from a tower that is associated with that particular date and time.
So with regards to the date and time, do you have to take into account if the records are kept in Eastern Time or UTC?
These are in local time, so the same time.
So the time that's on here is the time that the event happens here in whatever location it's plotted in?
Yes.
Okay. So going forward, continuing across, and then which column, you talked about distance from the tower, which column are we looking at for there?
So you'll see if you scroll over further, S and T, you'll see cell site and so start cell, start E node B. E node B is another name for cell site, like a 4G technology for cellular providers. So depending on what technology, whether it's 3G, 4G, et cetera, 5G, they call the hardware different things. It performs the same function. So that's a tower. And we will know that that tower is at a certain spot in the real world. So if I know that at a certain time, column 2, whatever that time was at midnight, the phone connected to a tower named 76963, the antenna 23, I can go find where tower 76963 is, plot that on the map and say, okay, this tower is here, and the antenna is pointed in a particular direction, and at midnight, the phone was in that direction, and then we'll see if you scroll further to the right. you'll see a distance there. So in column AO, it'll say 2.96 miles. So at that time, midnight on October 26th, that phone was 2.96 miles from that tower.
Okay, so we've gone through a lot. I'm going to go and break it down a little bit in some of the things you talked about. You talked about 3G, 4G, 5G.
Yeah.
What is 3G, 4G?
Just different technologies for, like, I guess, evolutions for the phone. Each time if there's a rollout, generally there's improvements in how well the phones work, the cellular networks work.
Okay, with regards to 3G, what type of information does that limit you to?
What do you mean?
In terms of distance from the tower, if it's a 3G tower, what type of range are you working
Oh,
with?
okay. Well, so that does play a factor in like the certainty or we'll see in the reports later, but this timing advance is an estimated distance from the tower, right? But there's a margin of error, a margin of uncertainty associated with it. And so at 3G, for instance, the network can only say within, either depending on the type of 3G, 234 or 244 meters, what that distance is. If it's 4G, they can tell within 78 meters. They'll say, okay, this is the timing advance increment.
And in the case that we have before us today with the 772-713-9807 phone number, what types of towers and service was being used?
During the period that I reviewed and analyzed and plotted, it was exclusively 4G.
4G. So in terms of how wide is going to be your margin of error on the 4G towers?
78 meters.
78 meters. So can you explain to the ladies and gentlemen of the jury as to how that data, that distance, how that is computed?
Sure. So essentially this is it's sort of like if you think about throwing, if I had a ball and I'm playing catch with myself, throwing it off the garage and when it comes back to me. So the cell tower will send out a burst of signal to the phone, and then the phone sends it back to the tower because the network knows when it sent the signal and when it received it back, it has an amount of time. And we know the speed that cell signal travels at, because it's the speed of light, so by multiplying distance by time, or excuse me, speed by time, we get a distance.
Is the speed of light constant?
Yes.
It's been a while since physics. So you just kind of explain that a little bit to the ladies and gentlemen of the jury as to how that works.
Yeah, so it's, that's the speed of light doesn't change. Cell signal is the speed of light anywhere in time. It's going to be the same.
Is the speed of light affected by foliage or trees or leaves or anything like that?
No, speed of light's the same.
Oh. Are cell signals or service affected by changes in environmental conditions?
Can be slight changes, but generally not. And if there's a change, we're talking about like minuscule amounts of meters, not miles.
So meters, not miles. And what types of environmental conditions would be required to have a change of those meters, not miles?
Well, if your phone is in a, like, a lot of the buildings down here are built for hurricanes, so if there's lots of concrete walls, that could affect it. If the path that the signal takes to the phone is not a direct line, but say it bounces off something, like it, we call that multipath, so if it hit a glass building and then came to the phone and then went back, obviously those things would increase the time that it took for the signal to go there and come back, so that would then increase the distance.
Okay. With regards to hurricanes, is that something that would affect? Blizzards?
I mean, if the way that would affect this would be if that had a catastrophic effect on the network and then the network wasn't functioning properly.
Okay. If there are records that you are analyzing, what does that tell you about that specific tower?
That it was working.
Okay. Going on again, so you've explained a little bit about a cell tower or a cell phone and how it works, and you mentioned cell towers. What are cell towers or antennas?
Yeah, so obviously our cell phones don't have wires coming out of them to make a call or send a text or do whatever we want on our phones. We have to connect to the cellular network. We do that through cell signal, which connects to an antenna, which is usually on a tower, and then through the network's infrastructure, the call or the data transactions routed through its core and then handle however you need to handle it. So a tower can be anything that has an antenna mounted on it.
Have you created a demonstrative exhibit to show the ladies and gentlemen of the jury what a cell tower is?
Yes.
Would it help in explaining and the understanding of the testimony?
Yes.
Okay.
Judge, we're going to object before she publishes it to the jury and maybe go sidebar.
Yes. Assist the witness in explaining or illustrating his testimony. The testimony of the witness is the evidence. These demonstratives are not to be considered as evidence in the case unless they are later received in evidence, and they should not be a substitute for evidence. Only items that are actually received in evidence would go back and to the jury room for your consideration during your deliberations. This is to assist the witness in explaining or illustrating his testimony, these demonstratives. All right, counsel, you may proceed.
Thank you. Okay, Special Agent Collins, could you explain to the ladies and gentlemen of the jury what we're looking at in this photo right here?
So this is just a generic example of what a cellular tower can be. Here you see it. Antenna arrays mounted on a monopole, so just a big pole that you see everyone's driven by these. And so you'll see that there's, on the image on the right, there's two triangular shapes. Each of those on each side, with each triangle shape, there's multiple pieces of equipment mounted on them. So that would be in a cell tower example that has 3 sectors or antennas pointed in 3 directions. So each of those sides that has multiple pieces of equipment, those are transmitters and receivers. Can I on this slide?
I was just about to tell you that is a touch screen, so if you touch it, you can draw on it as well.
Fantastic. So all of these would be part of one sector, one side, and all of these would be part of one sector, and all of these. So this would have 3 sides. And if you think about like what these are doing, if you wanted to imagine that it's like a flashlight, because visible light, cell signal, all part of the electromagnetic spectrum, they have the same characteristics and properties, right? So this would be like somebody standing on top of the pole with a flashlight pointed in one direction, sending light that way. And this side is a flashlight pointed in another direction. This side is light going in another direction. That way there's light or cell signal going in all directions to service, in this case, phones that are within the coverage area of the tower.
So you mentioned a little bit about the coverage area and the 3-sided. Going on to what's on page 4 of the demonstrative exhibit at this point. You explained the flashlights and things like that. Can you demonstrate again on this particular image, the sector 1, sector 2, sector 3, and why that's important?
So this would be, as we were discussing further, like further drilling down into what this example of a tower could be. So here again, the 3-sided tower, and you'll see that each side has a particular direction that that flashlight is pointing, that the antenna sends signal. That will be recorded in the tower list by something called an azimuth. So in the records that we'll have for the phone we were just talking about from T-Mobile, it will say the azimuth is 0. And what that means is that the flashlight is pointed 0 degrees, like out of a compass. And that would be where the coverage is the strongest, like that's the center of the beam, but it creeps out. And so it will be covered from approximately 300 to 60 for 120 degrees on that side. Each side, if we have 3, would be divided up like a pie to cover 120 degrees. That way we'll have 360 degrees of coverage for the tower. Towers don't have to be 3-sided. They can be 6-sided. They can be one side that covers 360. It's up to the network engineers who build out and optimize the network, what they want to create based on what they need to. But the most common type is 3-sided tower.
Is the information as to how many sides on any given tower something the FBI captures and takes note of?
The providers provide that to towers.
And is that provided to the FBI?
Yes.
Is that undone and updated so it is at the time of whatever the records were created?
Correct. Yes.
Could you take those same records that you were given and look at the towers that are working today and make an analysis?
Yeah, so whenever you do the analysis, you have to make sure you're using the tower list that corresponds to the time of the records because networks change over time.
Yeah. And are the azimuths, is that always part of the records that are given to you on each tower?
Yes.
When you pick up your phone and you make a call, what determines what cell tower the phone uses?
So the phone picks the tower that it's going to connect to for its initial connection. The way that does that is it, like even as if anyone's got their phone with them right now, as they're sitting here not using them, the phone is still scanning the environment. It's constantly looking for signal strength and signal quality. The phone's going to identify the tower, the sector. When I say sector, I mean a tower and an antenna that offers the clearest, strongest signal. When the phone wants to make a call or send text, that is the antenna, the tower that the phone is going to reach out to. So that's very important for what I do because that means that when the call is initiated, it's not based on the network or something. It's based on what the phone sees. It's based on what the phone sees as the tower that is the clearest and strongest signal.
Does the phone always use the closest tower?
No. The phone always uses the tower with the clearest, strongest signal. Usually, or often, that is the closest tower. However, there's other things that can determine what the clearest, strongest signal is. For instance, line of sight. If the closest tower doesn't have a clear line of sight to the device, then the phone may use a tower that's slightly further away because the signal strength and signal quality are better from the antenna with a direct line of sight, for instance.
Are all the antennas and cell towers, do they look like the ones that we showed in the previous slide?
No.
What does a cell tower look like?
Yeah, I mean, whatever the companies want them to look like, right? That's a good one because it's that I use in this because I identify that as a cell tower, but I'm sure everyone has seen antennas that look like they're hidden flagpoles, antennas that are mounted on the sides of buildings, up here on the roofs of buildings. It can be small antennas that are just on top, so street lights, it can look like anything.
In terms of the general direction that the cell tower antennas are pointed, are they at 90 degrees out or are they angled downwards towards the majority of the phone?
Usually they are tilted down.
If you saw an example of it picking a cell tower that's further away, would you look at the records and try and determine why that's happening?
So yeah, if I see a red flag or something to me that stands out and it's being atypical, when I'm doing my analysis, usually I'll look further into it and say, okay, why is this not connecting to one of the towers that I expected it would?
So we've described the CDRs and the information that's used on those. Is that the same that you did for each and every phone in this case?
So we were looking at the time in advance reports, the engineering data, the CDRs, the call detail records are a different data set.
And just explain to the ladies and gentlemen of the jury what's the difference between the timing advance, the engineering reports, and the CDRs.
So the CDRs, or the call detail records, are records of the phone's communications, like calls, incoming, outgoing, certain types of text messages, etc. That will say date and time, the numbers involved in the call, the tower, the azimuth, etc., but it doesn't have the extra information that the engineering report does. So in the call detail records, it looks like billing records that you usually see with your phone if people actually look at their billing records. It would say tower and sector in addition to it, but it won't say distance from the tower. It won't have the latitude and longitude coordinates or all the extra information in the time in advance report. The other really important thing to delineate between those two is, I just said that the phone picks the tower that it uses based on its measurements. And so the call detail records, the tower that is used is picked by the phone. It's that first connection. In the time in advance report, the engineering data, that's the network's perspective. So that's what the network is seeing behind it. And the tower that's listed in the engineering report may not be the serving cell. It may not be the tower with the clearest, strongest signal. It could be, but it could also just be another tower within the network that saw that phone and said, hey, I see you, or I see the device, it's this far away. So it's important to keep in mind what type of report you're looking at, because it obviously can affect the conclusions that you're making.
So in terms of the way you illustrate the difference between a tower being used or a sector and a timing advance, or the distance measurement on that, I want to make sure it's very clear. What we're looking at right now, what does this illustrate when we see just a round circle in your reports?
So this will illustrate the tower that the phone used, or if it's from a data report or the engineering report, the tower that is registered and listed as seeing the phone. All the green dots in the middle of this graphic, those are all cell towers, and you'll see that there's one tower in the center of the map that has a blue circle around it, and so that would be the tower that the phone connected to. That's not, I think it's not like if you're using Google Maps and you're just seeing a blue dot. When you pull that out, this is not the location of the device, this is the tower.
Okay, and can you just, so it's clear, point out a couple of the towers that are on this map and just highlight them so it's clear what you're talking about, because sometimes the color doesn't come across great on the screen.
So these green dots would be other towers that weren't used or that didn't see the phone. This one here in the center of the blue circle would be the tower that was listed on the report. And then this big blue circle, that's not a coverage area, that's not saying that, hey, the phone has to be somewhere. Then here I'm just flagging that as saying that is the tower that is listed in the report. That's the tower that was used over a cell phone.
Is it your testimony that the phone is definitely within that circle somewhere?
No, definitely not.
Why not?
That's not what this is intended to do. This is just intended to show this is the tower.
Oh. So now we're going to go into the cell site. How would you indicate that in your report?
So cell site, tower and sector, or tower and antenna. This is showing the direction that the flashlight is pointed. So this like wedge or a slice of pie, or however people like to think about it, that will show the direction of the flashlight's beam. So the azimuth, the center line would be, in this case, like 180 degrees due south, and then the illustration shows the estimated like ends of the coverage area. But what's really important about this is that this is just showing the direction that the antenna is pointing, the direction of the beam. So this is, again, not showing where the phone is. In other words, I'm not saying that the phone has to be within this blue shaded area. I'm not saying that the phone has to be within the arms of this black wedge. I'm saying this is the direction that the antenna is pointing.
Are you able to tell anything about the strength of a signal from a tower at any given time?
No.
Why not?
It's not reflected in the records that I have.
In terms of the average signal strength, is that something you have training and experience on from the various cellular telephone providers?
Average signal strength. No.
So is there any determination or anything that can be made about distance from a tower just based on what cell site the phone or device was using?
No. From your call detail records, you cannot tell distance.
So I want to go on to this type of illustration, if this type of illustration is used in your report, what are we looking at?
So this would be an example of the engineering data from the time of advance report. So now we see, again, the blue wedge saying, hey, this is the sector that recorded the phone. Here's the direction that it's pointed. And then we have that distance from the sector. So the distance, whatever we can say this is, for instance, 1 mile. So a particular example would be 1 mile here. And we see that it's a certain thickness of the band because the timing advance, margin of error or size, depending on the technology, can only get down to a certain distance. So for 4G, again, it's 78 meters. For 3G, it's about 234 meters. So the size of this band will depend on the technology that you're using.
So in the records in this case, what is the width of the band in your report?
78 meters.
Okay.
So in this case, what I'd be expecting, based on the information from the phone, from the engineering report, is that the phone would be somewhere within this band, this like curve, banana shape, whatever. That's based on the data from the engineering reports saying, okay, the phone was 1 mile from this sector, from this antenna points this direction. Here's 1 mile. The phone should be somewhere within that band.
With just one data point, can you narrow down where in that band it could be?
No.
With multiple data points, can you draw conclusions as to the location of the phone because of multiple records?
Yeah, potentially. So one way we could do that is in read intersecting bands. If we had another tower, could you zoom out a little bit, please?
Sure.
Like let's suppose that this tower down here also recorded a measurement. Maybe that it was a certain direction and distance, and so we had bands that intersected, then we could say, like, okay, that might make the conclusion the phone is in that smaller coverage area where it's where the intersections of the bands are, we can kind of triangulate. You could also use other information that's not related to cellular technology if there's other facts from the investigation.
Is that type of information provided to you when you're doing your analysis?
Yes.
Okay. And do you identify areas potentially of interest?
Yes.
Okay. Going on to this next slide here, what are you illustrating in this particular map?
So this shows the green dots are T-Mobile towers in the South Florida area at the time of 2018 and time relevant to this analysis or case. And the takeaways there are just there. You see in densely populated areas, there's a much higher concentration of towers, right? Because there's more people who have more devices, there's more demand of network resources. So the providers need to have more towers with smaller coverage areas to provide service to those devices. When you get to more rural areas where there's fewer people, fewer devices, the networks will usually have fewer towers that will have bigger coverage areas. So.
Okay. Is this map fairly and accurately depict the towers that were in South Florida in October of 2018?
Yes.
So going on to the areas of interest. If we can identify the ones that are listed here, I'm going to start with 805 Northeast 4th Avenue in Fort Lauderdale.
So that's shown in the upper right portion of the map with an orange flag and the white letters NE on it. That was a location. All these locations were provided to me by the detective who requested I do the analysis. But that was one of the locations identified.
And how do you plot or map these locations?
With mapping software, our mapping software is Google Maps.
Okay. And does that fairly and accurately depict the locations of the items of interest that are provided to you?
Yes.
Okay. So moving on, so you have a crime scene with coordinates on it.
Yes.
Is that again provided to you by the detective?
Yes.
Next, reported shooting. How would you identify that on the map and point it out, please?
So the reported shooting location is a blue flag with a little eye in it, shown here on the map, sort of, I guess, in general in the lower left.
Okay. After that, there's Memorial Hospital is your next. How is that identified on the map?
You have Memorial Hospital, 1901 Southwest 172nd Ave, Miramar, Florida. It's shown on the map with a red square and a white H.
Okay. Next location is labeled as McDonald's. Where is that on the map?
McDonald's is 17001 Miramar Parkway, Miramar, Florida. That's shown with a red circle and a yellow M on it.
Okay. And Sunset Lakes is the next one. If you could point that out.
Sunset Lakes is located at 18513 Southwest 40th Street, Miramar, Florida. That's shown on the map with an orange flag that has the white letters S and L.
And so last but not least, the Montessori Academy.
Yes, the Montessori Academy, 19200 Pines Boulevard, Pembroke Pines, Florida. It's shown on the map with an orange flag that has the letters M and A in white.
Are those locations that we just discussed consistently plotted throughout the rest of the mapping that you do in this case?
Yes.
So I want to go to the phone number 772-713-9807 and then the phone number 954-248-9081. Do you know who either of those phone numbers belong to?
Objection. Outside of the scope of knowledge.
Excuse me.
And hearsay.
Can I see this? Sidebar, please?
Okay, so you may answer the question. Do you know who any of these phone numbers belong to?
I don't know. I know the detective treated on this.
So-
Yes? I'm sorry.
We'll stop it right there. All you know is what somebody told you.
Right. All I know
Okay,
is-
so I don't want to get into any of that. I just want to know what your personal knowledge is. You don't have any personal investigation or knowledge as to who these phone numbers belong to?
No.
Okay. And you just know that the phone numbers that were provided to you?
Yes.
Okay, and the 772-713-9807, that's the same one that we discussed in States 28 that I published
Objection,
earlier.
Your Honor. He also testified that he never saw the document before, so it's outside of scope of knowledge.
Sustained.
Okay.
Thank you.
So with regards to the 772-713,
Objection, Your Honor. She cannot leave it up there published.
Speaking objections,
She's
Your Honor.
tainting the jury.
Just take it down, please.
Yep. So 772-713-9807, that specific phone number. On that, I want to talk in the 954-248-9081. Between 3:20 a.m. and 3:57 a.m., did you analyze the data for both of those phones?
Yes.
And if you could tell the ladies and gentlemen of the jury what this data is showing and explain it to them.
Sure. So the several slides like this in the report. So I'll talk a little bit more about this first one, just so everyone understands which the slide says. At the top, it says the analysis of the two phone numbers that conducting analysis for. It says the time period that I'm analyzing, so October 26, 2018, 3:20 a.m. to 3:57 a.m. And then the bulk of the slide is the graphic, is the map. You see all the green dots all over the place. Those are T-Mobile towers, like we talked about before. And then you'll see that certain towers are highlighted with a circle showing that those are the towers that saw the phone. Some circles are red, some circles are blue, some circles are red with a blue perimeter around them.
And so I'm going to kind of zoom in up here on this top section, the 3:20 a.m. If you could just show some of the red with blue circles and then the blue and red on that.
Yeah, so there's an example of a red circle, and what that means is that you can call it, since it's hard sometimes to remember numbers, we'll just call it the red phone and the blue phone. So the red phone was seen by that tower, and that's why there's a red circle there. Here, the network saw the blue phone on that tower. Here's an example of a tower that saw both.
Judge, may we approach Sidebar, please?
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. The witness is also present. The state's present. All right. So I don't understand. You're saying you didn't have this report?
So we got this report this morning while I was sitting in the courtroom. We don't have a printer here. So I asked the state to do the professional courtesy and give me a copy of the documents that she'd be using for this testimony. I'm trying to refer to what she's up to. She gave me 7 pages, by the way, which we started, and I was objecting to it being published because it still had the names in. She said, I'm not using that first page that I handed you, I'm using every other page. So I'm looking at the pages to try to go along with what she's showing, and I'm noticing she gave me a report from a whole nother phone. All I'm asking is to give us the actual documents that she's showing the witness. And to say I emailed it to you while we were sitting in the courtroom is a little disingenuous because I don't have the printer to be able to print it out. So I just asked.
So you have the report, all 3 reports, but the reports that you have that were generated to you have the phone number as well as a name that's identified that the phone is associated with. Is that correct?
She redacted that.
No.
Yes.
But you have the 3 reports.
Yes.
Discussing the phones, and you were given those reports some time ago, and yesterday your objection was made that it's conclusory as to whose phone it was, and I sustained that objection, told her to redact the name.
Yes.
Correct?
Yes.
And you're telling me you don't have the form of the reports with that redaction of these maps or whatever they are. with the names being redacted. Is that correct?
So I have it in email, but I'm asking for paper form so I can follow along. with-
Understood.
Yes,
All
that's
right.
exactly.
Thank you. So can you make copies for those?
I printed, I found all of them. If there's one that she's missing, I'm happy to do so, pull them up again. I printed them all this morning for her.
Council's suggesting she doesn't have them, so I just want to make sure she has
Of
them.
course, and that's not a problem. So, but they've all been turned over via email. This is all in there, the original copies as well that were provided.
Council does not have the ability to print something out in the courtroom now. She's asking, Council, Ms. Raven, Liberty's asking for a copy of it. Let's provide her a copy.
I'm happy to do so. I just need to know exactly which one she says she's missing and which one she says she has. I don't want to have to duplicate them if possible.
None of the documents she's published since
So just
testimony
do
started
me a
has
courtesy,
been
just
given
print
to me.
all of them out.
So,
All right?
Can we take a break while the jury's on?
We can, but can we finish this first?
Oh, yes, I thought you were
So
finished.
you're gonna make copies of all the documents.
so she has in her hand some of them already. So I just want to make sure I don't double print them.
Just double print.
On that. So
You know,
she-
Council's suggesting she doesn't have them. So let's just print them all.
Okay, well, she does have some of them. Just want to make sure.
For the record,
I don't know, you know, you're saying they're sent, Council's suggesting she hasn't received those things. I just want her to get copies of it. I don't want your constant back and forth. Well, she has it, just give her the copies. That's it. It's easy. Just get her the copies. All right? Mr. Devens, you need a restroom break?
Sir.
All right, we're in recess. Thank you.
you gave me this last moment, so you're going off the time. I don't need to second. I have nothing on my.
A little bit of the relationship between the prosecutor and the defense attorney and the judge and how they're all kind of interplaying with each other. It seems that the defense attorney and the prosecutor in this case are really not getting along. There's not a lot of professional civility going on. And I think that you saw that kind of play out when the judge is just telling the prosecutor, she says she doesn't have the documents. Just print a copy of all the documents and give them to her. Yeah. That should have been it. That should have been the whole thing. But the back and forth just kind of shows that the prosecutor is just trying to show the defense attorney is not being completely honest with the court, and it's unnecessary. It doesn't help the case at all. She should have just said, okay, judge, no problem.
Now, let me ask you this, Sonny. I want to go back to ballistics for a second. There are no murder weapons in this case. Prosecution doesn't have them. And we're not entirely sure if it was one weapon or multiple weapons. How is that something that could help the defense?
Because it says that the prosecution says this happens, but they don't have the evidence that these individuals had weapons. So that is questionable. Just like you said earlier, the other thing that's questionable is how did these two individuals who are accused of this particular crime not sustain any significant or no injuries at all if this was a drive-by shooting with random gunfire? I think this is going to say, well, there's no weapons, they can't prove it. How do they tie together those particular knots? This is a very interesting case.
All right, well, it is an interesting case. More to cover. They'll be back after that recess, but we have more to cover. Stay with us here on Law and Crime. We'll be right back right after this. back, everybody, and thanks for coming back to Law and Crime. The Broward County jurors are in a morning break in the trial of Florida versus Jamell Demons. This is the rapper better known as YNW Melly. He's accused of double murder for the 2018 shooting deaths of his two friends. And as we wait and want to go back to a little bit of what happened yesterday, where a detective with the Miramar Police Department took the stand. This is Jonathan Zeller. If you haven't seen this testimony, let's take a look.
Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work with the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the digital forensic examiner.
Okay. What is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
Okay, so what we use is a software and hardware from a company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
I've taken a few. Each of them consists of 40 hours of class training and exercises, and obviously the exam as well.
What about, have you taken training with the CAST team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So, depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know what the case.
In this case that we're here on today, Miramar Police Department Investigation 18-10.
I don't think we have color printers in the back side of my office, so it's not something I can do regardless. Let's get back on the record. I understand, well, first of all, the record reflect the presence of the defendant, his counsel, assistant state attorneys. We're still waiting for the state to provide certain documents to defense counsel, i.e. some maps that were being used as demonstratives. Counsel Sidebar suggested that she didn't have them. They were emailed to her, but she doesn't have hard copies, and Liberty wants the hard copies. So I had instructed the state attorney to go ahead and do that, provide those hard copies, and that's in the works because the printer in the courtroom doesn't seem to be working. So while we're waiting on that, let's go back and talk about the discovery cutoff that counsel suggested he wants. What's the state's position on the discovery cutoff?
That if there is anything that counsel brings up with regards to the witness that suggests additional analysis or anything that can be done, that the state would do it on that.
So you're opposing it?
Yes, Your Honor.
Anything else that you want to be heard on regarding this discovery cutoff?
No, Your Honor.
Anything the defense wants to be heard on?
Yes, Your Honor. I just started to do some research, and quite frankly, I've only candidly found a case. It's in the 4th DCA, but it concerns a civil matter, and it speaks of the need for a discovery cutoff to avoid the very term I used, ambush and surprise, and that when a party conducts itself in a way as to ambush there not to get the benefit of that. These trials, we understand, life goes on beyond trials. So the evidence that can be introduced into a trial should have some finite and determinable parameters. The notion that the state comes here and asks jurors to put somebody to death suggests that they have completed an investigation that warrants that co-signing, co-signature. To suggest that, okay, there are a lot of things that we could have done and we didn't do, and if you ask about them, we're going to go do it and introduce it while the proceedings ensue, is not only an ambush, but it's an insult to the process. They're saying that they have the evidence. Now, the state can get up there and say, hey, the defense is making some ridiculous cross-examination and we don't have everything because what we have is enough, which is when they bring an indictment of this nature, of any indictment, they're saying we have enough now, beyond a reasonable doubt. But what they cannot do is, as these proceedings go forward, continue to investigate and plug holes that we reveal to exist as the process goes on until this case goes to verdict. I'm not quite sure when this would end or how there is even a gatekeeping function of the court if there is no gate and there is no fence and there are no lines and no parameters of propriety. The state is making a representation by bringing this indictment that they are ready and they have proof beyond a reasonable doubt. And if that proof beyond a reasonable doubt also includes areas of investigation that were not pursued, then they should explain to a jury why it was not pursued and why the failure to pursue it does not undermine their case. They don't get to keep plugging holes as the proceedings go forward. And so, as the Fourth Circuit said, that is ambush. And the purpose of, the Fourth DCA said that is ambush. And the purpose of a discovery deadline is to avoid surprise, avoid ambush, and a party that engages in that ought not to get the benefit of it.
Thank you.
Thank you.
Hold on.
Just briefly, I would mention that defense hasn't yet to provide any reciprocal discovery, but alluded to some yesterday. that they were looking at Instagram posts and everything that had happened as recently as this week, but yet they have provided nothing to the state. So if there's any deadline of any sort that needs to be imposed on both parties.
Thank you. Oh, Counsel, my understanding is that's the way it works, is that it's not, Richardson violations apply to both sides, doesn't apply to just one side. It's deadlines apply to both sides. That's not what we're talking about.
We apologize. The treasurer's decided to start working. I'm sorry.
I apologize. What I was saying is that the whatever obligations that are imposed would be applicable to both sides when there's a discovery cutoff or not. My thought is as to the discovery cutoff, you can keep investigating the case however you feel fit, and you're more than welcome to do that. However, that doesn't mean that anything you find can be used at trial as in evidence. This thing with Mr. Moretti, where when I'm out of town on vacation, you're asking the detective, or he's offering, I'm not really sure how it happened, to continue and run this through another process, and the defense doesn't know about it. The defense cross-examines Mr. Zellner, Officer Zellner, and is not aware that he's asking questions about other programs, because his understanding is there isn't any other program. But you know there's another program, they have access to it, and they've done it, you just don't have the results. That seems to me to be what the counsel's talking about. And that seems to me to be a Richardson violation. There's a discovery that's ongoing, you know about it, and you're not telling them about it until we're here in court. So as far as Detective Moretti is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I just think the only way it can be cured is he's not going to testify about this second procedure that happened. That's not coming in. Same thing. If you want to keep investigating a case, you can do it. You can find exculpatory information. You may change your mind as to how you proceed with the case, and I don't have a problem. You can investigate whatever you want to investigate. But as far as using new discovery that you're coming in, I think a cutoff needs to be happened, because this is what's going on. We're going to have this. If you find something new, there's a whole, as counsel describes it, then you try to find evidence to plug up the hole that's new discovery. The defense doesn't have an opportunity to depose the witness. The defense doesn't have an opportunity to do X, Y, and Z. And that's just not the way it should be. It shouldn't be done by surprise. So
it's clear this was not a new item. This was just this. All of the information was supposed to be identical.
You found it. You had a meeting with the detective in May when we're in hiatus because I'm on vacation. All right. You have a meeting with him in May after we picked a jury, and when we're ready to, or we're in the middle of jury selection. You picked it. You did it, and you said, well, he tells you. Or you ask him, do you have more programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he in cross-examination points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting, it came up and he has the program and we can use it and we're doing it, all right? And but you don't tell him about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to him, and then you say, when it comes up at trial, I say, what was it? I don't have the report yet. That's why I didn't turn it over to him, but didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay? So, as far as the Detective Moretti, and whatever other form he used, that's not coming in.
Okay.
All right? That's the sanction. If you have other information, other discovery that's in the works, you better share it with them, because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because you find out they have additional capabilities and you want to go retest something. That's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to them. If you didn't turn it over to them, you can't use it. That's really the basic.
Understood, Your Honor. And so everything has been turned over. That was the only item of which there was additional investigation done on to see if there was any other information or anything else that came out. It was reported to me that it was identical in terms of the information that was done through Gray Key versus Celebrite on that. So defense counsel is attacking the veracity of the Celebrite program on that. So with regards to that, that's the only reason why that would even be brought up. But if I understand there, so we can move forward on that. But I do want to address one other issue while we're outside the presence of the jury. Counsel keeps objecting to publishing of items that are already in evidence and making speaking objections. So just ask if Your Honor could address that specific issue, because the state can publish the items that are in evidence in the presentation of their case, and defense can object if there's something that has not been admitted or something to that effect. But in terms of the speaking objections and things like that, those are improper in front of the jury.
Thank you. All right, no speaking objections. When do you expect this documentation to come over?
I think the printer just started working.
And I provided it to Ms. Liberty.
Do you have those, Ms. Liberty?
Yes, confirmed, Judge.
Are you ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
Bring the jury in.
Jurors entering.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the jury as well as the defendants, his counsel, the state attorneys. Our witness remains on the stand. Counsel, you can continue with your direct examination.
Okay, so we had left off, we were talking about the red phone and the blue phone. And just to remind the ladies and gentlemen of the jury, what is the red phone number?
That is listed at the top of the slide. It is 772-713-9807.
And then the blue phone number?
The blue phone number is 954-248-9081.
Okay, so going back, you have a little green box with the numbers 154129-11. What is that?
That is the name of the tower and the sector.
Okay. And the times that are listed below, what are those indicative of?
So there's a time that says 3:20 a.m. in blue, and it says 3:20 a.m. in red, and that is the time from the records that the blue phone and the red phone each respectively connected to that tower.
So based on what you're showing here, what can you tell us about where the blue phone and the red phone were at 3:20?
So generally in the area around New Era Studios.
Okay. As you're moving across the slide, what are we looking at?
So we see a series of towers that the red phone and or blue phone were observed by as they move from east to west. So you see there's a line of towers generally in this area, kind of along 595, down I-75, and then the last ones at the end of the slide are the west, kind of by the intersection, a tower that's near the intersection of Pines and US 27. The tower is 63035, sector 15, at 3:57 a.m. That tower saw each of these phones.
So I want to make sure it's clear when you're the 3:20 a.m. that's on the right side of the screen. Can you kind of show in order the way the towers are plotted?
Yeah, so I didn't know the time for each tower because then it would be just a mess of boxes on the slide. But generally, these towers in the northeast, and then sequentially or chronologically as time went on, these towers were used. This tower was used later in that tower, and this tower, and that tower. And so as time went on, from 320 closer to 357, these towers were used.
And based on your training and experience, what does that tell you about how the phones were moving in relation to one another between 3:20 and 3:57 a.m.?
Yeah, so in my opinion, that's consistent with devices moving generally together.
Okay. So you mentioned that there are some in which there is red and blue together. So I want to focus in. There's one here. It looks like at the intersection of Flamingo Road and I-75. And
Yes.
595 rather. The red with the blue. What does that mean when you have them overlaid like that?
So that tower saw both the red phone and the blue phone.
Okay. Is that at the same time or are they at separate times?
Could be either.
So going on to the phone of the 772-713-9807, what are we looking at this slide titled 3:47 a.m.?
So this is a plot of timing advanced data, and it shows that two data points basically from the engineering report. The tower 64337, sector 2, that's pointed south, recorded the red phone had two data points, one at 3:47:13 a.m., one at 3:47:24 a.m. And the measurement that went up was that phone at those times was 0.24 miles from the tower.
So you said it's two different times, but it's the same measurement. How do you explain that to the ladies and gentlemen of the jury?
That's just what the records recorded.
Okay. And in terms of by having two data points along, are they going to be in the same exact spot?
Well, it could be or it could not be. So the 0.24 miles from the tower is this red arc here. And I guess your question is the phone in the same spot or not? I don't know. Those are two data points close in time. They're separated by 11 seconds, so the phone certainly could be stationary. The phone could also be moving. For instance, at one point it could be here, and at the other point it could be there. There are both possibilities, and you can't determine for this thing.
And in terms of you don't have any cameras if it's stuck at a red light or anything like that?
I don't.
So that was the 772-713-9807 at 3:47 a.m. Okay. Moving on to the 772-713-9807 from 3:52 to 3:53 a.m. Could you explain what you're illustrating and the data shows on this slide?
Okay, so this shows two data points, both using the same tower and sector, tower 151, 685, sector 13. And the first data point is at 3:52:58 a.m.
Okay.
That's this arc here. That's 0.58 miles from the tower. And then 50 seconds later, at 3:53:48 a.m., the arc is 1.16 miles from the tower, this other arc.
And in terms of the distance between the two arcs, what is that amount?
It's a little bit over half a mile.
And the time frame in between those two arcs is how long?
About 50 seconds.
Based on the records and that you have, can you give a information as to where that phone was along those arcs?
Based on the records that I have?
Yes. Based on other additional information that was provided to you, can you make a determination as to where it's more likely than not the phone was?
Yes.
And where is that?
So the phone moved half a mile in 50 seconds. That's consistent with vehicle turn rates. It's too fast for a phone to run. That's 30 miles an hour. So there's a couple places that the phone could be logically. For instance, it could be going east to west on Pines. It could be going north to south on 184th. Those are both options. There's a data point that was provided to me. And that reason for this analysis was I was asked, hey, the detective recovered some video footage from Montessori Academy that he believed these devices might be in a vehicle that was seen driving by around this time. The detective asked, is the cell data consistent with these devices being in a vehicle? In my opinion, yes.
The data points that we're looking at, are those the only data points that exist in this case?
No, but these are the data points between 352 and 353.
No. So going on to now the 772, 713, 9807, and 954, 248, 9081. The 4 a.m. to 4:03 a.m. Can you describe what information is contained here?
So both phones are seen in the same tower and sector, tower 63035, sector 15, at 4 o'clock and 36 seconds. The blue phone was 1.45 miles from the tower. We have two data points on the red phone, one at 4 a.m. 54 seconds, one at 4:03 seconds. The red phone was reported being 1.5 miles from the tower and 1.45 miles from the tower.
So when we're looking at here, this purple area, why is that?
Because the red and blue phones are both, they are red and blue mixed purple. So
Just in case anyone's colorblind. So, with regards to the locations along this arc, can you narrow down in any way where the phones are along that arc?
now from the cell records, all you can tell is that there's somewhere within. Yeah.
And in terms of if you're looking at it in the totality of the circumstances based on the other records and information that you have, can that help and assist you in rendering opinion as to where the phones are located?
Yes.
And where would that be?
So the red flag depicts the crime scene that the detectives told me about, and they asked, is it possible for these devices to have been in the crime scene? In my opinion, yes. The data is consistent with these devices being in the area of the crime scene at this time.
Okay. So going on to the 772-713-9807 phone at 4:06 a.m. What information or data are you showing in here?
So this shows the red phone at 4:06:22. There's a data point where it's back on tower 63047, sector 3. It's 1.02 miles from the tower. So in this band here.
Okay, and in terms of where it is along that band, can you give a more definitive answer?
From the cell phone records alone, no. The reason for this slide, this analysis, was because the detective had video footage from Montessori Academy again at a certain time.
Objection, Your Honor, hearsay.
Sorry, repeat your question.
So based on these records, can you say where the phone was along that band?
And your objections and calls for hearsay?
That wasn't the same question, Judge.
Thank you. Proceed. You can answer the question.
So based on these records, can you say where along the band it was?
No.
Was other physical evidence provided for you to review?
I don't think I saw physical evidence, no.
Oh. So going on to the next slide, the 772-713-9807 and 954-248-9081. If you can explain what we're looking at on this particular slide.
So this is a series of data points on 3 different towers for both the red and blue phone between 4:17 and 4:23. We're starting back on the left side of the slide. where 417.43, the blue phone, is 1.21 miles from this tower. Shortly after that, at 4:18:02 a.m., the red phone is 0.87 miles from the tower. Shortly after that, 4:20:50 a.m., the blue phone is 1.02 miles from this tower. Then after that, at 4:23:22 and 4:23:55 a.m., the red phone is 0.29 miles and then 0.68 miles from this tower.
Okay, and in terms of what can you tell about how the phones are related in distance from one another based on this slide?
Distance from one another. Well, both phones moved north and then east. We know that the blue phone and the red phone are both over here, and now they're over here in the analytic period.
Can you have an opinion as to whether or not they separated during this time frame?
During this time frame?
Yes, 4:17 to 4:23.
I don't know. To me, I don't think there's enough data here to form.
Okay. So going on to the blue phone, 954-248-9081, 4:40 a.m. to 5:52 a.m. What data points and what information do you have on that phone?
So there's a lot of data points, and many data points for the blue phone during this time period. All the timing advance bands were either 0.82 or 0.87 miles from the tower, Tower 62492, Sector 3. Each of those bands, the 0.82 miles and 0.87 miles are shown here.
Okay. Does that phone then, that's all the data that you have for that particular blue phone?
Right.
Okay. Now to go to the 4:40 a.m. for the 772-713-9807, where does your data show that phone to be in the area of?
So at 4:40 a.m., at this point, the phones are clearly separate. At 4:40 a.m., we have two different types of data points that were plotted here. At 4:40:31, we have timing advance data, which shows that the phone is 0.5 to 8 miles from this tower. And then at 4:40:34 a.m., the red phone makes an outgoing call using that cell site, so that tower in Sector 62407, Sector 12.
Okay, and the outgoing phone call that is made, is that identified from the records?
Yes.
And what is that? I'm sorry.
That is a outgoing call to phone number 954-376-9158.
Okay. Does the red phone ever coincide again with the blue phone on the same arc that covers the hospital?
No.
So that was the first analysis that you did. Did you do additional ones?
Yes.
Okay. So I'm going to move on to the sprint and records and analysis that you did. Counsel, you're clear which one? So with the sprint records that you were given, did you have the same measurement or distance data for those phones?
No, we had a similar report, which is the timing advance, Sprint calls it per call measurement data report. It's formatted differently. It's a different network, it's a different company, but it has generally the same types of information contained in the report.
Okay. If there was going to be a distance in this report, where would it be shown?
It would be shown in column I.
Column I?
Yeah, just titled distance in miles.
Distance miles there. Okay. And to be clear, we're looking at the records here for 954-371-7895. Did Sprint provide the distance for column I at any point between 3 a.m. and 357 again. Sorry, that's column 163. Was there any distance provided?
No.
Okay. The 164 column, or row 164, row 60, 166, 167, and 169 was distance provided by Sprint at that point.
Yes.
Are they from a different manufacturer or vendor of cell tower?
Yes.
Okay. So based on, and so on this, the state would also publish what's been previously admitted as State 63. And for the record, that is the 2018-221418-6155597 customer service management screen of Chris Thomas. And the second one to be is published is the customer service management screen of Dontavius.
That's the objection.
May we approach?
Sure.
And so now also publishing the 2018-221418-6155640 records that have been previously admitted into Sprint and previously admitted as part of State 63. Special Agent Collins, the number that you're looking at here on the screen, 772-713-2341. Did you do analysis for those records?
Yes.
Okay. And again, for the record, publishing the subscriber information previously admitted as State 63 for Chris Thomas. Going down to the next phone number, did you do a cellular analysis for the phone number 954-371-7895?
Yes.
And for the record, publishing what's been previously admitted as State 63 with an identified subscriber of Dontavius Withers. Okay. On the Sprint records, do you do substantially the same type of analysis that we talked about on the true call data analysis?
Yes.
Okay. And do you use the same information to illustrate cell sites and cell sectors and
Yes.
towers?
Yes.
Okay. So again, the same demonstrative that's on what's labeled as page 3, you're still using the same symbols, the circle to represent a tower?
Yes.
Okay. Are you still using the same wedge or pie shape to identify a specific cell site?
Yes.
As to the next image that we're looking at, what does this show?
This shows the Sprint network in South Florida at the time of October 2018.
Does this fairly and accurately depict how the cell towers for Sprint were situated in October of 2018?
Yes.
And we had previously discussed the locations of interest. Are those the same as in the previous analysis that you did?
Yes.
Why don't you put these all on one giant map together?
All the phones?
Yes.
Well, one, it would be a lot of phones. It could be like confusing. to look at, to see all the different data points. And then, so that was one of the reasons why.
Oh. So going on to the phone number, the 772-713-2341, the green phone on this, and 954-371-7895. Can you explain what we're looking at of this October 26th, 3:22 to 3:43 a.m.?
So, much like the red and the blue phone, this shows that the green and the purple phone both use towers or seen by towers in the Fort Lauderdale area near the flag with the NE unit. Represents New Era Studios. At 3:22 a.m., the purple tower seen by Sprint Tower 168845. And then at 3:23 a.m., the green phone by a different tower, 335-911.
Okay. And in terms of, to go back to the 772-713-9807 and 248-9081, you're showing the same or similar time frames?
Yes.
Okay. Do the phones, the green and the purple phone, move consistently together during this time frame?
During this time frame, yes.
Okay. And how can you say that?
The towers, again, advancing chronology, consistent with the phones moving together, generally south, west, and then south again. They were hitting the same towers, similar times, through this point.
Moving on to now 3:43 to 3:57 a.m. What are you showing and illustrating on this slide?
So this is only the purple phone. And you'll see that there are several towers that saw the purple phone during this time period. Unfortunately, because we didn't get distance information report, we can't tell where, in relation to those towers, this device is. So you'll see that there's overlap between the towers, right? Like for instance, between 3:43 and 3:52, there were multiple times that this tower saw the phone. But during that time period, this tower also saw the phone at 3:48. During that time period, this tower also saw the phone at 3:49. 3:50, this tower saw it. So we have multiple towers from all different locations where the antennas are generally pointing that direction that saw the phone, but we don't have distance information.
Are there any phone calls or anything that would indicate that the phone used one of those towers as the clearest, strongest signal to make a phone call?
No.
Then going on to the 772-713-2341. Is this using some of the same towers?
Some of them.
Okay, and if we can just kind of go back and forth a little bit to explain to the ladies and gentlemen of the jury which ones are the same and which ones are different.
Sure. So I believe all three of these are the same, but the purple ones, or the purple phone, had multiple other towers that were used.
Okay. To look at tower 336-234-3. I'm trying to overlay them as, are they using the same antenna on that tower?
No.
Okay. Is this consistent with the phones being together?
No, in my opinion, this shows that the phones were separated.
So, and then in terms of the final analysis at 3:49 a.m., if you could, for the 772-713-2341 tower, if you could identify that on this exhibit, which is page 9.
The tower that recorded the phone at 3:49?
Yes.
This one in the center, tower 336-0972.
Okay. And then in terms of the final tower, the 3:57 a.m., if you could identify that one.
That's the western edge of the map area, tower 336-234, sector 3.
Okay. So going on to the third analysis you did in this case. Did you do an analysis again for the phone number 772-713-9807 the red phone, and 954-376-9158.
Yes.
And in terms of the 954-376-9158, is that the same phone number you testified to was the phone call at 4:40 a.m. and on the 772 phone?
Yes.
Okay. So going on to those, do you again use the same information to depict timing advance and cell sites and everything of that nature?
Yes.
The two phones, is it important to know what network a phone is on before you do the mapping?
Yes.
Okay. Were both of these phones on the same network?
Yes.
On this particular one, what network were both phones on?
T-Mobile.
Okay, so back to the red phone. I know these, again, fairly and accurately depict the location of the T-Mobile towers of October of 2018.
Yes.
Same locations of interest, or is there an additional one on this particular item?
There's an additional one.
And what item or additional location is on this map that is different from the others?
The Toscana Apartments, 5700 Toscana Lane, Margate, Florida. It's shown with on the map with an orange flag with a white letter T on it.
And if you could just circle it so it's clear to the jury where that's at.
Here's on the map. Here's the actual location.
Everything else remains the same?
Yes.
Okay. So on the 954-376-9158, the kind of turquoise phone, what information are you showing from 1:08 a.m. to 8:23 a.m.?
So this is information from the call detail records, not engineering data. This is calls and texts. And it shows that between 1:08 a.m. and 8:23 a.m., there are several calls and texts at the phone, to and from the phone, using two different sectors of the same tower, shown here with two different wedges.
And so based on your training experience, do you have an opinion as to where that phone was from 1:08 to 8:23 a.m.?
Yeah, so generally in the area, just kind of apartments.
Moving on to October 26, 2018, from 12:01 p.m. to 12:12 p.m. on this turquoise phone, the 954-376-9158. What information are you mapping here?
So here we're showing both the engineering data, the timing advance information, as well as information from the call detail records. So first, 12:01 and 12:02. The phone, turquoise phone, is in these two bands here. First, this one is a little closer to the tower, it's 0.63 miles away, and then the second band is 0.73 miles from the tower. During that time period, also at 12:01:39, the turquoise phone places an outgoing call to the red phone, 9807.
So then the next time frame that you're mapping on this location is what?
It's 12:05 when the timing advance measurement that's recorded is 1.02 miles from this tower, south of it.
Okay. Going on to 12:06:07 to 12:12:37.
So during that time frame, there's measurements from two different sectors of the same tower. So we see on the one hand that there's arcs here that are either 1.45 and 1.5 miles from the tower.
Okay.
But also during that time period, we have measurements from a different side of that tower. They're 1.5 and 1.55 miles from the tower.
Okay, and in terms of the location, is there anything you can say with specificity as to where that phone was at 12:07?
No, I mean, I think that I would generally look for the phone to be someplace where the arcs are overlaid, or an area where it would be seen by both sectors, but no, you can't in isolation do it.
Do the cell phone towers overlap in their sectors?
Yes, they do.
Going on to October 26, 12:14 to 12:20 a.m., the 954-376-9158 phone number, the turquoise phone. What are we looking at in this image?
So starting down here, south on US 27, or excuse me, on the tower near the area of Pines of US 27, it's pointed south. At 12:14, 14 p.m., the band is 1.45 miles from the tower. Then a few seconds later, it's 1.21 miles from the tower. It's getting closer. A few seconds later, it's 0.97 miles from the tower. And then 0.48 miles from the tower. Then it's in this band on a different sector, but perhaps still close to the tower, traveling the same direction, 0.63 miles. And then to the north, 1.1 and 1.6 miles from the tower.
And so in terms of the north to south distance of each of these bands, how wide are they? If we're looking at the north to south, aspect between here and here, what type of, remind me, what, is this still on a 4G phone?
Yes, yeah. So each of those arcs is still 78 meters deep.
Okay. Based on the multiple locations that you have, do you have an opinion as to how that phone or handset was traveling?
Yeah, I think the data is consistent with the phone traveling south and north during that time.
Now going on to the 772-713-9807 between 12:01 and 12:12 p.m. on October 26, 2018. What are you illustrating with this particular image?
So at 12:01, first there's an incoming call from the turquoise phone 9158, and then at 12:01, the red phone is in this band, 0.92 miles from the tower. At 12:03, it's 0.68 miles from the tower. At 12:05, it's 0.92 miles from the tower. And then 12:07 to 12:12, it's 1.55 miles from the tower.
Okay, and just to flip back again to the 12:01 to 12:12 for the 954-376-9158. In terms of, can you make any opinions as to where these two phones were located in relation to one another during these time frames?
So they're in the same general geographic area for sure. Right? They're both on the same tower at the same time, near Pines and US 27. There's areas where there's times when their bands are approximately the same, and there's times where they're different as well.
Okay. Can you make any sort of opinion that they were in the same vehicle?
No.
Going on to the 772-713-9807 phone from October 26, 2018, from 12:14 p.m. to 12:21 p.m. What data are you illustrating in this particular slide?
So the first data point, 12:14:47, is this band here. It's 1.02 miles from this tower. The next one, 12:16:28, is this band here, 0.92 miles from the tower. Then continuing on in time, at 12:18:08 p.m., the red phone's in this band, 0.92 miles from the tower. And then at 12:18:28, 0.68 miles from the tower. And then finally at 12:21:17, it's 0.29 miles from this tower.
And in terms of that was the end of that mapping and cellular analysis that you were asked to do in this case.
Yes.
Do all of the maps fairly and accurately represent your testimony that you just gave?
Yes.
In terms of, we talked a little bit about cell phone signal and things like that. Does being in a parking garage or being at elevation change your analysis of where the phones would be?
Being a part of the elevation change. I mean, I don't think so. No.
If there was something that was a red flag in the data, what do you do to catch that?
Well, if I see a red flag for whatever reason, something that doesn't make sense, I'm going to look at it much more closely and try and figure out, okay, what is the issue? Is there an issue?
Was there any such information or issues that in the records that you looked at in this case?
No.
Can you ever say why a phone picks a particular tower or doesn't pick a different one?
Yes. So if we're talking about making a call or sending a text, and then from the call detail records, the phone picks the tower based on its readings of signal strength and signal quality. The phone always picks the tower with clear, strong signal. If we're talking about the engineering data, what the network sees, why the network reports the distance measurement from one tower instead of another, no, I don't know why.
Oh. In terms of, can you tell whether or not a specific tower was working on the evening in question?
If there's a record associated with that tower, it was working on the evening.
There's other mapping software that's available. Does the FBI use a specific mapping software when doing this?
Yeah, we have a couple different programs. I used one program.
Okay, and what is that?
ESPA.
What is that specifically?
ESPA is a program for cell site data.
Why do you use that specific program?
Well, it's the tool, one of the tools that we have, and they meet our needs or requirements as an agency.
In terms of just plugging the latitude and longitude into Google Maps, is that something you can testify to based on those records?
Yes.
And do you use that and those latitude and longitude that are in that timing advance data to determine where the phone was?
So I didn't use the latitude longitude to produce that report. Could I use them? Could I plot them in ESPA or Google Maps and look at them? Sure. Yeah, absolutely.
Why don't you rely on them?
I don't rely on them when I'm doing my expert testimony because I don't understand all the factors that go into the network driving that estimated location for the device. For investigative leads or something, if I'm looking for a kit, of course I'm making my report for expert testimony. I use the time in advance to understand the math.
And in terms of, is the math constant?
Yes.
Do you take into account, you mentioned the UTC time versus local time. Do you take that into account in all the records when you're looking at those?
Yes.
Does the power of the antenna or cell site affect your analysis on the speed of light and the distance from the tower for each cell phone?
No.
Okay. Can you explain what is tower loading?
Tower loading. Like when a tower gets overloaded?
Correct.
Okay. So towers have, finite capacity. There's, not unlimited network resources for a phone company. So generally, you're able to make calls or text whenever you want, right? Like towers generally don't get overloaded, but it is possible for towers to get overloaded. So the way you see that, I guess, would be one, if you're trying to make a call. If you've ever experienced the phenomenon where you're looking at your phone, like say it would have to be an event where there's a ton of phones, like an unexpected, unanticipated influx of devices and people, like say the Super Bowl or something like that, and there's just an incredible demand for network resources. Everybody's trying to Facebook Live or make calls, take video, everything. So if you've ever been in a situation where you're looking at your phone and you see, man, I have like great service, I have 4 bars, but I try and place a call, and the call just won't go through. It's because the towers, could be because the towers are overloaded and you just can't handle your call.
Okay, and in terms of, would that be something that the phone would be able to see in the phone records?
So if the tower's overloaded, the phone won't know that it's overloaded, right? The phone can't see or doesn't have a view into what the network is handling, which is why your phone has identified a particular antenna as the one that offers the clearest, strongest signal. It says you've got 4 bars from this antenna, this is the one I'm going to connect to. It doesn't know that that antenna is overloaded, and so that's why when you have 4 bars, you hit send and try to make a call, the call just doesn't connect, it just won't go through. The phone doesn't know, oh, I should be looking for an extra antenna someplace. All it knows is that's my antenna.
And if there's no records or no entry in the records, can you analyze any of that data?
No, obviously I only am able to analyze the data that I have data points for.
In terms of the mapping and everything that you created, is it a fair and accurate depiction of the cell phone data and records that you just specified to?
Yes.
Does it in terms of as you're creating it, are you creating it as an expert in cell phone data and mapping?
Yes.
Do you do validation and verification of the data and the information that you're relying on?
So, through my training experience, I know that the time in advance data is very accurate. And we talked about that earlier or yesterday, where it's like have real life validation for it. Like, yes, I've done historic cell site analysis, had it validated by finding the phone in the place where I expected it to be, or seeing video of the person with the device at that point in time.
All right. Here, if we may approach Sidebar.
Break, so we're going to take a short recess to not discuss the case, not form any opinion about the case, or allow anyone to discuss the case with presence or research. Please leave your notepads on your chairs. We'll be back really shortly. Thank you. Thank you. Let the order reflect the jury step down. Counsel remain. Call with the defendant and no witness. Yes, counsel, I'm sorry. I just figured it was easier if we just let the jury go.
Understood. Yes,
Makes sense. Your Honor, may we have this discussion just in case there needs to be some supplementation testimony outside the presence of the court?
Sure. You can step outside.
Yes.
Thank you, sir. Special Agent Collins has left the courtroom. Yes, sir. He wants an issue, yes?
Well, he's got to use the restroom.
Who does?
Defendant.
Sure. We'll take we'll be in recess. Arrange for a restroom break for Mr. Demons.
And I provide a case officer of the court and counsel on the admissibility of the demonstrative exhibit that appears the state.
Thank you. I'll take a look at it.
the two phones, is it important to know what network a phone is on before you do the mapping?
Yes.
Okay. Were both of these phones on the same network?
Yes.
On this particular one, what network were both phones on?
T-Mobile.
Okay, so back to the red phone. I know these, again, fairly and accurately depict the location of the T-Mobile towers of October of 2018.
Yes.
Same locations of interest, or is there an additional one on this particular item?
There's an additional one.
And what item or additional location is on this map that is different from the others?
The Toscana Apartments, 5700 Toscana Lane, Margate, Florida. It's shown on the map with an orange flag with a white letter T on it.
And if you could just circle it so it's clear to the jury where that's at.
Here's on the map. Here's the actual location.
Everything else remains the same?
Yes.
Okay. So on the 954-376-9158, the kind of turquoise phone, what information are you showing from 1:08 a.m. to 8:23 a.m.?
So this is information from the call detail records, not engineering data. This is calls and texts. And it shows that between 1:08 a.m. and 8:23 a.m., there are several calls and texts at the phone, to and from the phone, using two different sectors of the same tower, shown here with two different wedges.
And so based on your training experience, do you have an opinion as to where that phone was from 1:08 to 8:23 a.m.?
Yeah, so generally in the area that is kind of apartments.
Moving on to October 26, 2018, from 12:01 p.m. to 12:12 p.m. on this turquoise phone, the 954-376-9158. What information are you mapping here?
So here we're showing both the engineering data, the time in advance information, as well as information from the call detail records. So first, 12:01 and 12:02. The phone, turquoise phone, is in these two bands here. First, this one is a little closer to the tower, it's 0.63 miles away, and then the second band is 0.73 miles from the tower. During that time period also, at 12:01:39, the turquoise phone places an outgoing call to the red phone, 9807.
So then the next time frame that you're mapping on this location is what?
It's 12:05 when the time in advance measurement that's recorded is 1.02 miles from this tower, south of it.
Okay. Going on to 12:06:07 to 12:12:37.
So during that time frame, there's measurements from two different sectors of the same tower. So we see on the one hand that there's arcs here that are either 1.45 and 1.5 miles from the tower.
Okay.
But also during that time period, we have measurements from a different side of that tower that are 1.5 and 1.55 miles from the tower.
Okay, and in terms of the location, is there anything you can say with specificity as to where that phone was at 12:07?
No, I mean, I think that I would generally look for the phone to be someplace where the arcs are overlaid, or an area where it would be seen by both sectors, but no, you can't in isolation do it.
Do the cell phone towers overlap in their sectors?
Okay, let's talk about this a little bit more. So, Paul, you had brought up an interesting question to me in the break about what the defense will do if you had the opportunity to cross-examine this FBI special agent. What would you do?
Is there an objection?
There is no objection, Your Honor.
What's the objection?
The objection is that although those diagrams might accurately present what he testified to, his testimony alone talks about those diagrams are inaccurate. Imprecise, excuse me. Specifically, he stated in his testimony that there is a margin of error If you look at those diagrams, it appears that the phones are traveling together. It looks like they're at the same location. But if you listen to what his testimony says, one, there's a margin of error. He also goes on to say that specifically the precision is limited and cannot precisely determine the location of the phones when the mapping tends to show a precise location. The maps alone contradict his testimony. Furthermore, these charts tend to place the phones together. As you heard the testimony, it looks like they're overlapping. However, he also testified that even though it shows that the phones are together, there's this band that the phone could be on this end of the band, or the other phone could be on this end of the band. And I believe that precision is over miles. I would state that it's misleading and highly prejudicial to a jury to be admitted. And I would also remind the court, I thought we had addressed this yesterday, and you stated that his reports were not going to be coming in. And she does bring up the 403 on the test. If I look at this case law that she goes through, prong 4 is not met, stating pursuant to section 90.403 Florida statutes, the evidence, although technically relevant, must not present a substantial danger of unfair prejudice that outweighs its probative value. And that's exactly what these demonstrative charts are doing.
Thank you. Anything else from the defense?
No, Judge.
Anything else from the state?
Just relying on the case law.
Counsel, it appears to me that, we talked the other day about the report per se not coming into evidence. Counsel just wanted, my understanding, to admit it wholesale, and I said I didn't think that was appropriate, and I sustained the objection to put that in there. But that's different from the maps and things like that. It appears to me that it meets all the criteria as stated in the case that counsel provided here, and the witness identified it, he spoke about it, he explained it, and I don't disagree with you that he said it's not a, there are some variances in it, and that's been brought out in direct examination. I'm sure you're going to bring it out in cross-examination as well. I don't believe there's any 403 analysis that's not some type of unfair prejudice, substantial chance of unfair prejudice or anything along those lines. This is exactly what he testified to. So I didn't admit it. Objection notice over. These are items QQQ, RRR, and that's still be admitted. All right. You ready to proceed?
Yes, sir.
All right, bring the witness back in. Let's get the jury in.
Jury entered.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the acquittal of the defendant. Demons of counsel, the assistant state attorney, ladies and gentlemen, the jury, all witness, attorney, Collins remains on the stand. Ladies and gentlemen, outside the present, the state offered items QQQ, RRR, and SSS. Is that correct?
Yes, Your Honor.
All right, and they were admitted into evidence. What's the
States QQQ will be 65, states RRR will be 66, and states SSS will be 67.
Thank you. Counsel Jury, you may proceed.
Thank you. Okay. Special Agent Collins, I want to go through on some of the timing advance records. And just so for the purposes of what we're talking about, it's row 139, 140, 141, 142, and 143 of the 772-713-9807 phone records. The latitude and longitude you mentioned, and this would be covering the times from 3:48 a.m. through 3:52 a.m. You indicated that the latitude and longitude are the first columns that are put there. And then the next column, column C, is called confidence.
Yes.
What does the confidence column modify?
It refers to columns A and B.
So is there a numerical value that's assigned to the low, high, and medium data entries in column C, the confidence?
So confidence, it refers to, that's T-Mobile's determination based on the number of data points that they have used to derive or estimate the device's location with that latitude and longitude, refers to, or gives it confidence look like low, medium, or high based on the number of data points, basically.
And in terms of, do you use that in any way, shape, or form to testify to where you are placing the phone in your analysis?
No.
Okay. The question as to the difference between accuracy and precision. Can you explain that?
Sure. So precise, I guess, would be much more narrow. In other words, the latitude and longitude, what we were just talking about, like that is incredibly precise. That refers to like a particular point on Earth. But it may not be completely accurate. Like there could be a margin of error in it. So, for instance, if there's a margin of error that says, okay, like I'm giving you a precise point, a particular latitude and longitude coordinates, but my margin of error is 800 meters, well, that might not be very accurate. What you're saying is it's somewhere within an 800 meter in radius of this latitude and longitude point. So, I guess precise would be very small. Accurate, whether it's reliable or not. In other words, like a cell site used by the phone to make a call, for instance, that's not a very precise area. We're talking about a general coverage area of an antenna. But it's completely accurate. Like, there's no denying that is the cell site that the phone saw as the cell sector that gave it the clearest, strongest signal. So it's very, very accurate, but it's not very precise. It's the size of the coverage area.
Okay. And so last but not least, from the state would just be publishing part of State 64. The top number, the 954-376-9158, is that the cell phone that you did the analysis on? One of them?
It's one of them, yes.
One of the phone numbers?
Yes.
Okay. For the record, publishing part of State 64, contact list for the phone number 954-376-9158 from the phone extraction 772-713-9807. No further questions of this witness, Your Honor.
Thank you, counsel. You have any cross-examination?
I do have a cross-examination, Judge. But if you remember before court, I had asked that we take a break before.
Oh, yes. That's it. Why don't you come side by side?
It's on lunchtime.
Council, 2 minutes to set up, and my thought is we just take a luncheon recess now. So do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence or do any research. It's now looks like 5 to 12. So how about if we see everybody back here 1:15? All right. Does that give you enough time? Yep. All right. 1:15 for lunch. Remember, don't discuss the case. No research. Just leave your notepads on your chair. Reflect the jury's excuse, Counsel Manuel, the defendant. Anything to discuss, ladies? No?
Just returning all the evidence trust.
All right, so see everybody back at 1:15. All right. 10 minutes lunch.
Excuse me, but
Good afternoon, and thanks for joining us. I'm Anjanette Levy, and you are watching Law and Crime. We will be taking your questions this hour in the trial of YNW Melly. He, of course, is on trial for the murders of his two friends, YNW Juvy, YNW Sakchaser, back in October of 2018. Keep your questions coming to us on TikTok, Twitter, Instagram, all the platforms on social media, YouTube, of course, and we'll get to as many of them as we can during this lunch break. And this morning, it's all been about cell phone testimony. First off, let's check in with Terry Austin, who is at the courthouse in Broward County. She is covering the case for us with the very latest on what's gone on in court today. Terry, bring us up to speed.
Well, it's been a very interesting morning for certain. Judge Murphy has been at times a little irate at the prosecution, and he actually ordered the prosecution to make copies of reports that the defense had not received to date. Technically, the discovery should be over by now, but these reports were not completely given to the defense, and so the judge said, you must do that. We took a long break, and those copies were given. We have on the stand still FBI Special Agent Collins, and he is testifying about the cell phone data and the information that was downloaded. So he's talking about all of the various different phones, where they were located. He did put several of those phones at the scene of the crime. So his testimony is going to continue for probably the rest of this afternoon. I would say that the jury is extremely attentive. They want to know what is going on with this data. He actually is the first witness who is analyzing the data. So I think it's very interesting for that jury to see what is going on in the crime scene.
I don't often hear, Terry, I feel like sometimes judges are pretty lenient during trial, but he said this is a discovery violation. You don't hear that a lot during trial. You hear a lot about disputes during the pretrial phase over discovery, the defense claiming, you know, a lot of times in these high-profile cases and a lot of other cases that they're not getting the discovery they are entitled to in a timely manner. So what did you make of the judge basically saying this is a discovery violation?
You know, I couldn't agree more. You don't hear judges saying that this is a violation. And not only that, he actually sanctioned the prosecution. As it turns out, the lead investigator in this case, Moretti, had a report and then a follow-up report. But the defense did not know about that follow-up report until the defense cross-examined actually another officer, Zeller. So because of that, the defense is at a, they basically were not able to look at that report and determine what they wanted to use for that report. So the judge said, look, you can't get that report in now, and you can't call any of the officers to talk about that report. So it was a win for the defense, and it was a sanction for the prosecution. And it is very rare that you see something like that. It's definitely a slap on the wrist, and it's something I think the prosecutor will have to think about when she goes back to the office. It's, obviously very difficult when you're on trial, what to do, what not to do, but you never want to be sanctioned. You never want to have the state to actually be hurt or the defense to actually be hurt. And here, the state has been hurt. They cannot bring in that evidence to this trial.
And it's really an unforced error because they could have just turned over the information. It's as simple as that. We are going to be taking your questions this hour, as I mentioned, so let's get right to it. As I said, keep them coming to us on YouTube, Twitter, Facebook, Instagram, TikTok. We'll get to as many of them as we can over this next hour. Linda Kenny-Bodden is here with us as well. Famed defense attorney, has done her fair share of high-profile trials over the years, and, of course, a Law and Crime Network host. So, Linda, this first question will go to you. At Harry Low Keys 7144 asks, what do you think about all the love Melly is getting? I've been watching our YouTube chat a little bit today, Linda, and I can tell you, Melly is getting a lot of love. So it makes you wonder, are these a lot of his fans in there? Is this PR going on?
Yeah. Well, first of all, good morning, good afternoon, Anjanette and Terry. It's always wonderful to be on with you. But yes, I've noticed that. I noticed that his followers have increased on all of his social media accounts. But I think part of it also is that the prosecution case is looking a little bit, shall we say, problematic. So they're giving him love because they feel now that perhaps he's been in jail at 24 years old for 4 years on a case that he shouldn't have been charged with in the first place because he became the suspect because of who he was. So I think the love follows that, Anjanette.
Yeah, it seems like his followers, he's got a fair share, a lot of people going on in there, a lot of fans, a lot of supporters, whatnot. Terry, what is the vibe like in the courtroom today, I guess? I'm wondering from you right off the bat. We kind of touched on this earlier with the jury looking engaged and everything, but among the victims' families and Melly's family, does there seem to be any tension right now?
Well, I would say that most of the tension right now is coming from the defense and the prosecutorial teams. They are really bickering about the evidence. And right now, as I mentioned before, I think the defense has the upper hand. The audience is basically just paying a lot of attention. There are more people who are on the side of the courtroom for Melly. As you mentioned, there are some Melly fans, obviously a lot of the family members. And on the other side of the courtroom, we do have some of the family members for the victims as well. I would say that most people are just listening intently to the witness on the stand. They are watching, obviously, Melly as he sits there. One thing I'll add, Anjanette, he is paying, Melly is, close attention to this FBI agent. He is looking at the witnesses, and he is actually taking some notes. So I would say the whole courtroom is paying very close attention to this particular witness.
And you know that this cell phone data information, cell site location data is very important to the state's case. That means it's also important to the defense's case. Our next question comes from Melly Lover. My question is the evidence against YNW Melly irrelevant, like YNW Melly's lawyer says it is, Linda? And this question is coming to us on TikTok.
Well, there are only 2 people in the car who survived the shooting. And one of them is Melly, and another one is his co-defendant. So just as we had in the Aaron Hernandez case, which I tried, the prosecution always goes, in my opinion, for the person who is more famous. And YNW Melly is more famous. And that's what the defense is saying. You targeted him. You absolutely targeted him. Now, does that mean the evidence doesn't prove it was him? Well, if there's any little bit of doubt that it could have been Henry, that he's the one who could have been the shooter and not Melly, that Melly could have gotten out of the car, that it wasn't Melly's phone that we're hearing about, sure, the prosecution's case could be very weak when it goes to the jury, especially in a death penalty case. Remember, that jury is watching everything there. So every time the defense objects, they go to the sidebar, and there's a ruling which seems to favor the defense. The jurors also see what our viewer sees.
Most definitely. All right, we are going to take a quick break. Keep the questions coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll get to as many of them as we can. Stay with us. I'm Anjanette Levy, and you're watching our live Q&A on Law and Crime. We'll be right back. Welcome back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime. We are in the middle of a lunch break in the trial of YNW Melly. He is the South Florida rapper known by his legal name of Jamell Demons. He's accused of 2 counts of first-degree murder for the October 2018 deaths of his 2 friends and YNW members, YNW Juvy, who was Chris Thomas Jr., and Anthony Williams, who went by the stage name YNW Sakchaser. We're taking your questions during this lunch hour, as we always do, so keep them coming to us on Twitter, Facebook, YouTube, Instagram, and TikTok, and we'll get to as many of them as we can. Joining us now is Bridget Williams. She is a defense attorney. Also with me is Linda Kenny-Bodden, a defense attorney and Law and Crime host, and Law and Crime's Terry Austin, who is down there at the Broward County Courthouse for us covering the case. Our first question, and Bridget, I'll bring this, throw this one over to you. Our first question right now is Hasco Vlogs from YouTube asking, they just need him in the location of the scene to convict him, right?
Well, the thing is that, again, the phones are putting, the records and what the witness is testifying to. He is testifying as to where the phones are located. And that does not necessarily mean this is where Melly was. This does not mean that is where he was at, exactly. And so I would say, no, not exactly. That's not all they need. We know that he was already in the car, right? We saw him getting in the car at the beginning when they were leaving the recording studio. The issue here is, when did he leave that car prior to the victims getting shot? If he did leave the car before the victims were shot. And so we're looking at the time frames here, not necessarily was he there, was he or not.
Mm-hmm. There are a lot of pieces of the puzzle in this case. The surveillance video, the cell records, the differing stories of differing witnesses, and the co-conspirator in this case. Our next question comes from Diana Shields from Facebook. Terry, I'll throw this one to you. Why did the DA, meaning the district attorney in Florida, it's the state attorney, in that county, put this prosecutor on such a high-profile case?
Well, sometimes you get the luck of the draw. I mean, I think this prosecutor probably prepared for this case, but she wasn't prepared for, I think, a defense team that really does have all of the information that they need to proceed forward and to make the objections that they are making. So the defense is not making it easy for the prosecution. They are doing their homework. They are putting in the cases. And I think the prosecutor is doing the best she can with what she has. I think the biggest mistake, Anjanette, that she's made so far is to not turn over the discovery. You mentioned it before. It's an unforced error. It's something that probably someone who is new would be doing. I don't know how long she has been in that prosecutorial office, but frankly, I think that was probably her biggest mistake, and hopefully she'll learn from that.
And I think it is a formidable defense team, and you can tell David Howard is prepared for just about anything. I mean, he's very good. You can tell he's this is not his first rodeo. Our next question is from Dior Kennedy 745 from YouTube. Linda, is there such a thing as a surprise witness? If so, what's the procedure to bring that testimony in?
Well, there can be no surprise witness from the prosecution because we don't try cases by surprise anymore like you would see on TV and maybe the old Perry Mason shows. Everything is regulated. Prosecution has to turn over all items, and you'd be surprised in how many cases, Anjanette, they do not. That's why we have innocent people that are convicted, and we find 20 years later that there was something in the file that was exculpatory, which means that the person was not guilty. So there can be no surprise witness, but if a new witness came in that no one would have an idea would be coming in, then the prosecution would still have to give notice, and the defense would have time to prepare for that witness. But that's usually not the case.
Our next question, Bridget, I'll send it to you. It's from Twitter. @Nat asks, if Melly does get sentenced to death, will he have a chance to speak his last words for the courtroom for his fans?
You know, I think that he definitely will be able to do that. That's up to the court. The judge will make some, words and allow for him to be able to do that. But the first threshold is getting over if he's going to be found guilty, and that's where we are now. And if he is, then we move on to that step. And if that is the case in a sentencing or anything at that time frame, then the court will make the announcement that allows for him to be able to have any last words, or if he wants to say anything to his fans or to his family.
And it won't be last words. Let's say he is ultimately convicted and he is sentenced to death. I mean, he would be able to speak, obviously, anytime he wants in this trial. He can take the stand to testify in in his defense case in chief, or he could speak in the mitigation phase. We just don't know if he would choose to do that, but it would take years and years because there would be so many appeals in this case. Dior Me, yes.
The Florida Supreme Court has just stayed 2 death penalty cases in the penalty stage as a result of the 8-4. It just happened last night as a result of the 8-4 law that Governor DeSantis signed. So if this case even got a conviction, there'd be a question whether or not the defense team would apply for a stay and whether it be stayed.
Oh, and that could definitely happen. Thanks for adding that, Linda. Our next question comes from Instagram. It's from DiorMe_me. Terry, is the cell phone evidence debunking Melly's statement that he wasn't in the car at the time of the shooting, but cooperating with deposition of Miss Felicia Holmes' statement of the FaceTime call?
Well, that's an excellent question. Right now, the witness has not put the car at the scene. One of the things I think the prosecution will have to do is to get information from the car that car is at the scene. The cell phone data just means the cell phone was at the scene. As a matter of fact, it doesn't even mean Melly was at the scene because the phone could have been carried by anyone else. So I definitely don't think that it's a problem, anything Melly may have said at this point, because the prosecution hasn't proven that Melly was at the crime scene, that he was holding the phone, or that he was in the car. The only thing they are showing right now is the location of the cell phone, all of the cell phones, frankly. And so I think we do have a ways to go to actually say that Melly is the one who did the shooting. He had the gun, he was in the car. Long way to go before that.
Bridget, this next question I'll send over to you, also from Instagram. 543 Ina asks, hi, tuning in from Australia. Thank you, Australia. We always love it when we get questions from different countries, and we do get a lot of Australian viewers. My question is, will the jury look at YNW Melly behavior, happy, giggling, goofing around, etc., and take it as there is no remorse, therefore he is innocent? Or will it backfire on him, and the jury will the jury take it in a negative way, Bridget?
Well, we never know what jurors are thinking. However, as a defense counsel, it's our job really to let the defendant know before a trial, before a hearing, before any matters before the court, to take it seriously and to make sure that they are on their best behavior. Melly has been quite the character throughout this entire trial. He mouths words to people in the audience. He says prayers. He gives kisses in the air. I believe he was said on his social media that he was giving kisses to angels, is what he said on his social media. And so if I was his defense counsel, I would have nudged him at that very moment to stop it right at that time. I also would have had a conversation with him prior to trial to make sure that he is being in a serious manner, that he's also showing that he's taking this seriously. You just don't want the jurors to think anything differently. You want them to make sure that they think that this is serious to him. I mean, he's being tried for a double murder case and, could be sent to death here. And so it's a very serious offense.
It's as serious as you can get in our criminal justice system in the United States, and really in any country for that matter. Our next question comes from Alex A. from YouTube. What does hung jury mean, Terry Austin?
A hung jury is a mistrial. It means that they can't all come to a unanimous decision. We're in the guilt phase here, and they do have to come to a unanimous decision on both of these murder counts that we have first degree for Melly. And so if you don't have, all of them agreeing, and it can take time, these types of things, sometimes the judge has to go back and say, look, it may seem as though you have lots of questions. It may seem as though you can't come to a decision, and he might give a charge saying, go back and see if you can come to one kind of conclusion. So right now we are nowhere near the, deliberation phase, but if they actually do start deliberating and if they do become hung and that charge doesn't address the situation, then that could mean that there is a mistrial. And a mistrial simply means that they could start all over again. The prosecution would have the ability to make the decision as to whether or not they want to bring the charges against Melly again. So hopefully there won't be a hung jury, which would mean a mistrial, because with all of the effort that's been put in already, you want to see some sort of definitive conclusion to the trial.
Most certainly. Our next question, Dakota.G9, Linda Kenny-Bodden. This is coming from Instagram. If the defense is winning at this point in the trial, how do you think the prosecutors could sway the jury in their favor if they do not have any more hard evidence or witness testimonies to provide them with?
Well, this is a really interesting question, because remember the surprise witness issue the other day, or the other question we just had? There is one thing that prosecutors may decide to do. They may decide that the devil in this case is Melly, and then go back to the attorney for Henry and say, let's make a deal. Will you testify as a prosecution witness, and we will give you a deal of whatever time served or whatever, on the basis that they feel they need to get Melly. I don't think that's going to happen, but it's always in the prosecution arsenal. And they could say to the judge, the deal was just made. The defense can then move it. They'll move for a mistrial. They'll move for all sorts of motions, but the judge will let it go through.
So even that late in the game, Linda, you think the judge would allow it if they said, hey, we made a deal with Bortlen, he's going to come in here now?
Yeah, I think because the deal is dependent on the attorneys, right, to accept it in the first place. So I think he would. He may put a little delay. And remember, we have that delay built into the third week of July here. So that could happen. I don't think it's going to happen, because I don't think Henry wants to be in jail or in prison being the proverbial, what we used to call snitched, or now call incentivized informant. But it's there.
Yeah. In prison, though, they still call him snitches. So he probably does not want to be labeled a snitch. It's never a good thing. All right. We are going to take a quick break. Keep the questions coming to us. They've been fantastic. Twitter, Facebook, YouTube, TikTok, Instagram. And we'll be right back. I'm Anjanette Levy, and you're watching Law and Crime. Welcome back. I'm Anjanette Levy, and thanks for joining us this lunch hour as we take your questions in the YNW Melly double murder trial in Broward County, Florida. Lots of good questions coming in, so keep them coming on our YouTube chat, Twitter, Facebook, Instagram, and TikTok. We'll get to as many of them as we can, and we've got a little bit of lunch with the ladies going on today. All-lady panel taking your questions. Linda Kenny-Bodden is here, Bridget Williams, a criminal defense attorney, and Terry Austin is in Broward County, Florida for us at the courthouse covering the case. Our next question, Terry, I'll throw this one to you, comes from Chris Prince from YouTube. Is a defendant smiling in court a normal thing? In your opinion, is the defendant usually found guilty when showing that type of body language?
Well, I think a defendant smiling in court is a normal thing. You have to remember that it's very nerve-wracking, and you automatically have responses that you really cannot control. So I think if you see someone smiling and they're fidgeting around, it could just very well be nerves. Now, I will say that in the past, I do think that Melly has been more active and more pronounced. Today, he is very serious. I've seen less smiles, and certainly there are no antics going on. And as far as the jury is concerned, the jury does look at the defendant at every move and every motion that that defendant makes, because they're trying to make a determination as to whether or not the defendant is guilty or innocent. And so I think they are looking at him. It doesn't seem to me, because I'm looking at the faces of all these jurors. We have 15 jurors. We have 9 women and 6 men. They actually seem to be paying more attention to the witness. And they think, you know, at least it seems as though they're thinking that whatever it is that's going on the defense table is something that might be normal. It doesn't seem as though they're using it against him. So at the end of the day, I don't think that the antics will be used against him. No way to really tell. But right now, he is being very serious.
And I think we should point out, in fairness to Melly, a lot of what we saw during the first week of the trial with the praying and the blowing of kisses and all of this stuff, a lot of that happened outside the presence of the jury. It was captured by our camera, but, you know, the jury is not supposed to be watching anything regarding this case. So they shouldn't have seen any of that. All they should see is what's going on right there in front of them in the courtroom. Our next question comes from Miranda O'Ganier from YouTube. Linda Kenny-Bodden, are they going to revisit the evidence of the shots in the car, because multiple of those bullet holes would have gone through Bortlen and Melly if they was in the car, and that shows that they both got out?
Well, that's interesting, because I do not know, because I don't have the list, whether the defense has a reconstruction expert, a crime scene reconstruction expert, and whether or not they feel the need to use that, or whether or not they feel that they poked enough holes in the cross-examination of the prosecution's expert to say that indeed it shows that only one of them maybe could have gotten out. But if I were the defense right now, and I'm a big one for putting on a defense case, I'm not sure I would use a crime scene reconstructionist here. But again, I'd have to see the reports, and sometimes you just have to live the case. But you see how close attention our viewers are paying? That's the same type of attention and questions in their head the jurors have right now.
Mm-hmm, most certainly. One thing we should point out, too, that I think is really interesting, and we haven't heard this testimony yet, Linda, but Christine Bradley, the assistant state attorney, said in her opening that the evidence, the medical examiner is going to testify that Juvy and Sakchaser were dead when the bullets were fired into the vehicle, not from the back seat where they claim they were fired from. So that'll be some interesting testimony when that comes up. Yeah, J Cinco exclamation point from YouTube, Bridget, asks, question, when do you think they will start trying to bring in his music into it? And will it have a big impact on what the jury might think? I'm not really sure, Bridget, that they're going to go there.
Right. I don't think so either. That's an interesting question. I know that, sometimes the state will bring in evidence from a defendant's social media, from their music, from their lyrics. He has a song that it's called "Murder on My Mind," so I don't know if the state is going to be bringing that in right now. it's their job to show that he, in fact, was the killer in this particular situation. And so if I were the prosecution, I would be focusing on, the fact that he was in the vehicle at the time. He was the person who made the shots that came from within the vehicle.
Yeah, and I hate to bring this up again, but in the opening statement, Christine Bradley said something like about music being artistic expression. We won't be getting into that. But she did talk about social media messages. So maybe the judge didn't let them go there, and maybe the prosecution's just saying, we're not even going to touch it, because bringing in rap music lyrics has been a kind of a controversial thing, bringing this stuff into trials across the country. Terry, let's get a question over to you now. This is from Jessica Ann from Facebook. Has the prosecutor lost the jury with all of this long testimony?
Well, yeah, that's a very good question. I think in the beginning, yes, they had witnesses on the stand who went on and on talking about information that really wasn't relevant, just sort of trying to teach the jury what was going on from an evidentiary standpoint. But now they're putting on witnesses who are fairly quick, getting up and down. And so I think the jury is paying attention to these witnesses because it's not prolonged. Now, in cross-examination, I do think the defense is doing a really nice job at disputing some of the information, making it seem like they didn't go far enough, or they're not doing an analysis, or they're not the experts to really talk about the data. It's mostly forensic data, and that can be boring, I agree, but I do think this is a very tentative jury, and they are paying close attention to everything that's going on that witness stand. I don't think they're being distracted by anything in that courtroom. They're paying very close attention.
All right. Linda, this next question I'll send over to you. It's actually, we kind of have two questions put together from two different viewers. Nina Stanek from YouTube, who is from Switzerland, so thanks for tuning in from Switzerland, and Joe Nose from YouTube. Both are asking about Cortlen Henry, the co-conspirator who's charged separately in this case and will face trial at a later date in a separate trial. Asked, do you think Cortlen will take the stand and snitch on Melly? Is Bortlen a state witness in the case? Will he have his own trial? So yes, he's going to have his own trial. I answered part of that. But Linda, the rest to you about, do you think Cortlen will take the stand and will he snitch?
Well, that's a question that we just talked about with a little bit different bet. Thank you, Nina and Joe. Because the question is, will he snitch? Now, remember, he could be a witness, but I would imagine that if he gets on the stand and decides to snitch, right, what's the defense going to do? What did you do? You found God when it was decided that you had to have your own trial in your own death penalty case, and now you want to talk about YNW Melly? You didn't say that before. You didn't say that before you got a deal, and the deal saves your life, not his, doesn't it? And there you go. The defense really has a lot to work with. So my impression is no, he won't take the stand, even though the prosecution may decide they need him because they're losing the jury.
Yeah, I don't think Bortlen's going to be taking the stand. I just don't. I think it's too risky for the prosecution. Plus, he's accused of murder. I just don't think it's going to happen. TT by 3 from Instagram. Can someone explain the car stealing or car sealing situation? Was it Melly in the rear drivers, Bortlen in the rear passenger, and the two victims in front? So, Bridget, can you clear that up for TT by 3?
Okay, so that's an interesting question. She's asking if who was all located in the vehicle and where they were. So I guess I would say we would go back to what the camera shows. And I mean, I think that's the clearest indicator of where everyone was. You had where Melly was in the back of the vehicle, and the forensics team is stating that is where the initial shots came from the back of the vehicle. And that's why they are putting this murder on Melly, because they are saying that the initial shot came from the back seat of the vehicle that was from where Melly was sitting at.
Yeah, so they are saying Melly was in the back driver's side, and then one victim up front, another victim next to him. So that's why kind of what they're saying here in this case. Our next question, Terry Austin. At user NQH1 or High 1 from YouTube, why doesn't the state seem to have solid evidence so far? Seems a reach to convict a man on such small evidence. So this is somebody who doesn't believe that the case is very strong. What do you have to say about that?
Well, this is a circumstantial case, and sometimes it's very difficult to prove a circumstantial case. You don't have a witness who can say, I was there, I saw exactly what happened. So to that extent, it is a weak case. But if they do it correctly, they can put forensics in. I mentioned this before, but they need to make sure they have the phone data. They need to make sure that they have any sort of cameras that might have been outside to view the cars. They need to get the information from the cars to see where the cars went. And so I think if they put all of that forensic data together and they do it well and they analyze it, they can pinpoint what exactly happened. You know, as far as the car, we do have the video of the individuals getting into the car. And what the prosecution is claiming is, yes, you're right. We have Melly in the back, and he's in the back behind the driver. We have Christopher Thomas, who's in the back on the passenger side. And we have Anthony, he is in the front on the passenger side. And they have Henry as the driver. So that is what the prosecution is claiming. And they're going to have to prove that with the forensic evidence that they have. And so far, that's what they're putting in. And I think it's really, I wouldn't say it's a weak case. I would say it's a difficult case.
And it's a very interesting case. It's got a lot of people watching and paying attention. We are going to take a quick break. Keep the questions coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll be right back. I'm Anjanette Levy, and you're watching Law and Crime. welcome back, and thanks for being with us on the lunch hour during the trial of YNW Melly. We've got a lot of great questions coming in, and we are answering them for you, so let's get right back to it. Aziella from YouTube, Bridget asks, why aren't they doing anything about Melly having multiple personality disorder? I don't know if he's been diagnosed with that, Bridget, but I know that he has said prior to all of this happening in interviews that he's got Melly and Melvin, and then he said in another interview I saw that he's got like 3 or 4, maybe 5 personalities.
Right. And so I don't know if that's something that has been brought up to the court, that he has a mental illness or has multiple personality disorder in any shape, form, or fashion. And if that should be taken into consideration if he could stand trial or anything of that nature. And so I don't know if that's something that's going to be brought in by the prosecution. If so, they should have notified the defense if they were going to be doing that by now. So I don't think that that's something that's going to be coming up.
Mm-hmm. Linda Kenny-Bodden, Minx TV from YouTube asks, will the same evidence be used against the co-defendant, Bortlen?
Absolutely. There's a lot of evidence that goes to Bortlen also. That's where the shooting took place, according to the prosecution. The fact that where they found the cartridge underneath the front seat of the car. So much of this is actually going to be the exact same people testifying. Maybe the prosecution will shorten some of them, such as the examiner, the firearms examiner, who talked about how firearms have patterns and all to the nth degree, so much that the defense took advantage of it in cross-examination by giving and telling the jury they all had certificates now. But you will see much of the same evidence.
Terry, Tiara Williams from YouTube asks, did they do a psychological evaluation on Melly?
You know, to my knowledge, the answer to that is no. I don't think that there was any issue of competency. And actually what that means is that he's going to be able to assist with his defense. And there hasn't been any issue as far as that's concerned. There were no examinations. And, you know, we just talked about this, you know, multiple personalities. Again, there hasn't been any medical evidence put into trial, certainly. And I agree with Linda, I don't expect that we'll see that because we haven't had any witnesses on the list that would talk about any medical evidence. So far, nothing has come into trial to that effect, and I think we're just going to see him continuing, and, you know, he's competent, he's mentally sufficient to try the case and to be involved, and I think that's all we're going to see at this point.
Yeah, most definitely. I mean, it could be a totally different story, though, Linda, just really quickly. If he is convicted and they go on to the penalty phase, I mean, there could be some psychological information that comes in for mitigation, right?
Absolutely. When you get a death penalty case, you actually start with mitigation as a defense attorney. You find out everything about your client from pre-birth, before he was born. What was his life in utero like, as we saw with the Parkland shooter? So they will go into every single thing that he's had, every single psychological issue, and they will probably have somebody then diagnose him, or may have already had someone diagnose him, but haven't revealed it to the prosecution because they don't need to right now because there is no conviction.
Bridget, Nikki Burns from Twitter asks, do legal teams typically get feedback from their leadership on how the trial is coming across? That's the first part of the question. Second part is, and what types of strategy adjustments are allowed in the course of the proceedings?
Well, yes, I would say I was a former prosecutor. When I was a prosecutor, we definitely had some of the higher up prosecutors and the actual district attorney who would sometimes come down and even watch the trial while we were in the process of the trial. And then they would give their feedback and in an effort to improve the prosecution and give feedback on what questions should be asked of witnesses, if witnesses should go out of order of what was already planned. And so she would definitely be able to get some feedback from other prosecutors that are in the district attorney's office. And so she can use that to her advantage as she sees fit.
Terry, this is from Julie Mart26 on Instagram. She asks, what is the strongest evidence they have that he was involved?
Oh, Julie, that's a great question. I think that video of them coming out of the music studio and getting into the car and placing him in the back seat, so far, I think that's the strongest evidence against Melly. I do think that because this is a circumstantial case, they're going to have to piece it together because they don't have much else. I think, frankly, they do have more evidence against Henry. He was the one who went into the hospital. He was the one who told the initial lies, at least according to the defense attorney. And so I think they have a stronger case against Henry, frankly, than they do against Melly, but we'll see how it pans out. They don't have any hard evidence. They don't have any witnesses. They actually just have the cell phone data so far. We might see additional data that places him at the scene of the crime, but right now we haven't seen all the evidence, and right now I don't think it's the strongest case.
Interesting. We'll have to wait until it's all been said and done, until the case is over, at least the state's case in chief. And then we move on to the defense case, of course, if they decide to put one on, which we believe they will. Crystal W. from YouTube. Should the prosecutor be fired for her actions and violations? Linda Kenny-Bodden.
Prosecutors seldom get fired for actions in violation. Even when they have caused wrongful convictions, we seldom see any punishment meted out to prosecutors, although that may be changing a bit. But if indeed there is a discovery violation, the best practices for any office would be to redo the teaching that you have about what should be turned over. And usually in a big office, there is a Brady unit that says and reviews everything if it's even questionable about whether it should be turned over. So maybe the whole office has to look to see whether or not they're doing things properly if the basic discovery violation that was made by her has been made by others in the office.
Bridget, next question is from Lies Never Told 247 from Instagram. Why didn't Miss Holmes' daughter testify? That is Mariah Hamilton, the former girlfriend of Melly.
Well, I would say the only person who would know the reason why she didn't testify would be the prosecutor in this particular case. And so maybe the prosecutor doesn't think that the girlfriend's testifying would be helpful to their case at this time. And so bringing up Ms. Holmes would be more helpful to their case in chief here. And so the prosecutor has the decision and has the power to decide on what witnesses she brings up. And so she just probably didn't think that it was helpful for her in this case, and maybe that Ms. Holmes was more helpful and laying out what was needed here.
Trap Man NYP from Instagram, Terry. Is he ever going to take the stand? What do you think? Do you think Melly's going to get up there and testify?
I don't think Melly is going to need to get up on that stand and testify, at least based on the evidence we've seen thus far. If the prosecution is putting on a case, and if right now it's not beyond a reasonable doubt, and I think there is a ton of doubt, much less reasonable doubt, in the jury's mind at this point with the evidence that's gone in, he will not take the stand. There is a lot of risk when a defendant gets on that stand. They have to be cross-examined. They could really talk about information that contradicts with other information that they've previously provided. And if you don't need to get up on that stand, obviously they have a right not to testify, and the jury cannot use that against the defendant, and the charges will be talking about that. The judge is actually going to make sure the jury's instructed to that effect. So if you don't have to, don't put the defendant on the stand. And in this case, based on what we've seen thus far, things could change. I doubt very seriously if Melly will get on that stand.
Well, Terry, I'm sorry to cut you off. We got to go to break. I'll be signing off. Linda Kenny-Bodden will be taking over. We'll be right back.
Good afternoon and welcome back to the Law and Crime Network. I'm Linda Kenny Bodden. Our coverage continues in that Broward County courtroom for the trial of Jamell Demons, better known as YNW Melly. This 24-year-old rapper is charged with two counts of first-degree murder for the deaths of Christopher Thomas Jr., also known as YNW Juvy, and Anthony Williams, also known as YNW Sakchaser. All were a part of the YNW collaborative, along with the co-defendant Cortlen Henry, who will be tried separately. Right now, the court is on their lunch break and should be returning soon. But I want you to take a listen to some of the testimony that happened earlier of Special Agent Brendan Collins, who's with the FBI. His cross-examination is expected to begin once they return on lunch, but he was under direct examination all morning. So why don't we take a listen to the prosecution's case?
Going on to this next slide here, what are you illustrating in this particular map?
So this shows the green dots are T-Mobile towers in the South Florida area at the time of 2018, at the time relevant to this analysis or case. And the takeaways there are just there. You see in densely populated areas, there's a much higher concentration of towers, right? Because there's more people who have more devices, so there's more demand on network resources. So the providers need to have more towers with smaller coverage areas to provide service to those devices. When you get to more rural areas where there's fewer people, fewer devices, the networks will usually have fewer towers that will have bigger coverage areas. So.
Okay. Is this map fairly and accurately depict the towers that were in South Florida in October of 2018?
Yes.
So going on to the phone of the 772-713-9807, what are we looking at this slide titled 3:47 a.m.?
So this is a plot of timing advance data, and it shows that two data points basically from the engineering report. The tower 64337, sector 2, that's pointed south, recorded the red phone had two data points, one at 3:47:13 a.m., one at 3:47:24 a.m. And the measurement that was that phone at those times was 0.24 miles from the tower.
So you said it's two different times, but it's the same measurement. How do you explain that to the ladies and gentlemen of the jury?
That's just what the records recorded.
Okay. And in terms of by having two data points, are they going to be in the same exact spot?
Well, I mean, it could be or it could not be. So the 0.24 miles from the tower is this red arc here. And I guess your question is the phone in the same spot or not? I don't know. Those are two data points close in time. They're separated by 11 seconds, so the phone certainly could be stationary. The phone could also be moving. For instance, at one point it could be here, and at the other point it could be there. There are both possibilities, and you can't determine from this data.
And in terms of you don't have any cameras if it's stuck at a red light or anything like that?
I don't.
Okay. Was other physical evidence provided for you to review?
I don't think I saw physical evidence, no.
Okay. So going on to the next slide, the 772-713-9807 and 954-248-9081. If you can explain what we're looking at on this particular slide.
So this is a series of data points on three different towers for both the red and blue phone between 417 and 423. We're starting back on the left side of the slide, where 417.43, the blue phone, is 1.21 miles from this tower. Shortly after that, at 4:18:02 a.m., the red phone is 0.87 miles from the tower. Shortly after that, 4:20:50 a.m., the blue phone is 1.02 miles from this tower. Then after that, at 4:23:22 and 4:23:55 a.m., The red phone is 0.29 miles, and then 0.68 miles from this tower.
Okay, and in terms of what can you tell about how the phones are related in distance from one another based on this slide?
Distance from one another. Well, both phones moved north and then east. We know that the blue phone and the red phone are both over here, and now they're over here in the period.
Can you have an opinion as to whether or not they separated during this time frame?
During this time frame?
Yes, 417 to 423.
I don't know. To me, I don't think there's enough data here to form.
Okay. Now going on to the 772-713-9807 between 12:01 and 12:12 p.m. on October 26, 2018. What are you illustrating with this particular image?
So at 12:01, first there's an incoming call from the turquoise phone 9158, and then at 12:01, the red phone is this band, 0.92 miles from the tower. At 12:03, it's 0.68 miles from the tower. At 12:05, it's 0.92 miles from the tower. And then 12:07 to 12:12, it's 1.55 miles from the tower.
Okay, and just to flip back again to the 12:01 to 12:12 for the 954-376-9158. In terms of, can you make any opinions as to where these two phones were located in relation to one another during these time frames?
So they're in the same general geographic area for sure. Right? They're both on the same tower at the same time, near Pines and US 27. There's areas where there's times when their bands are approximately the same, and there's times where they're different as well.
Okay. Can you make any sort of opinion that they were in the same vehicle?
No.
Going on to the 772-713-9807 phone from October 26, 2018, from 12:14 p.m. to 12:21 p.m. What data are you illustrating in this particular slide?
So the first data point, 12:14:47, is this band here. It's 1.02 miles from this tower. The next one, 12:16:28, is this band here, 0.92 miles from the tower. Then continuing on in time, at 12:18:08 p.m., the red phone's in this band, 0.92 miles from the tower. And then at 12:18:28, 0.68 miles from the tower. And then finally at 12:21:17, it's 0.29 miles from this tower.
And in terms of that was the end of the mapping and cellular analysis that you were asked to do in this case?
Yes.
Does being in a parking garage or being at elevation change your analysis of where the phones would be?
Being a part of the garage elevation change? I mean, I don't think so. No.
If there was something that was a red flag in the data, what do you do to catch that?
Well, if I see a red flag for whatever reason, something that doesn't make sense, I'm going to look at it much more closely and try and figure out, okay, what is the issue? Is there an issue?
Was there any such information or issues that in the records that you looked at in this case?
No.
Can you ever say why a phone picks a particular tower or doesn't pick a different one?
Yes. So if we're talking about making a call or sending a text, and then from the call detail records, the phone picks the tower based on its readings of signal strength and signal quality. The phone always picks the tower with the clearest strongest signal. If we're talking about the engineering data, what the network sees, why the network records the distance measurement from one tower instead of another, no, I don't know why.
Well, as we have in this case, we've been getting an education, this time from an FBI agent in cell towers. And I need to bring my great guest in to discuss it. obviously a host here in all the programs we have on Law and Crime, the great Brian Buckmeyer, also a great criminal defense attorney in his own right, and of course the former president of the New Jersey State Bar Association, another great, trial attorney and criminal defense attorney, Bob Hilla. But Brian, I want to start with you. How does this testimony advance the prosecution to a guilty verdict beyond a reasonable doubt, or is it more beneficial for the defense being exploitative?
So I think it's more beneficial, and thank you for that amazing welcome to Linda. I think it's more beneficial for the defense, but let me walk through why I think that is. This testimony for the prosecution is giving the jury a general idea as to where these two cell phones were. I'm assuming at some point they're going to say the red cell phone, we believe, was YNW Melly, and the blue cell phone was one of the other three people in the car. See them traveling together, see them separate. I think that separation and in between them traveling together is going to be where the shooting occurred, because we all know that YNW Melly was not there when Cortlen Henry reported that the shooting occurred. So they can kind of piece together the storyline, generally speaking. But the devil's in the details, and most defense attorneys will come up and say, okay, take this information and show me where the shooting occurred. So far, the prosecution hasn't been able to articulate that. So if the defense can say, well, this general information is great, but it wasn't specific enough for you, the investigation, the prosecution, to give us the ultimate answer that we're all looking for as to where the shooting occurred. Were you able to get video from where that shooting occurred? Did this information further investigation? And if it didn't help the law enforcement get to the right person, then why should the jury be able to use it for beyond a reasonable doubt? That's how I would argue as a defense. So I think at the end of the day, this helps the defense more than it does the prosecution.
And let me now turn to Bob Hilla. Bob, you were talking to me as this was going on, and you were saying, wait a second, is the cell phone in two separate locations? I mean, I could hand you my cell phone accidentally, you could walk out with it, or maybe I have somebody else's cell phone here with me on the set. So tell me, how does this, when you were listening to it, help the prosecution and help the defense, akin to what Brian just told me?
Well, it's a part of the story. I mean, obviously, it needs a lot more of an evidentiary boost to it because it doesn't really tell us anything about how the victims died and who did it, which is what the state has to prove as to this defendant. What it does tell us is that these cell phones were in the general vicinity and when. So to the extent that it's linked, but I'm not so sure it's all that important because you have the surveillance video that shows these people all getting in the car together. You have three of them coming back to the hospital afterwards, two of them who are deceased. So the question is what happened in between. I'm not so sure, unless you have a direct linkage with those phones, that that's really going to help answer that question. But I think the jury wants to know everything that the state found in this case that might be relevant in telling at least bits and pieces of the story. So in that regard, I think they're going to give a lot of tolerance to this part of the trial.
Well, then let me go back to Brian for a quick question here. Brian, so Melly got out of the car. That's what Bob Hilla is saying. He got out of the car before the shooting happened. So how does the prosecution put him back in the car when the shooting happened if he got out of the car before the shooting happened, as his defense will say?
I don't think they can. I don't think there's going to be any information to say that based on us being able to track these two cell phones that we believe belong to, I think, Henry and YNW Melly, that these are them and believe it them. I know they submitted some evidence saying that, hey, look, we took a screenshot of the person using this phone, and in that screenshot you can see YNW Melly in the small box as he's FaceTiming someone. Great evidence, great use of an argument. I get that. But saying that these two phones travel together and then at some point in time they were not traveling together, and the inability to pinpoint exact locations, because what you're really doing is you're pinging off of cell phone towers. You're not triangulating exactly where someone is. You can give a general idea of where they are in that area. So saying that at some point they're close and at another point they're a distance away, it doesn't say where the shooting occurred, when he got out, if he was in the car during the shooting or outside the car during the shooting. It leaves more questions than answers.
And Bob Hilla, let me just talk to you about one final point then on this. So you have Henry, who brings the two decedents to the hospital. But does that mean that he's saying, well, this, please help them? Or is that saying, hey, I'm trying to set up, like, it's not an alibi, but a cover story that I really wasn't the shooter when I was the only one in the car with the two other people and Melly is nowhere to be found?
Well, and Henry's the interesting part of this puzzle because, the jury can still reject this idea of a drive-by and can still acquit the defendant if they believe that the state didn't rule out that Henry didn't shoot these people or that the defendant somehow played some part in that, or even had knowledge that he didn't just take out a gun and shoot these people and then he just split from the scene. So the jury is going to look at everything here, and it could acquit because of the role that Henry had in this, and the unexplained role that maybe he had in it.
And the unexplained role that Henry had. And, Henry, there was a shell casing that they couldn't necessarily match. Found, well, let's see, a lone one in the car under the front seat, and that's where Henry was sitting. So I think that we should all ponder this, because when that jury goes back into that jury room, they're going to be doing the same thing, pondering, and they're going to say, what did I just hear? Even if they can't talk about it, does that help me get closer to the football touchdown the prosecution wants, that it was Melly who was the shooter, or does it just give me a more reasonable doubt? In any event, we're going to take a quick break here at the Law and Crime Network. When we come back, we'll go right back into that courtroom, right back into that testimony that the jury is hearing, and let you assess it, and then we'll talk about it some more. Stay with us. Welcome back to the Law and Crime Network. As you know, I'm Linda Kenny Bodden. We're expecting trial in the YNW Melly case to begin any moment. The jury was taking a lunch. But while we wait, why don't we listen to some testimony from a detective, Jonathan Zeller, with the Miramar Police Department that occurred yesterday in a courtroom. And it's important because the prosecution put him on to try to prove their case beyond a reasonable doubt. We'll talk after you hear it. Listen.
Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work with the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009. So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
What's that? How are you breathing?
Jury entry.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, defendants, his counsel, assistant state attorneys, ladies and gentlemen of the jury, and our witness, Brian Collins, remains on the stand. Ladies and gentlemen, I just had a nice lunch. When we broke, counsel had not yet had an opportunity to commence her cross-examination of this witness, so we're going to turn it over to the defense now. Counsel, if you're ready, you may proceed.
Thank you, Judge. Good afternoon, Agent Collins.
Good afternoon, Ms. Liberty.
Nice to see you in person. The last time we met, I think it was over Zoom.
Yes.
And last time we met, you actually told us you were working for the terrorism squad section of the FBI.
The transnational organized crime.
Okay, and that's where you learned the CAS report stuff as a collateral duty, correct?
No, I started doing CAS as collateral duty when I was a special agent working gangs, part of our state youth gang unit. And then I started doing terrorism investigations as my primary job and continued doing CAS as a collateral duty. Then I did CAS full-time in DC as a supervisor. Then I got promoted to field supervisor, which is my current job, not exclusively.
So you're still supervising organized crime?
Yes.
So do you do any of the CAS work with organized crime?
No.
So do you know, if you know, when's the last time you actually did a CAS report? An actual one for an actual case, when's the last time?
This would be, so I kept all the cases that I had done previously that had been adjudicated.
Okay.
I have not taken new cases since becoming a supervisor.
And just curious, from the last time we spoke, which was about a year ago to now, has anything changed with the technology that we should be aware of? Right. So you had testified earlier talking about timing exams, and you said with T-Mobile they call that true data, correct?
Timing advance is the principle where the network is able to calculate the distance from a tower. T-Mobile has a brand called TrueCall that they use to do that.
And who within T-Mobile would do the TrueCall? Is that engineers? Who would know that information?
I don't know.
So I'm going to put up your report. And looking at this band.
Hold on a second. You want that?
Oh, I do. Sorry.
Thank you, Gary.
All right, so this is your report. And we have this band here that kind of looks like, I know last time you called a hot dog, I like to call it like macaroni. But what does this band represent?
That is the timing advance band. So the engineering report, the true call report from T-Mobile would say the distance from the tower is 0.24 miles. And so then based on the timing advance measurement, which in 4G is 78 meters, that band is 78 meters deep, so it would be plus or minus 39 from 2.4 miles on either side.
So plus or minus, so it's an estimated distance, correct?
Yes.
All right. How does T-Mobile determine? I think you testified earlier that T-Mobile determines the distance by speed times time equals distance, correct?
Yes.
All right. And how fast does that signal travel?
At the speed of light.
All right. And you had testified earlier that the speed of light is a static number, correct?
Yes.
However, I tried to do the math myself because I think I'm really smart. And one of the things that I came across when I was looking at the speed of light was that it could actually be a 3 times 10 to the 8th power meters per second, or the actual number is 2.99792458 times 10 to the 8th power. So if you know, is T-Mobile using the higher number of the 3 or using the actual number with the speed of light?
I don't know.
Okay. But you would agree when we're dealing with the meters per second, that could actually be a big distance, correct?
Yeah, so obviously the bigger the distance or the bigger the time, then the more significant the distance or the difference between those two numbers would be, yes.
And just curious, would that estimate, because we talk a lot about sectors and I'll get further into it, is it possible that that estimate would change what sector you're paying off of?
It's possible estimate would change what sector you're paying off.
Well, let me ask you this,
No.
because if we're dealing with a meter, if we're dealing with a meter, it's 3 feet 3 inches, correct?
Yeah.
And if I'm off by 4 or 5 meters, we're talking about like 15 feet basically, correct? That's a little bit more than 15 feet.
Yeah, so I guess at some point there always has to be a transition from one sector to the other because they have multiple sectors. So on the sector boundary, could that change? I guess, yeah, there's a possibility for that for sure.
Okay. Can you do this calculation yourself?
Which calculation?
The calculation of the speed times time equals distance. Can you do that math yourself?
Yes, I can.
By hand? And would you include timestamps when you did that calculation?
So I didn't do that calculation for this report. I used the distance that was in the engineering records that T-Mobile gave it produced. If they gave me the time, and we could use either 3.0 or 2.99, whatever the other number that you said was for the speed of light. I can do math if that was your question, but for this report I did not do that math to produce these distances.
Okay. So can you tell me about any publication that would tell us about these expected accuracy of the timing advance records?
Nope.
All right. You haven't. So in your map, throughout your map, you talk about these bands and the distance from the tower. Is there any publications or any other data that you have that would explain how accurate that is?
No.
Do you know of any scientific testing outside of the legal community as to this whole cell tower stuff?
I mean, the cellular community, because this is an important part of how cell phones work on a cellular network.
Okay.
But apart from that, no.
Okay. And you show that band as a plus or minus 10 miles, correct? Is that the width of it?
No, it's 78 meters.
All right. And could you break that down? How big would that be? If you were to compare, like, would that be a football field, 2 football fields?
No, it's less than a football field, slightly less than a football field.
So slightly less, like 3/4 of a football field?
Something like that.
And do you have any factual basis that would back that up?
Factual basis for what 78 meters is?
Yeah. No, well, the distance, the approximation of the span. Do you have anything that would back that up?
As to why it's 78 meters?
Yeah.
Because that's what based on how the technology works, based on 4G, that's what the timing advance is. I mean, that's just what it is.
So did T-Mobile tell you this in your training, or how did you figure it out?
Yeah, through my training experience, not T-Mobile specifically, but I mean, that's for regardless of whether it's T-Mobile or Verizon, Sprint, I mean, 4G technology, the timing advance is 78 meters.
All right. So is this an estimate that's being made by T-Mobile?
The distance?
Yeah.
The tower?
Yeah.
Yes. Yeah.
All right. So would you say that this is T-Mobile's best estimate and it's actually no more accurate than the call detailed records themselves?
Well, so I think that in my opinion and experience, generally the timing advance is accurate. The call detail records are accurate. I guess I'm sorry, can you repeat the question?
So I was just asking, is T-Mobile's best estimate on this map correct? Is it any different or any more or less accurate than the call data records, the CDR?
Well, the call detail records will have to be more accurate because they are less precise. So without a doubt, that is the sector that the phone chose. The timing advance measurement, in my experience, is accurate, but there are factors that could make it less accurate than the call detail records. For instance, we just talked about how the difference of whatever 3 100ths in math could make a difference in the calculation of distance. Earlier we talked about how like multipath signal bounces off multiple surfaces on the way to the phone or on the way from the phone back to the tower. That would increase the amount of time that it traveled, which would then also increase the distance. So although I think the timing advance is accurate because it's more precise, there's the potential for it to be less accurate than call detail records.
So do you know of any publications or studies that would back up your opinion?
No.
Okay, so based on that information, you can't really tell the court precisely which locations these phones are following, can you?
No, I mean, one of the limitations of cellular analysis is that you can only say a general area where the device would be at a given time.
All right, so even with the general analysis, all of the stuff that we've gone through for about 4 or 5 hours, at the end of the day, you can never give an exact location.
True.
All right. Can you tell us if a phone is on a highway?
So that depends. For one data point, no, you can't. You just general area where the phone would be. If you have multiple data points, you may be able to infer an opinion as to where you think it is. For instance, like in this case, if you see the device traveling from east to west, the towers along 595, and you have the time between those towers, you could infer what the speed would be and say, okay, I think it's likely that they're on the highway because I know the area, or they're on State Road 84 traveling at a certain speed. But from the cellular data alone, no, you can't tell if the phone's in a car, on the side of the road, on the road.
So can you tell if it's in the woods?
No.
How about another residence located in the area?
No.
And could you tell if somebody was walking around a car with the phone? Would you be able to tell that?
No.
Okay. go back to your report. So it'd be your testimony that this phone, 9807, could be from here to here, correct?
Yes.
And what was the distance from here to here?
Oh, I don't know what the distance is from one end of that illustrated arc to the other.
Okay. Well, can you actually guarantee that the phone is in the arc?
No.
And why can't you guarantee that it's in this arc?
So that arc depicts the time in advance measurement with the time before, including the 78 years time in advance, which is all the resolution you can get. Why I can't guarantee that it's there as well. One, the sectors themselves, the sector itself. So that's an illustration, it's an approximation of the sector, right? Like talked earlier about it being a flashlight to illustrate the direction that the cell signal is going. If anyone drew a flashlight, we draw a cone or something that looks like this. But everyone who's used a flashlight knows that it's not actually like a tube on a paper towel. It's not actually just a tube, right? It's brightest here and it gets weaker and weaker and weaker. So although in this illustration there's hard black arms that say this is the limit of the sector, that's not really the case. There's some bleed openings. So that's the first point, is that it could be, in this instance, potentially over here, potentially over here. Second instance is, as we talked about, if there was something that delayed the signal traveling from the tower to the phone or back, that would make the distance longer than where the phone actually is. So it's a depiction of the records, but with 100% accuracy to say that the phone has to be in this band. No, I can't say that 100%.
Okay. And I did switch the page, so we're looking at your page 12 of your report. And looking at this, can you tell the court if the phone is between these two bands at any given time?
I infer, in my opinion, yes, because it had to have been at some point in time between those two bands, because it was here at 350 or somewhere within this area at 352.58 and somewhere here at 353.48. So to get from here to here, we had to be somewhere between them at some point.
But didn't you tell us earlier that you don't always necessarily connect to the tower closest to you as the one with the best signal? So could it be possible that this is actually the tower with the best signal and the phone is nowhere in that sector?
So this is from the engineering report. And so the engineering report had two measurements for this tower and sector, the 0.58 miles and the 1.16 miles. The engineering report does not, that's the network's perspective. So when I was talking about what they call detail records, where the phone measures the clearest, strongest signal, and then picks the tower or the antenna on the tower that offers the clearest, strongest signal, that's from the call detail records. The engineering reports is the network's perspective.
So where did you get the engineering reports from?
From T-Mobile.
So didn't you previously testify that Detective Moretti gave you these records?
Yes.
So did they come from Moretti or from T-Mobile?
From Detective Moretti.
All right.
From T-Mobile.
And so the engineering report, is it what Ms. Bradley, the state attorney, had put up previously, all these numbers and environments? Is that,
yes.
Okay. Do you double check that report?
What do you mean?
Do you validate it? So you get this report with all these numbers. Do you have a system in place at the FBI that you could cross-references to make sure that the latitude and longitude and the distance is actually what it's saying it is?
No.
So, do you even know if it's credible?
Yeah, outside
the scope.
Overruled. You can answer the question.
So, yeah, the accuracy of this report is pinned on those records being accurate. In my experience, the records that we get from telecommunications providers are accurate, which is why this works.
Well, let me ask you. So, have you ever had an engineer come through on any of your cases, the 130 cases that you had, and have them validate the information that you got from T-Mobile, Sprint, or whatever carrier it is?
So I've had cases where there was a, actually, no, not for me. I know of other cast assets who had cases where there was a red flag or a problem, and then we contacted the engineers and said, hey, there's something that that's not making sense. We need to look more into this. But for me, no.
All right. Do you know of any instances in these records where a mistake or any oddity occurred?
No.
All right. So, and you've already testified you did not request an engineer to assist you to review these records, correct?
Correct.
And you said that one of these bands would be a little less than 100 yards wide?
Yes.
All right. I want to show you this engineering report that you're talking about. Okay. So there's a section on this engineering report that's labeled environment. All right? And it goes on to tell you, and I'm looking for, good thing I didn't do the cell tower analysis, it'd be a mess, so obviously I can't handle this modern technology. But you have a section in here called environment. I just want to find where it's at.
It's to the left.
Yeah, it's so small I can't even see it. But you know what I'm talking about when I talk about environment, correct?
Yes.
Do you rely on this?
No.
Why?
I don't know how it's calculated.
So, and it goes back to my other questioning. This document that's produced from T-Mobile, from their engineer, your engineering report, says that T-Mobile can tell you if a phone is outside, inside. So why do you rely on everything else in this document, but you won't rely on that column?
So I rely on the time in advance, I guess, just because I have, well, I think it really comes down to two things. One, because I understand it, I understand speed of light times time equals the distance. And two, because I've done that and I've been able to validate that through my real world experience. That's why I have confidence in the time in advance. When it comes to the environment and the latitude and longitude coordinates and their associated confidence level, why don't I use that? Well, I didn't use them in this report because I don't know all the factors that go into calculating those. And I don't have real world experience validating those or disproving them to speak to myself personally, whether they would be exact.
You had previously testified that in your training you actually get invited out to different cellular companies, correct?
Yeah.
And did you get invited to T-Mobile?
Never been to T-Mobile.
Okay. Do you know if any of your past people went to T-Mobile?
I don't know.
Okay. Can you tell us how T-Mobile could tell if the phone is indoors?
Don't know.
Have you ever performed any testing to determine if a phone is indoors or outdoors based on the time in advance records from T-Mobile?
No.
And is there any way for you to verify that environment column? The environment estimate from T-Mobile?
Yeah, I mean, if we wanted to test it, we could coordinate something with T-Mobile, or I'm sure T-Mobile could test it, where they would use test phones and do things that people do with phones, calls, texts, data. They would look at the phones of the record and say, like, okay, here's our control group, and here's what the data said, and here's where the phones actually were. So is there a way to do it? I'm sure that.
We were kind of just talking about a hypothetical, because
Right.
as far as you know, it's never happened. Right. Okay. So with the true call distance estimates, has T-Mobile ever shared the calculation with you or possibly other members of the task team?
The calculation is the speed 3.0 or 2.997, whatever times the time. That's the calculation.
So have they shared that with you guys? Have you gone through to find out what exact number is, how they're coming up with these formulas, anything like that?
Yeah, and that's that calculation for time in advance. Again, that's not unique to T-Mobile. That's how all phones have to function on cellular networks. They have to have time in advance measurements of. And so we'll talk about multipliers and.
So it's just T-Mobile gives it to you. You have 100% trust in T-Mobile and its records, so you just get them and you go off of that, correct?
I plot the data from T-Mobile and do an analysis. I don't take anything for given as I'm doing my analysis.
But you don't know if the numbers are correct because you don't have an engineer validating or rechecking anything, do you? So you're
I'm relying on the accuracy of the records, yes.
All right. So basically, you're telling us that we're to trust an undisclosed calculation as being accurate.
Argument.
Right. And do you not have any of the measurements for the underlying true call data?
I don't think so. I mean, I don't know. There's a lot of columns on this engineering report. It's possible that something is buried there, but I don't think so.
Okay. Go back to your report. So in this report, you say that the measurements of phone number.
Just like on the phone.
I'll move it up here. So your report says, you can come over the stage if you want to help me.
Of course.
That these two phones, 9807 and 9081, are in the area of the crime scene, correct?
Does it say consistent with, or what's the?
Your language is cellular measurements are consistent with, yes, the two phones being in the area of the crime scene.
Yes.
All right. But is it not true that they could also be over here?
Yes.
And could 9807 be over here and 9081 be over here?
Yes.
Could it be over here?
I don't think so. Yes. Yes.
And right here.
Yes.
And again, this is an estimate because it could just be pinging to the tower with the best signal, correct?
No. Because this is from the engineering report.
Okay. So, page 14 of your report, you say that phone number 9807 is within this area, correct?
Yes.
But would you agree it's not actually touching any of the points of interest?
At that time?
Yes.
Yes. If you find points of interest, if you mean the locations that were highlighted earlier in the presentation, then yes, it's not overlapping the Montessori Academy or any other place at that time.
Okay, let's turn to page 16 of your report. So does this show phone number ending in 9081 near the hospital?
Yes, that's consistent with the phone being at the hospital.
But this science is not actually precise enough to pinpoint the location of the phone, correct?
Correct.
So while you say it's consistent with it being at the hospital, you actually don't know that, do you?
From the cellular data alone, no.
Go to 17. Here you've mapped again the data for 9807. And again, would you agree that this macaroni does not touch any of the points of interest?
Yes.
Can you explain what this means? Can you see that?
340, the text box that you're pointing to?
Yes.
Yes. So that means that there were multiple data points on that tower and sector between 3:43 a.m. and 3:52 a.m.
Okay, so 3:43 to 3:52 a.m., that phone number was pinging off of this tower.
So it's from the engineering reports, and that tower saw the phone multiple times between 3:43 and 3:52.
Okay, so let's go over here, and what's this mean?
The same thing. All these cell sites that are shown are from the protocol measurement data from Sprint's engineering reports, and those towers in that sector and on that tower saw the phone at whatever times indicated.
Do you know the difference from this point to this point?
I'd imagine it's a couple miles.
So from this report, we're showing that there's a couple miles difference, but the phone is pinging over here at 3:49, but according to your report, between 3:43 and 3:52, it's pinging here. And what does this one mean right here?
3:48.
So it's pinging from this tower at 3:48.
That tower saw the phone, yes.
All right, and then down here?
3:50.
So again, back here, between 3:43 to 3:52, it was pinging off of this tower, but at 3:50, it was down here.
No. The phone wasn't down there. It wasn't up here. The phone wasn't in any of those places. That's not what the data says. The data is saying is that these towers at those times saw the phone. This is all from the engineering reports, which means that the towers, these towers that see them, are not necessarily the tower with the very strongest signal. It's not necessarily the serving cell that saw it. If we had distance information at these times, we'd see like a band, just like we did on the T-Mobile record. So for instance, at this one, 3:49, we'd see a distance, whether it's an arc like this or like this, whatever. The distance column on that engineering report for all these data points was blank. We don't have distance. So we know that these towers saw the phone. And we know that they were not necessarily the serving cell. It could have been. Any one of them could have been, but we don't know that. And we don't have any calls on the call detail records to cross-check and say, okay, well, which tower did the phone reach out to and did need to make a call? So we're left to the question then is, well, what's this mean? Because as you were just asking, as we were just talking about, 3:49 falls between 3:43 and 3:52. How could two towers in two completely different areas both see the phone? Well, they both did see the phone at different times because they registered that connection with the phone. So if you ask me what's my opinion, what's that mean? It's like, well, the phone was someplace where all these towers could see it. And I note that this one is pointed generally west, this one's pointed west-southwest, this one's pointed southeast, this is northeast, this is this way. So my conclusion would be that this data, which it's hard to form a conclusion from because I don't have the distance information I want. It's not going to say, okay, the phone is, generally it's in Miramar. We know that, right? It's not in Fort Lauderdale or Miami. It's probably somewhere in the middle of all these towers. So if I'm asked a specific question, like, hey, is this consistent with the phone being in Silver Lakes? I would say yes. Is it consistent with the phone being in McDonald's? Yes. I mean, This is at a...
So it could be anywhere in Miramar, basically.
I don't think it could be anywhere in Miramar. I think it could be anywhere kind of in this map area. I think it's a fair statement.
Okay. At any given time as well, correct? Because I just for the sake of my knowledge, when we look at this item that says 343 to 352, so I know it's hitting that tower throughout that time, right? But it's then also hitting this other tower at the exact same time, and 30 seconds is hitting this other tower. Is that a fair statement?
The network's hitting the phone. The phone isn't in the network, but yes.
Okay, and then how far can a phone go? Is it 1 mile? Could it be between 1 mile and 20 miles? Or could a phone ping off a tower that's 50 miles away? Do you have any background on that?
Yeah, so it depends kind of what you're asking. If you're asking how far away can a phone be from a tower when it makes a call, well, I mean, that depends. If you're asking how far away can a tower see a phone, which is a different thing, because the phone choosing the tower is going to rely on the phone's clear, strong signal, and that also depends. Generally, I see something in the range of like a couple miles, but I've seen in extreme cases many miles that a tower can see a phone.
Okay. So even with this is again based on that.
Yep.
Any area could be in this ping.
To try and make a conclusion about a precise location for a phone on this data is I don't think possible based on this data.
So wouldn't it be more accurate just to show a range of where it could be at rather than trying to do these curves and pinpoint the precision?
What do you mean?
I mean, you would agree with me that there are some unknowns. Even though we're talking about the speed of light static, we don't know what T-Mobile's using. Are they rounding up to the 3, or are they actually keeping the right number, correct?
Well, regardless of what they're giving us a distance, and that's the distance that's plotted. So we plot the distance, applying the records that T-Mobile gave us, not saying, okay, the phone's here in this bubble or something like that. We're saying, hey, this is what the records show.
Well, it seems like you're giving testimony that it's precise, but when we get through the data, how it's used, that it's actually really just an estimate. So is it precise, or is this an estimate that you're giving us?
I guess it's not an estimate like a, hey, just some number that's made up, just a ballpark, hey, I don't know, 10,000 or something like that. Yeah. But if you're asking, I think you're asking about really the accuracy, not the precision, because that number, like if the number is 0.54 miles, that's a precise number, right? That's down to hundredths of a mile. You're asking how accurate is that number? And we'll say, okay, generally that's accurate. And that's why with my testimony, even when I have a precise number like 0.54 miles from a tower, I still say, hey, it's consistent with it being at this location, where it's generally in the area of this apartment complex or something, because the possibility they may not be precisely there.
So based on that map, could it be possible that you had 2 phones registered to the same person on the same carrier being operated by 2 different people who were sitting next to each other? Can those 2 phones ping off different towers?
When you say ping off towers, you mean are you talking about the engineering report?
Yeah, the engineering report.
Could different towers see those phones?
Yeah, so
yes.
We're both sitting in the car here. Yep. Is it possible that it's pinging off to here, and then the other person's phone is pinging here?
Yes.
While they're next to each other?
Yes.
All right. Can you tell if this phone's in somebody's pocket?
No.
Can you tell if it's left on the car seat?
No.
Can you tell who had the phone?
No.
Okay. No further questions?
Counsel, thank you. You ready to redirect?
Yes, Your Honor.
You ready? You may proceed.
So in terms of, I'm going to make sure we're clear and it's very clear for the jury. What's the difference between the engineering report and the call detail report?
So the call detail records show what the phone was doing, like the phone's calls and texts. And they will list a tower and a sector in them. And that's the tower and the sector that the phone identified as the one that offers the clearest, strongest signals. That's the tower that the phone chose to connect to when it needed to make a call or send a text. That's the phone's perspective. The engineering report is a network's perspective, so different towers that may or may not be the serving cell could have seen the phone.
Why is it important to differentiate between those two?
Because, so if I'm plotting doing a report and I plot the phone that was the serving, or the tower that was the serving cell, then I'm showing, okay, wherever the phone was in this coverage area, it's on this is the one, the best tower, the strongest signal point. With the engineering report, like the slide we were just looking at, none of those may have been the best one. So if I'm looking at something that I plotted because of call detail records, I would infer that that's probably the tower that's the closest or the best line of sight. With the engineering data, that may not be the case.
Okay, and so in the one we were just talking about, that was under the 3717895, that phone, correct?
Yes.
Okay. So if you can explain to the ladies and gentlemen of the jury, there's discussion about the accuracy versus the precision of the records. Is this a precise estimate of which towers saw that phone?
Yes.
And how can you say that?
Because it listed, the records listed specific towers that saw the phone at a specific time.
Are you ever going to say, based on the data that you have here, precisely where that phone was?
No.
What conclusions can you draw from this map based on your training and experience?
That the phone is generally somewhere in the area shown on the map. In my opinion, it's likely to be in the center of the map here, because that's where the direction that the antennas on the towers that saw the phone are pointing.
So counsel asked you about the latitude and longitude columns that are on the call records from the engineering report.
Yes.
And so you mentioned that you do not validate these particular records.
Yes.
Could they be accurate?
They certainly could be accurate, yes.
Can you explain as to the ladies and gentlemen of the jury, if you call 911, what does a cell phone provider send out to law enforcement?
At a minimum, I asked us to provide the tower and sector codes.
Oh. And at maximum, what can they provide?
I don't know.
In terms of those coordinates and things of that, is that also collected for the purposes of location for 911 emergency?
Maybe.
Okay. You said that, and counsel asked you a lot about validating your findings, your records, your analysis. When you are doing the training and experience, do you validate the records that are given to you by going out and finding a specific phone in the field?
Yes.
Okay. Would you be able to validate your records with other corroborating information?
Yes.
For example, a video. Would that help validate your records if the phone is seen in the video?
Yes.
If there is video or surveillance footage of locations and the phone is seen in that area, would that validate your information?
Yes.
Is, for example, on the cell phone records that have been placed in the mapping of the 772-713-9807 and going to the 248-9081, 440 to 4:52 a.m. If that phone is found at the Memorial Hospital, would that validate your findings?
Yes.
Is cell phone technology new?
No.
How long has it been around?
Decades.
Okay. The materials and things that you were relying upon, how long have those been used?
A long time. More than a decade.
In terms of the difference between the 2.99 and 3 to the 10th, what types of difference in distance are you looking at when you're making those tiny advance bands?
So that's not a huge number, a huge difference between them. So that would be generally a small difference between the distance estimates there.
Are we talking meters or miles?
Meters.
In terms of the distance, you said it's 39 meters plus or minus each direction from the center of that location.
Yes.
The specific location that's plotted is based on the location of the tower.
Yes.
Is the tower a known quantity?
Yes.
Does the tower move?
No. I mean, it can, but as of the records, no.
With regards to publications and trainings and things of that nature that you rely upon, are you trained in this area?
Yes.
What types of resources and materials are you used during your training with the FBI CAST analysis?
Yeah, so instructors from Florida Institute of Technology who teach cellular theory and network engineering, network engineers from all the major service providers, other related fields, certain like manufacturers, the ecosystem, and then also we have a lot of peer instruction as well.
In terms of if a child is kidnapped in Miami, are they going to call an engineer to find them?
No, they'll probably call the police or the FBI.
Council asked and brought up a lot of things about the distance and the measurements in the records. Is it possible to go through the CDRs or in the instance of the Sprint, or for example, the engineering report on the 9807 phone number and highlight instances of exactly where on your records it corresponds with the records as provided from T-Mobile?
Yeah, we could go through line by line and say, here's the map that I made, here's how the corresponding line in the T-Mobile report counts.
And in terms of the records and things that were sent to you, were they forwarded with a T-Mobile email address attached to them?
Yeah, I got them on a thumb drive, and they had a certification from T-Mobile or Sprint or whatever.
In terms of, there's a lot of discussion, I want to make sure it's clear for the ladies and gentlemen of the jury, when you were plotting some of these particular phones, specifically the Sprint ones, are you saying that these towers are the ones that would have been used if they were making a phone call?
No.
What are you saying?
These towers saw the phone.
Can you give any more indication on the direction or anything on that specific issue?
On the direction, you can see the side of the tower that saw the phone, but that's it.
Has this type of analysis been used to solve crimes?
Yes.
Has it been used to locate missing persons?
Yes.
Judge, I'm going to object because this line of question is outside of my cross-examination.
Overruled.
In terms of the data that you rely on, has it been validated in your personal experience and training?
Yes.
Nothing further, Your Honor.
This witness excused.
Yes, Your Honor.
Thank you, sir. You may step down. Excuse me. Counsel, want to call your next witness?
Yes, Kurt Rhodes.
Good afternoon. Are you Kurt Rhodes?
Yes.
Welcome. Come on up. This is our witness stand here. When you get there, you can put your things down, remain standing, and raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Kurt Rhodes.
Please spell your first and last name for the court recording.
KURTRHODES.
Thank you so much.
Please have a seat. Mr. Rhodes, that microphone in front of you will adjust up or down, but it does not move back and forth, all right? Are you ready to proceed, sir?
Yes.
Counsel, you may.
Thank you. Good afternoon, Mr. Rhodes. How are you today?
I'm well. How are you?
Very well. Thank you for asking. Could you please introduce yourselves, ladies and gentlemen of the jury, and tell them where you work?
My name is Kurt Rhodes. I am a DNA analyst. I work in the BSO crime laboratory as a DNA analyst.
And what are the qualifications to be an analyst in the BSO crime lab for DNA?
I have a Bachelor's of Science degree in forensic science from the University of Central Florida. I have completed the Sheriff's Office training program for DNA analysts. I hold certification from the ABC for American Board of Criminalistics and Molecular Biology. And I am required to complete at least 8 hours of continuing education per year.
And so how long have you been employed for the Sheriff's Office?
I began in 2004 as a DNA technician. I went into DNA training in 2005 and began DNA casework in 2007.
Can you explain to the ladies and gentlemen of the jury what's the difference between a DNA technician, like you were in 2005, and when you transitioned to 2004, and transitioned to 2005 to be the DNA trainee?
As a technician, I would do instrument maintenance, quality control checks on the chemicals and reagents, do ordering, record keeping, case coordination.
So you briefly mentioned a little bit of your educational background. What types of coursework and classes did you take when you were getting your initial degree in the sciences?
The program that I did through the UCF was the DNA-based program for forensic science. So there was genetics, molecular biology, biochemistry. There was a statistics course, mainly the coursework towards the end of the degree requirements were mainly geared towards genetics and biochemistry and molecular biology.
So do you have specialized training using statistics to interpret DNA?
I have completed the statistics in my college coursework, and I have attended courses throughout my career in the Sheriff's Office dealing with statistics and how they relate to DNA case reform.
You mentioned that you're required to do 8 hours of continuing education. Is that on a yearly basis?
Yes, per year.
And approximately how many hours of continuing education have you completed since 2005 when you started your DNA training?
Again, it's at least 8 hours. Some of the courses, use the term loosely, range from 8 hours to 40 hours. So 1 year maybe 8 hours, another year maybe 48 or even 60. It just depends on the year.
So in terms of the DNA section that you work for, what does it do on a day-to-day basis?
As a DNA analyst, I examine evidence that's submitted by investigators in attempts to develop DNA profiles from question samples and ultimately compare them to known standards to see if the individual that is being investigated or even the alleged victim would be included or excluded from the evidence that's submitted.
In terms of the DNA analysis, do you do that yourself, hands-on?
I do.
And the training that you started to talk about, you said you started training in 2005. Could you talk and explain to the ladies and gentlemen of the jury what that training entails?
It entailed readings, hands-on processing of the samples that we did at the time, extraction methods, quantitations. There was written tests as well as a mock court. Then there was it ended with a competency test to ensure that I was able to process samples appropriately and and then I was allowed to do supervised casework, and then finally independent casework.
So let's explain to ladies and gentlemen, what is a competency test?
A competency test is given to an analyst after they have completed a training program for whatever subject. It could be as simple as an extraction method or maybe a quantitation method. So the laboratory would then provide a test that the analyst would conduct. They would process this test and return the results to the agency to see if the results that they've gotten were appropriate for what was doing.
And do you have to pass these competency tests or examinations before moving on to the next steps?
The competency tests are done to ensure that you are competent in the technology that is going to be employed in casework.
So once you pass that initial testing, is there additional yearly or biannual proficiency testing done?
As a DNA analyst, I am required to do 2 proficiency tests per year. In my laboratory, the agency will purchase proficiency tests from a provider. I process them, generate my results, my answers, and those are then sent back to the provider to ensure that I'm getting the correct answers.
Are those done in-house in terms of the scoring and completion of that proficiency testing twice a year?
I process it in-house, it's reviewed, and then it's sent back to the test provider.
Does the proficiency test require and include statistical interpretations?
They do.
And has the statistical interpretations changed as the way they've been doing in the field of DNA over the last couple of years?
In my laboratory, yes. It went from statistical calculation with known as random match probabilities, single source samples, and CPIs, which were combined probability of inclusion. We've transitioned from those 2 methods to a likelihood ratio method.
And can you explain, in as simple of terms as possible, what is a likelihood ratio?
A likelihood ratio is a comparison of 2 hypotheses. Hypothesis 1 compared against hypothesis 2. In terms of casework analysis, the initial hypothesis is that a person is included as a contributor to a sample, and the competing hypothesis is that the evidence or the DNA profile is coming from an unrelated unknown individual. So that is how the likelihood ratio is set up. Person 1 or person of interest is the contributor to the evidence versus it's coming from an unknown, unrelated individual.
Okay. So I want to go back, and so can you describe to the ladies and gentlemen of the jury, when you're doing a DNA analysis, what is it that you're looking for?
For the analysis that I'm doing, I am processing for STRs, or short tandem repeats. These are small fragments of DNA that are located in our DNA genome. They repeat a certain number of times. When I first began DNA casework, I was processing 15 STRs plus the allege or sex-determining marker, and now the technology has gone to 24 STRs.
So when you say short tandem repeat or STRs, do they code for something like eye color or hair color?
These are non-coding fragments of DNA.
Why is it important to look at those areas as opposed to eye color?
The locations that we're testing, or that I'm testing for, the locations that I'm processing, they're robust. They're polymorphic, meaning that there are differences. There's not just 1 or 2 variations. There could be 10 to 12 different variations, and they are independent from each other, meaning that the result that I get at location 1 will not affect the result that I would get at location 2, or the DNA profile at location 1 isn't affected by the DNA profile of location 2.
Is that a genetic marker? Is that what you're talking about?
Yes.
Okay. And just so it's clear, can you define exactly what a genetic marker is from the DNA analyst perspective?
As it relates to what I do, it is the STO, the shorthand. That is the specific DNA fragment or DNA marker that I'm processing and testing for.
Can you explain what an allele is?
The allele is the genetic trait or characteristic. In terms of STRs, as I mentioned, they're short fragments of DNA that repeat. So they're measured in numbers. At location, I'm just going to say location 1, an allele or characteristic of gene may be a 7, or an 8, or a 9, or an 11. So a DNA profile that I generate is actually just a series of numbers based off of the alleles or traits that I obtain at each DNA location.
You said they're identified by numbers. What does that mean? Could you explain like where the numbers, what do you say? Is it 274? Is it 11?
As I mentioned, the 7, 8, or 9, that refers to the number of repeats. So with the STRs, it's a repeated fragment of DNA, ATCG, and that ATCG may repeat a certain number of times. It may repeat 7 times, or 8 times, or 9 times. And so that is what those numbers that I'm expressing represent.
And where does that repeat? How does that show up in a person's individual DNA?
It is located on the DNA chromosome.
And what determines what makes up an individual's DNA chromosome?
In the case of humans, our DNA is inherited from our parents. We receive half of our DNA from our mother and half from our father. And with the exception of identical twins, no two individuals are going to share the exact same DNA.
In terms of your casework and the DNA process that you do, has that been validated?
Yes.
Is the Broward Sheriff's Office Crime Lab accredited?
It is.
And by what outside accredited body?
We're accredited by ANAB, or the ANSI National Accreditation Board.
What's the purpose of maintaining an accreditation as a lab?
The accreditation is a voluntary process. The accrediting board will do an audit on our laboratory. It will check our SOPs, or standard operating procedures, to ensure that we are doing proper record keeping, we are following the procedures that we have in place, and that the laboratory is essentially running as it is supposed to be according to the SOPs.
And in terms of the specific areas in which the lab is accredited for, are you only talking on DNA?
It's accredited in 4 different sections: DNA, firearms, chemistry, and fingerprints.
Have you worked in any of those other sections?
I have not.
In terms of the proficiency testing that we talked about earlier, is that also part of the accreditation process?
Yes. Everything that is done in the laboratory will be audited through the accrediting body.
And is there also accreditation and validation in terms of statistics that are used?
Again, it's part of the audits.
You mentioned that you used to do 15 areas plus allege, and now you're at 24 areas. Can you explain what made that change occur?
The DNA analysis is a science, and as the years go on, the science advances. So the companies that provide these commercial kits are able to make combinations of these STRs in a bigger multiplex, that's what it's identified as, to analyze more DNA locations all at once in order to provide a better picture compared to years prior when it may have only been 9 locations.
With regards to the locations, does the software take into account the frequency or the amount of number of times a particular repeat is found in a population?
I'm not sure of your question.
And previously, when you were doing random population, random maps, or CPI, is it important to know how frequently a specific allele was shown up in a population of individuals?
Yes. At the end of the analysis, if I am, let me start over again. After I look at the evidentiary samples, I'll determine if it's a single source profile or a mixture, and then do a comparison to a known standard. If I am going to report that the known standard is included as a contributor, I am required to give a weight to this. And in order to give a weight to this match or inclusion, I am required to provide a statistical calculation. So years prior, as I mentioned, it was RMP or CPI. We've gone to likelihood now. But all of those different calculations or those statistics are based on allele frequencies. And what that means is those STR markers that I mentioned before occur in the population at different frequencies. So I mentioned allele 8 may occur at a frequency of 25% of the population has it. And allele 7 may occur at 15%. So when I do a statistical calculation with all of the alleles present in the DNA profile compared to the standard, all of those frequencies are used to calculate the end result, whether it's an LR, a CPI, or an RMP.
So when you change your method, you're still using a lot of the same and building on the same items that you've used in the past?
Yes, that's right.
Has the likelihood ratio, LR, been validated for statistical analysis?
Yes, it is.
Can you tell the ladies and gentlemen of the jury about how in the lab you prevent any sort of cross-contamination?
When I process evidence, I am processing one case at a time, and when I refer to that, screening evidence. So the initial step is to look at the evidence that I am receiving from our central evidence supply to ensure that the seals were intact. I'll do an inventory of the evidence compared to the submission form and property receipts. Typically, the items are packaged all together in kind of like a big brown bag. I'll open that bag up and do an inventory. And then again, process one evidentiary sample at a time while leaving the other samples in a drawer or a cabinet.
What do you do in between each sample to your workstation?
And the workstation is cleaned with bleach and alcohol. As I'm doing my screening, I do wear a lab coat, gloves. I work in what's called a dead air box, a big plexiglass box about the size of this bench here. And I do all my processing on the bench. I'll clean that up after I'm done with the evidence, change my gloves, and then move on to the next piece of evidence. When the next step would be extraction, which would be after I've taken my sample and my cutting of this evidence, I place it into a tube and try and elute out or purify any DNA present that's on that sample. At that point, I'm working little test tubes. So I would again be changing gloves, wearing a lab coat, a mask, and I would only be working with one sample at a time, or only open it one sample at a time to avoid sample contamination.
In terms of, you mentioned the test tubes, are those sealed?
Yes.
So you talked about how you get evidence and it's brought to you. Does the lab assign a specific case number at the lab to track all items of evidence and samples?
Yes. When the investigator brings the evidence to the evidence window or the central receiving, there's a property receipt in the submission form that's brought in and accepted by the evidence intake unit, and it is given a laboratory number.
When you receive evidence, you mentioned you check the seals. Why do you do that?
I check the seals. It's an indication if the evidence has been tampered with. There is a chain of custody form with property receipt, and it lists who had custody of the evidence, and then from history from which person to which person it's transferred to.
And where is the evidence stored before you go and retrieve it?
For the most times, it is stored in the evidence vault. There's some cases where the evidence intake unit keeps it up front in their area, in the safe. But the majority of times, they have an evidence vault in which I go to retrieve the evidence.
So we've talked a lot about DNA and kind of the process leading up to that. What about serology? Is that a part of your job as well?
Serology is one of the first steps that I do when screening the evidence. With each case that's submitted, there's an evidence submission form. It gives me an idea of the type of evidence that I'm going to be processing. Sexual assaults. Years prior, I would screen for semen, looking for sperm cells. Maybe the case has indications of blood, at which point I would do presumptive testing for blood. Items of evidence are submitted where the investigator is just looking for what's essentially called contact DNA, where an individual had come into contact with maybe an item left at the scene. There's no real serology to do on that one, but I would just take cuttings of the samples.
So, Mr. Rhodes, I want to make sure it's clear. Is it your job to go out and collect DNA evidence?
No, I do not do any of the collection. The evidence is submitted and I retrieve it from the evidence form.
Do you give any advice on where to collect evidence from?
I do not.
Have you ever been in any training in crime scene or evidence collection?
I have.
In terms of your employment at the sheriff's office, have you ever worked outside of the forensic DNA section?
I have not.
How many times approximately have you done the DNA analysis process we're going to talk about?
I was processing about 100 cases per year. I would say roughly 2 to 3 samples per case, so maybe 200-300 samples per year for a good 10 years. So thousands of samples in processing.
And in that time, have you had the opportunity to testify in court?
I've testified in Broward County about 40 times and in the federal district 3 times.
Here, offer to defense for law matter?
No need. No objection.
Proceed, counsel.
Okay, so I want to start with, in this particular case, did you do DNA analysis?
I didn't.
Could you please describe for the ladies and gentlemen of the jury the step-by-step process you go through? You started talking a little bit about extraction. You could pick up there and continue.
So again, the first step would be a screening of the evidence to collect my samples, which I would then put in 2 small, essentially test tubes, little microcentrifuge tubes. I would add reagents or chemicals to the tube in order to elute out any potential DNA that's present on the sample and to purify any DNA that may be present in that cutting.
Should we approach for just one moment?
Yes. Discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in the presence of person or research, just leave your note page on your shirt. Thank you. Thank you. Let the record reflect the jury step down. Counsel remain along with the defendant or witness remains on the stand. Is everything all right?
Yeah, we just need a moment.
Okay. You need a restroom break, Mr. Demons? Yes? Can we arrange that for Mr. Demons, please?
Yes, sir.
All right, we'll be in recess. Thank you.
Thank you. If I could tell the witness why we're taking a break. They were being loud.
We're in recess.
I objected. They're telling you.
What is that?
I said no.
Oh, I thought you.
No, I said no.
Welcome back to the Law and Crime Network. YNW Melly, the prosecution says he's a double murderer. His trial is going on right now, and on the stand for the prosecution is a DNA analyst. His name is Kurt Rhodes. Let's go into court and listen.
Last couple of years. In my laboratory, yes. It went from statistical calculation with known as random match probabilities, single source samples, and CPIs, which were combined probability of inclusion. We've transitioned from those two methods to a likelihood ratio method.
And can you explain, in as simple of terms as possible, what is a likelihood ratio?
A likelihood ratio is a comparison of two hypotheses. Hypothesis 1 compared against hypothesis 2. In terms of casework analysis, the initial hypothesis is that a person is included as a contributor to a sample, and the competing hypothesis is that the evidence or the DNA profile is coming from an unrelated unknown individual. So that is how the likelihood ratio is set up. Person 1 or person of interest is the contributor to the evidence versus it's coming from an unknown, unrelated individual.
Okay. So I want to go back, and so can you describe to the ladies and gentlemen of the jury, when you're doing a DNA analysis, what is it that you're looking for?
For the analysis that I'm doing, I am processing for STRs, or short tandem repeats. These are small fragments of DNA that are located in our DNA genome. They repeat a certain number of times. When I first began DNA casework, I was processing 15 STRs plus the allege or sex determining marker, and now the technology has gone to 24 STRs.
So when you say short tandem repeat or STRs, do they code for something like eye color or hair color?
These are non-coding fragments of DNA.
Why is it important to look at those areas as opposed to eye color?
The locations that we're testing, or that I'm testing for, the locations that I'm processing, they're robust. They're polymorphic, meaning that there are differences. There's not just 1 or 2 variations. There could be 10 to 12 different variations, and they are independent from each other, meaning that the result that I get at location 1 will not affect the result that I would get at location 2, or the DNA profile at location 1 isn't affected by the DNA profile of location 2.
Is that a genetic marker? Is that what you're talking about?
Yes.
Okay. And just so it's clear, can you define exactly what a genetic marker is from the DNA analyst perspective?
As it relates to what I do, it is the STL, or the short tandem. That is the specific DNA fragment or DNA marker that I'm processing or testing for.
Can you explain what an allele is?
The allele is the genetic trait or characteristic. In terms of STRs, as I mentioned, they're short fragments of DNA that repeat. So they're measured in numbers at location. I'm just going to say location 1. An allele or characteristic of gene may be a 7, or an 8, or a 9, or an 11. So a DNA profile that I generate is actually just a series of numbers based off of the alleles or traits that I obtain at each DNA location.
You said they're identified by numbers. What does that mean? Could you explain like where the numbers, what do you say? Is it 274? Is it 11?
As I mentioned, the 7, 8, or 9, that refers to the number of repeats. So with the STRs, it's a repeated fragment of DNA, ATCG, and that ATCG may repeat a certain number of times. It may repeat 7 times, or 8 times, or 9 times. And so that is what those numbers that I'm expressing represent.
And where does that repeat? How does that show up in a person's individual DNA?
It is located on the DNA chromosome.
And what determines what makes up an individual's DNA chromosome?
In the case of humans, our DNA is inherited from our parents. We receive half of our DNA from our mother and half from our father. And with the exception of identical twins, no two individuals are going to share the exact same DNA.
In terms of your casework and the DNA process that you do, has that been validated?
Yes.
Is the Broward Sheriff's Office Crime Lab accredited?
It is.
And by what outside accredited body?
We're accredited by ANAB, for the ANSI National Accreditation Board.
What's the purpose of maintaining an accreditation as a lab?
The accreditation is a voluntary process. The accrediting board will do an audit on our laboratory. It will check our SOPs, or standard operating procedures, to ensure that we are doing proper record keeping, we are following the procedures that we have in place, and that's the laboratory is essentially running as it is supposed to be according to the SOPs.
And in terms of the specific areas in which the lab is accredited for, are you only talking on DNA?
It's accredited in 4 different sections: DNA, firearms, chemistry, and fingerprints.
Have you worked in any of those other sections?
I have not.
In terms of the proficiency testing that we talked about earlier, is that also part of the accreditation process?
Yes, everything that is done in the laboratory will be audited through the accrediting body.
And is there also accreditation and validation in terms of statistics that are used?
Again, it's part of the audits.
You mentioned that you used to do 15 areas plus allege, and now you're at 24 areas. Can you explain what made that change occur?
The DNA analysis is a science, and as the years go on, the science advances. So the companies that provide these commercial kits are able to make combinations of these STRs in a bigger multiplex. That's what it's identified as.
Prosecution hasn't gotten to the substance of the DNA yet. That gives us time to take a quick break here at the Law and Crime Network. Stay tuned. On the other side, YNW Melly and our own Terry Austin, who has been in that courtroom today. Stay with us.
this is just an example of interference for demonstrative purposes.
Could you like make some jokes while you're up there?
You ready?
One in a row. First one.
While we're waiting, I want to say that the BSO officers that are in this courtroom have been very cooperative and helpful, and I thank them all, except for Gary, of course.
Call the guy with the AC.
Again, Gary, over here, we think you're awesome.
Thank you. That side of the table. This side, nah. Huh? I don't blame you.
His counsel and the assistant state attorneys, the jury's still in the jury room. I understand, counsel, I overheard you said you're going to use a demonstrative.
Yes, sir. I showed it to defense counsel already.
And I have no objection.
Thank you.
And you'll give that instruction on demonstrative evidence, right?
Yes, sir.
Thank you. Jury entering.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the jury, the defendants, his counsel, the assistant state attorney, the witness remains on stand, and when we broke, I think counsel, you're going to be able to continue with your direct examination. Is that correct?
Correct, Your Honor. So,
you may proceed.
thank you, Mr. Rhodes. Okay, we talked about, you discussed what is extraction. Next, so is that, did you complete your discussion of what is the extraction step for DNA?
I'm not sure. Extraction is when I'm trying to elute out and purify any potential DNA present in the samplings or cuttings that I've taken from the evidence. The next step would be quantitation, and that would be to determine how much DNA present, if any, is in the DNA extract, to then target a specific optimized amount of DNA for the amplification. Amplification is where I'm now going to be targeting those STRs, or those short tandem repeats, through a process called PCR, or polymerase chain reaction, in order to make a detectable amount of DNA from that DNA extract, so that I could then go on to the last step of instrumentation, which is the detection phase using capillary electrophoresis.
So I want to go back and we talked about the PCRs, the polymerase chain reaction. Does that change the underlying DNA sample in any way?
It does not. It's simply there to make a amount of DNA that can be detectable on an instrument.
And why do you do that?
That is the basis for the DNA typing that I do.
And the PCR typing that you're talking about, how long has that been used?
That's been for several decades. It's used in mass disaster identifications, paternity testing, in the medical field.
How long has the process of DNA analysis and identification been used?
Again, it's been decades. STRs came around in the 90s, the middle to late 90s. So for 30 plus years, PCR has been employed.
Again, it's been a little while since high school biology. Can you explain how DNA comes to be in an individual person?
As I mentioned, you receive half from your mother, half from your father. The woman has the egg, and the man has the spermatozoa. Each of those cells has half from each parent, and it combines to form the child.
So, is it always the first allele in any allele pair always comes from mom, and the second one always comes from dad?
No. So the way that the allele table is organized is the smallest allele or number, comma the biggest allele number. I would only know which allele came from which parent by doing a comparison to the known parents. But there's things called recombination that take place during reproduction. So it's basically just a random sampling of the parents' DNA when those reproductive cells are formed to then make the offspring.
In terms of your DNA analysis, do you take into account siblings?
Siblings do come up from time to time. The best way would be to request a standard for comparison.
With regards to a sibling, or if you thought a sibling was involved, is that something you could tell from the data?
There is significant sharing between siblings. So if an analyst, myself, or any of my coworkers comes across a case where there is the potential that there could be a sibling, that information can be relayed to the investigator.
And I want to talk about, so it's clear, what is a standard when it comes to DNA?
A standard is a sample that's collected from a known individual. As I mentioned early on, the purpose of my analysis is to compare evidentiary or question samples collected at an alleged crime scene to a known standard or to a known person to see if that person is included or excluded as a contributor to any DNA left, again, at the potential scene.
In terms of how you're expressing your conclusion, are you expressing it in terms of it's more likely to be this individual than an unknown, unrelated individual?
Very similar, very close. I issue reports, and the wording is that the evidentiary sample is X times more likely to have originated from the person of interest than if it had originated from an unknown, unrelated individual. And when those samples become mixtures, then it becomes a little bit more wordy. That's the intent of it.
So going into, you talked about the unknowns and the standards. Is that related to you in some form when the evidence is presented to you?
Yes, it has to be.
Why is that important?
It's important so that I know exactly what evidence is questioned and what is the standard. The evidentiary samples are processed separately from the known samples to avoid any sort of contamination.
When you say separately, do you mean separate workstations, separate times? Can you define that for ladies and gentlemen of the jury as to what you do to separate them?
I will process the question samples first, and then I do work in extraction batches. So several cases of question samples will be extracted, amplified, and put on the instrument together. And then I'll work a set of known samples, again, separate from the question samples, at different times and spaces.
Is it separated by days?
Not always, but there are chances, or there are times where it is separated by days, but it's definitely separated by time.
So the last step of the process that you were talking about, the capillary electrophoresis. What is that?
That is the step where I put the amplification product. I take a small portion of the amplification product and inject it onto an instrument. And what that's doing is it applies an electric charge to this little liquid to essentially suck up the DNA that's present from that amplification. And it runs through a little thin, tiny straw, so you have a visual, a capillary. And the DNA fragments are separated by the size, because all of the STRs have to be detectable and they all can't be the same size. So as they migrate through this capillary or little tiny straw, there is a fluorescent tag that is present on each of these DNA fragments. A laser will excite that fluorescent tag, it emits light, and that light is captured. But again, the DNA fragments migrate or travel through that little capillary based on the size. The smaller ones will migrate faster, and the larger ones will migrate slower.
Is this captured in some sort of a chart or diagram that's then presented?
The samples are collected, and then they're analyzed through a program, and then I do have printouts. They're called electropharograms.
So with Your Honor's permission for a demonstrative as to what an electropharogram looks like.
Okay, is there any objection?
No objection.
All right, again, ladies and gentlemen, the witness will be using a demonstrative to assist in explaining or illustrating his testimony. Please remember that the testimony of the witness is the evidence. However, the demonstrative is not to be considered by you as evidence in the case unless it's later received in evidence, and it should not be used as a substitute for evidence. Only items of evidence received will be available to you for consideration during your deliberations. So at this time, this is not in evidence, it's demonstrative.
Mr. Rhodes, may I? Mr. Rhodes, can you explain kind of what this chart is?
So this is an electropharogram. This is one of the pages. They're typically on 2 or 3 pages based on whether it's a single source or a mixture profile. As you see across the top, there's some red boxes. And
So I'm going to zoom in a little bit so it's easier to see.
There's these red boxes, and then you'll see a bunch of letters and numbers. To the left, you'll see D8S1179. That is one location that I am testing for. It's on the 8th chromosome. I would call it D8 for short. And as you go across to the right, you'll see D21 for short, D18 for short. And these are the locations, or these are the specific STRs that I'm analyzing.
In terms of you said it's a D8, is that the address of where this STR is located?
That's essentially what that is. It's the location on the chromosome, the 8th chromosome, and then the S1179 gives a more specific location on where it's located.
Can you describe that like in terms of a house address? If the address is 123 Main Street of a house, how would that correspond that to what you're looking at here?
The best I can do is, again, it's on D8, would mean that's DNA on the 8th chromosome, and the S1179 gives a more specific location on that chromosome. Again, we have 23 chromosomes, so there are multiple chromosomes.
And do you test and sequence every single marker on every single chromosome when you're doing DNA analysis?
No, it is only the select set of STRs that is used for each specific commercial kit. And in this particular kit, I use what's called Global Filer.
And what is Global Filer?
This specific DNA kit used for these STRs.
And how many specific locations are you testing for in Global Filer?
There are 24.
So in terms of the specific evidence that you did in this case, I want to kind of just go in order with your reports, if that's okay. The items that were submitted to you and processed on that. I'm going to start with the lab number items 16 and 17. If you need to refer to your report.
Yes.
Okay, so items 16 and 17. Was there a description attached to those items?
There was.
And where do you get the description from?
The description comes from the property receipt as well as the evidence packaging.
If there is a discrepancy between the property receipt and the evidence packaging, do you note that?
Yes.
So starting with 16 and 17, what description were you given as to where that swab originated?
These are oral swabs coming from Cortlen Henry. Item 16 is the right side, and item 17 is the left side.
Do you test both of them?
I did not. I tested one.
Why don't you test both of them?
It's a buccal swab or oral swab coming from the same individual. There's not going to be a difference in DNA based off the left side of his cheek or the right side of his cheek.
So when you test item 16, can you explain to ladies and gentlemen and the jury how you go through that process?
It is, again, what I mentioned before. I would screen it, do an extraction, quantify it, do an amplification, and then develop the DNA profile and use it as a DNA standard for Mr. Henry.
Moving on to item number 18. Did you test in that particular item, develop a DNA profile?
I did.
And the DNA profile assigned to item number 18 was what?
It is a DNA spot card from Christopher Thomas.
And in terms of what is a DNA spot card?
It's a blood thin collection card taken from the medical examiner.
And as to item number 19, the next item, did you test and develop a DNA standard or profile from item 19?
I did.
And what was that?
It was a DNA spot card from Mr. Anthony Williams.
Going forward to item number 20, what was that?
It was identified as swab from water bottle, PM number 18.
Do you know where that water bottle was?
I do not.
Did you do the DNA analysis on that particular item?
I did, yes.
And can you explain what conclusions you drew on that item?
The DNA profile obtained from item number 20 was uninterpretable due to insufficient data.
Can you explain to the ladies and gentlemen of the jury what does it mean with insufficient data?
After I do the analysis of any DNA product, after I run it through calculated electrophoresis and look at the electrophoregram, I look at the data and I have to determine, is there enough data to determine the number of contributors? Is this a single source profile? Is this a two-person profile? Or a two-person mixture? Is it a three-person? After looking at the results, I deemed that there wasn't enough information to even determine how many number of contributors were in the profile. So I deemed it insufficient or uninterpretable.
So does that mean there wasn't DNA there?
It means that there was DNA, but I was unable to make any sort of comparison.
You mentioned that you have to determine the number of contributors. What would help you determine the number of contributors to a DNA item?
The number of contributors, it's based off of the DNA results. One of the things that I look at is the number of alleles that are present. As I mentioned, we receive half of our DNA from our mother, half from our father. So at a specific location, I would expect to only find a maximum of 2 different alleles per location. So if I'm looking at, let's say, D8, as you had seen, and there was 3 alleles or 3 different peaks present, it's a pretty good indication that it's coming from at least 2 individuals. If I had seen 4 peaks or 4 alleles, maybe 5 alleles, now there's a potential that there's 3 people that could be contributing to this profile. And after I do an overall analysis of the entire electrophoregram, I would then come to a determination of whether it's 2 or 3.
So when you're said overall, do you look at each area or each address that you're looking at individually?
Individually first, and then overall to get the final interpretation.
And is that something you have training and experience in doing?
Yes.
How often do you have to analyze mixtures as part of your DNA casework?
Mixtures usually come up, I would say, at least half of the time in DNA samples that are processed.
So going on to what was labeled for your DNA report as item number 21, what was that listed as?
It's listed as swab from spent casing Blazer 40 S&W PM number 18.
Were you able to get any DNA results from item number 21?
I was not.
Why not?
There wasn't sufficient DNA present in the extract to obtain DNA results on the electrophotogram after I did the amplification.
Okay, going on to item number 22. What was that described as?
Swab from Gucci sandals, PM number 19.
On number 22, were you able to determine the contributors on that particular swab?
That result was interpreted as a mixture originating from 3 contributors.
And were you able to identify the 3 contributors?
I was not.
In terms of, are you able to say and give a statistic as to each of the 3 individuals that you identified on item 22 as to their likelihood of being a contributor to that mixture?
Yes. So every sample that is deemed to be conclusive or whether interpretable single source mixture, I would then do a comparison to any known samples submitted. So each of the 3 individuals were compared against this mixture.
And were you able to determine whether or not you can give support to Christopher Thomas being included in that mixture?
Yes, the DNA results are 4,730 times more likely if they originated from Christopher Thomas and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals. And this provides moderate support that Christopher Thomas is included as a contributor.
So this is the first time, ladies and gentlemen of the jury, have heard moderate support. Can you explain what the verbal qualifiers are that you're going to be testifying and using to describe the DNA results?
Yes. The likelihood ratio can go from really small numbers. The resulting likelihood ratio number can go from really small to really large. So I will have a verbal qualifier listed on the report, and it goes from limited support, moderate support, strong support, and very strong support. And this tries to give a scale to the number that you're hearing.
And so the numbers that you're going to be talking about are exponential sometimes.
That's correct.
If it's the opposite direction, if it's an exclusion, what type of number, what type of words would you be using?
If it's an exclusion, which is really, there's a chance that there's a small likelihood for exclusion, and at that point it would be limited support for exclusion, or it would just be a straight exclusion with no verbal qualifier.
So going back to item 22, you said moderate support as to Christopher Thomas.
That's correct.
Okay. And did you also analyze that with regards to the individual that was identified as Anthony Williams?
I did, yes.
And so what was the likelihood ratio that Anthony Williams was a contributor to the DNA found on those samples?
The DNA results are at least 3.07 times 10 to the 25th, or 30.7 septillion. Times more likely if they originated from Anthony Williams and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
With regards to the individual that was identified as Cortlen Henry, what conclusions were you able to draw with regards to him and that DNA sample?
He was excluded as a contributor.
So you said 30.7 septillion. How many zeros is that?
There are 25 zeros after the 3.
Why is it that you don't say it's Anthony Williams, Chris Thomas, and some unknown individual?
Sometimes that is reported if it's requested. The likelihood ratio that I'm reporting out now is done on an individual basis. So I would conduct or calculate the likelihood ratio of the first individual, report the number, do a likelihood calculation of the second individual, report the number, and if it's requested, an additional calculation can be done and reported in which both individuals would be included in the mixture.
So I want to make sure it's clear. You're looking at each contributor individually?
Yes.
And that is because it's the hypothesis is either however many times more likely that they are versus that they are not included.
Could you say that again?
You're making me do math. So with regards to the likelihood ratio, the first hypothesis is the number that you come out with, or the number you're reporting. If it is the 30.7 septillion times more likely that they are included, that's the first hypothesis, that they are there and they are a contributor. The second hypothesis is that they are not. So you're saying that it is 30.7 septillion times more likely they are a contributor than they are not, than they are excluded.
Sort of. I would explain it as, again, these likelihood ratios are, it's a calculation that's going against two competing hypotheses. So there is more support that Mr. Williams, in this case, would be included along with two other unknown, unrelated individuals than if the DNA results were coming from three unknown individuals.
Okay. And so for item 22, the swab from the Gucci sandals you had testified Cortlen Henry was excluded.
That's correct.
Okay. Moving on to item number 23. What was that?
It's listed as a cutting blood stain on front of T-shirt. Drew, I'm not sure how to say this, Drew Filmedit CG10.
Okay, going on to item number 23, the cutting from the front of the T-shirt. What were your results on that?
The DNA results were interpreted as a mixture originating from two contributors.
Okay.
After doing the comparisons to each individual, the DNA results are at least 982 times more likely if they originated from Christopher Thomas and one unrelated unknown individual than if they originated from two unrelated individuals. And this provides moderate support that Mr. Thomas is included as a contributor.
And then with regards to Anthony Williams.
The DNA results are 3.22 times 10 to the 25th, or 32.2 septillion. Times more likely if they originated from Mr. Williams and one unrelated unknown individual than if they originated from two unrelated individuals. And this provides very strong support that Mr. Williams is included as a contributor.
982 and 32.2 septillion. That's a big difference.
Yes, and that's, again, one of the reasons that the verbal qualifier is put into the report.
In terms of identifying and making a conclusion based on that, is there anything that you take into account as to the amount of DNA that's in it?
The DNA mixtures that are analyzed at the laboratory that I analyzed, I use a program called StarMix, or STRMix, and this is a program that helps to deconvolute these mixtures. And what deconvolute means is to determine if you have two contributors in the mixture, are you able to tease out or generate essentially who the first contributor would be compared to who the second contributor would be. As the amount of DNA is increased, in these DNA extracts and these amplification products, the result becomes more robust, and you would have a more solid comparison, or an easier comparison, maybe that might be the right word. If you have a full single source DNA profile, it's a lot easier to compare to a standard than if you had a really partial DNA profile. And once you start compounding that into a mixture, if you have essentially two partial DNA profiles mixing into one stain, which would then make this partial two-person mixture, doing comparisons may lead to likelihood ratios that are on the lower side, versus if you had two robust DNA profiles, or two robust DNA sources of DNA making a mixture, and then the likelihood ratios may result in a number that's far larger and more support for the inclusion.
Okay, so I want to make sure it's clear. If you have 1 gallon of blood from one individual and 1 drop of blood from another individual, is that still, you can get out 2 profiles?
There is a potential, yes, but again, it depends on the overall result.
Would that come across in the data that you're looking at?
Absolutely.
And how would that read out in the data?
When I look at a DNA profile, mixture profile, you can see, or oftentimes you can see that there is one contributor that is contributing or providing more genetic material to the mixture versus the second contributor or third contributor. So you'll see differences in the peak heights or the alleles or the characteristics as you go across the electroparagram. And you can, I can look and see, hey, this looks like a 2-person mixture. This one contributor is providing more DNA material than this other contributor.
As to item number 23, can you say which individual contributed more genetic material to that cutting on the front of the t-shirt Drew filmed it?
I cannot specifically say that, but the likelihood ratio would provide the verbal qualifier that there's very strong support that Mr. Williams was included as the issue, or actually the issue.
So going, and then in terms of, did you also analyze that cutting against Cortlen Henry?
I did. Mr. Henry was excluded as a contributor.
So I want to also take a moment here to talk about different types of DNA and serology. Did you do serology on this particular item 23?
I did, yes. I did a presumptive test for the indications of blood, and it was positive.
If there are blood genetic material and epithelial genetic material, does that change your analysis in any way if you know they're commingled?
No.
And why not?
If a stain has potential blood on it, I'm going to take a cutting or a sampling based off of that size of that blood stain, because I can't saturate my DNA extract with all the blood DNA or DNA from the blood stain in hopes that I obtain enough, or there is any second contributor from any potential epithelial cells. And epithelial cells are basically the skin cells on the outside surfaces of your body. So if I were to rub this bench top here, deposit some of my DNA from my skin cells from my hand, and then there's a blood stain that comes up next to it. If the investigator swabs this, essentially this mixture of my DNA plus the blood stain, the blood is going to, for the most part, cover up or provide a majority of that DNA, because the blood is a far richer source of DNA than the skin cells.
Is a person's DNA the same in every cell in their body?
It is.
So going on to now item number 23. What is that described as? I'm sorry, 24. We just finished 23. Item 24. What is that described as?
The cutting blood stain on rear of t-shirts, Drew Film Edit CG10.
Did you do a DNA analysis on item number 24?
I did. It was interpreted as originating from a single male contributor.
And were you able to make a reasonable or a likelihood ratio as to which individual contributed to that bloodstain?
I did the comparisons to the 3 individuals. The DNA results are at least 1.59 times 10 to the 25th, or 15.9 septillion times more likely if they originated from Mr. Thomas, Christopher Thomas, than if they originated from one unrelated, unknown individual.
Were you able
Mr. Henry and Mr. Williams were excluded as contributors.
My next question. So with regards to item number 25, were you able to conduct a DNA analysis of that item?
I did.
What was that item identified to you as?
Swab, bloodstain, G12, Air Jordan, sneaker E.
Were you able to come to a conclusion as to the source of that bloodstain?
I obtained a DNA profile and interpreted it as originating from a single male contributor. Mr. Williams, or all 3 individuals were compared. In comparison to Mr. Anthony Williams, the results are at least 5.3 times 10 to the 25th, or 53 septillion, times more likely if they originated from Anthony Williams than if they originated from one unrelated, unknown individual. Mr. Henry and Mr. Thomas were excluded as contributors.
So I want to move on to the next report that you did. In terms of the crime lab and how it works, when evidence is submitted to the lab, is it submitted in batches from the investigative agencies?
When evidence is submitted, we have a submission policy. So based off of the type of incident that's being investigated, there's essentially a number of items that can be submitted. In the cases of homicides, there are typically 10 to 12 items per testing round, is what we call it. We want the investigators to provide the most probative evidence for their investigation first, and then move on after that. With the cases of maybe a non-suspect burglary case, you may only get 2 evidence items worth.
In terms of limits on homicide cases, is there any limit to the number of items that can be worked?
There's no limit as far as I know. Again, it's worked in series of samples so that 100 or 150 items aren't submitted all at once. Again, to try and have the investigator determine which would be the most probative evidence for the investigation.
And in terms of your role in that process, do you know the underlying facts of the investigation as it's progressing?
Sometimes yes, but mostly no. I'm typically just assigned the case. There may be some communications between the unit supervisor and the investigator as to why more evidence is being submitted, or reasons why the investigator is requesting more evidence.
In front of you, there's a stack of items that have already been admitted into evidence. If I may approach, Your Honor.
Yes.
We've talked about a few already here. Do you recognize the green sticker on this item that's already been admitted as States 58? Please.
Yes.
And how do you recognize that?
On the back, it has my laboratory number, my initials, and all the item numbers as they were submitted to the laboratory.
And do you then assign the individual numbers that we talked about?
Yes, the numbers are assigned based off our record-keeping system. They're a sequential number, so the first item gets number 1, and then sequentially down the line.
Okay. Moving on to what's been placed into evidence as States 53. Again, do you recognize that item?
I do. Again, it has my laboratory number, my initials, and my item numbers marked on it.
What's been previously admitted into evidence as States 33. Do you recognize that item?
I do. Again, it has all my markings on it.
Okay. As to what has been admitted as State 46.
Yes, again, the items are marked and my notations on the evidence.
Okay. And as to item State 32, did you ever get this one?
I don't think so.
So the answer is no.
No, I do not, because my markings are not on here.
Okay. As to what's been admitted as State 26, have you reviewed that item?
Yes, I have.
Is that
I've
okay?
marked it and with my laboratory item numbers and my initials.
So I'm approaching with what's been previously marked as State GG for identification purposes only. Okay, I'm showing you what's been previously marked as State GG for identification purposes only. Do you recognize that item? Please. It is open.
Yes, it has my markings on it, case number, item numbers, initials.
Did you analyze the items inside of that package?
Yes, I did.
Hold on just a moment. So showing defense counsel, it's been marked as State triple T. Correct. Showing you what's been marked as State triple T for identification purposes only. Do you recognize that item?
I do. Again, has my information marked on the outside.
And did you collect that item?
No, I did not collect it.
Is that an item that you analyzed?
Yes.
Okay, and we'll come back to that. Thank you so much. So all of the items that we're looking at here, Mr. Rhodes, are packaged in paper bags.
Or manila envelopes, yes.
Why is that?
The investigators use these types of evidence packaging in case the evidence is wet. It helps to allow air to get through the package to dry it. One of the things that will cause issues, degradation, is essentially having a biological stain remain wet, and mold, mildew, and bacteria will grow on it and potentially destroy any DNA present.
Is it important to keep DNA in a dry environment for preserving it?
Yes.
Is there limits on the temperature range in which the DNA is kept at the evidence vault?
There's no limits. The evidence vaults in the laboratories are around 60 degrees, maybe 65. We do have freezers that we have old cases. So as long as the evidence is kept cool and dry, and the frozen is cool and dry, the DNA will persist for decades.
In terms of if the DNA is heated, would that cause degradation to it?
Yes, heat, moisture, and sunlight are three of the main factors that will cause degradation and essentially destruction of the DNA present.
So why don't they just keep it in plastic bags?
The plastic won't allow any air to get through to the evidence, and it will basically cause condensation if it's moist. If the evidence is moist or wet, which will then lead to the mold, mildew, and bacteria growing.
Can one person's DNA change to become someone else's?
No.
How does it not? Does air bring other DNA into those bags and samples?
No.
So going back now on to item number 26 that you processed. What was that identified as to you?
Swab from Yellow Jacket.
And there's another number that you list in your notes and reports of an 81. Where is that number coming from?
The first number, 26, is the item number that is generated in the laboratory when I am doing inventory in my inventory system. The 81 is the agency number as it's submitted on the prior receipt.
Okay. So going on to Item number 26. Did you analyze the swab of the yellow jacket as it's described?
I did, yes.
And what were your conclusions on that particular item?
The results were interpreted as a mixture originating from 4 contributors.
So were you able to make determinations as to the standards that you had?
I did, yes.
Okay. If we could discuss first with regards to Anthony Williams. What conclusion did you reach and what statistical basis for that?
He was included as a contributor to the mixture in the likelihood calculation. The results are at least 2.05 times 10 to the 8th, or 205 million. Times more likely if these DNA results originated from Anthony Williams and 3 unrelated unknown individuals than if they originated from 4 unrelated unknown individuals.
In terms of a 4-person mixture, do you expect the statistics to be a little bit lower, just based on that?
It depends on, again, when I was speaking of contribution, if a person is more represented in a sample, the statistics or likelihood calculation can be rather large. It just depends on how much contribution is in that mixture.
Were you able to exclude anybody from the swab of the yellow jacket, item 26?
Christopher Thomas and Cortlen Henry were excluded.
In terms of item number 27, how was that I'm sorry. Yes, item number 27. How was that number identified to you?
Swab from Gatorade bottle.
Were you able to analyze that and develop DNA profiles?
I obtained a single source profile indicating male origin.
Were you able to determine the single source origin of that profile?
Christopher Thomas was included. The likelihood calculation is as follows. The DNA results are at least 1.65 times 10 to the 25th, or 16.5 septillion. Times more likely if they originated from Mr. Thomas than if they originated from 1 unrelated unknown individual.
Okay. Going on to item number 28. Did you do the same?
I did.
And what was that listed as?
Swab from Gatorade bottle.
And that swab, who were you able to determine, or what DNA conclusions were you able to make?
The DNA results were interpreted as originated from a single male contributor. Mr. Anthony Williams was included. The likelihood calculation, the DNA results are at least 4.38 times 10 to the 25th, or 43.8 septillion times more likely if they originated from Anthony Williams than if they originated from 1 unrelated unknown individual.
At this point in everything that we have talked about, were you provided a standard for the defendant, Jamell Demons?
No.
So going on to item number 29, were you able to develop a DNA profile on that particular item?
I analyzed the results and deemed it to be uninterpretable due to limited data.
And what was item number 29?
It's listed as swab from bloodstain on rear passenger seat, PM number 1.
And you couldn't say where that was collected from?
I can.
Going on to your next report, we're talking about the MVAC filter. Can you explain to the ladies and gentlemen of the jury what is an MVAC filter?
An MVAC filter is a filter paper where the investigator will essentially soak the surface of whatever they're looking for, maybe a shirt or a shoe or even a door, in a liquid, and they come back and they vacuum it up. And all of that vacuumed up liquid will then go and be deposited on the filter paper. That filter paper is then taken out of the apparatus, dried, and then I will take a portion of that filter paper and try and develop a DNA profile from the surface that they process.
Excuse me, I didn't hear the item number. What's the
It's item number 31 of his report.
Thank you.
So on the MVAC filter, item 31, that you were asked to process in this case, what was your information relayed as to where that MVAC source was?
It's identified as MVAC filter 9 from spent casings found on ground at US 27 and Southwest 208th Avenue.
So we talked a little bit about things that are conducive to DNA. Does sunlight have an effect on it, you said, I believe, right?
Yes, it can.
What does sunlight do to DNA if exposed?
Again, with the heat, light, and moisture, it allows bacteria to grow and to essentially degrade the DNA.
Okay. And when you did an analysis of item number 31, the MVAC filter, what conclusions were you able to draw?
I did an extraction on the piece of evidence, and after quantitation, I determined that there was insufficient amount of extracted DNA to go forward. So I did not attempt to develop a DNA profile, and I stopped processing at that point.
And if you remind ladies and gentlemen of the jury, what does it mean if you stop it at that second step?
The extraction, meaning I would not obtain a DNA profile that could be used for any sort of comparisons. There just isn't enough genetic material in the extract.
What is the information, what are you relying on, and what training and experience to make that conclusion?
It's the quantitation results, the type of sample that I have obtained, or that I analyzed. So I'm not surprised that MVACs from casings yielded very little DNA.
Moving on to your next report, item 32. Was that item provided to you for DNA analysis?
It was, yes.
And that is in evidence, I believe, if I may, as states 46.
Yes.
So if I may, published for the jury.
You may.
So I'm publishing now states 46. What was states 46 reported to you to be?
These are oral swabs or standards from Jamell Demons.
And with regards to item number 32 and 33 in your report, are they the same?
Item number 32 is listed as the right cheek, and 33 is listed as the left cheek.
Similar to we previously talked about, did you just pick one to test?
Correct, I did, just the first one.
Is there any rhyme or reason as to picking the right versus the left?
Nope.
Going on, and so once you got this standard, did you go back and look at the other evidence you previously analyzed?
Yes, so comparisons were made to all the previously analyzed questioned evidence.
So going to item number 22, the swab from the Gucci sandals. Were you able to compare the profile from Mr. Demons as opposed to the profile developed from those sandals?
I did, and he was excluded.
The blood stain on the front of the t-shirt, item number 23, were you able to compare Mr. Demons' profile to that?
I did a comparison, and he was again excluded.
What about item number 24, the cutting on the blood stain of the rear of the t-shirt?
After comparisons were done, he was excluded.
Okay, then on item number 25, the swab of the blood stain from the Air Jordans.
Again, an exclusion.
Going on to item number 26, the swab from the yellow jacket.
An exclusion as well.
And in terms of the item number 27 and 28, the swabs at the Gatorade bottles. What were the results on that?
Those were both exclusions.
So going forward to what's been shown to you but not yet admitted into evidence for identification purposes is states triple T. What was that item told to you to be?
I'm sorry, could you repeat that?
Sure. On your item 34, what's been shown to you for identification purposes only as states triple T. What was that item described to you to be?
It's listed as a cutting of headliner.
And how did you analyze that particular piece of evidence?
That evidence, I had to do a visual examination on it and actually take a cutting of a potential blood stain.
And can you explain to ladies and gentlemen of the jury what's the difference between using it from a swab versus a cutting of an item?
This was a piece of evidence, a headliner. It was the size, maybe a foot squared. There were some small red brown stains on there. So there's oftentimes where the evidence itself is better to be submitted as opposed to moistening a cotton tip swab and then swabbing it, just in case the small blood stain becomes too diffuse on the cotton tip swab. And why that's important is I do my best to preserve evidence for future testing. So if an item of evidence is submitted, I typically process only half of the evidence. If there's only one swab submitted, I'll process half of the swab, leaving half for retesting either in current technologies by another laboratory or save it for future testing when technology has advanced even further. So if there's small potential blood stains, again, it might be beneficial to actually examine the evidence and take a cutting, as I did in this particular case.
Okay, and in terms of were you able to do an analysis and develop a profile on that particular item?
I did. I obtained a DNA profile originating from a single male contributor.
And were you able to identify the source of that single male contributor?
Mr. Anthony Williams was included as a contributor.
And what support can you assign to him being the contributor?
The likelihood ratio calculation, the results are 5.12 times 10 to the 25th, or 51.2 septillion times more likely if it originated from Mr. Williams than if it originated from one unrelated unknown individual.
Did you also do serology on that specific item?
I did. I did presumptive testing for blood, and it was positive.
When you're doing DNA testing on this, will you know without doing serology if something is epithelial or blood?
I would know.
In this case, the serology indicated blood. And which test did you use to determine that?
I used a phenolphthalein test.
And were any individuals excluded from that sample?
Mr. Henry, Mr. Thomas, and Mr. Demons were excluded as contributors.
So moving on to item number 40. We're getting towards the end. With regards to item number 40, was that item submitted and analysis done?
Yes.
Okay. What was item number 40? What steps of the DNA process did you take it through as well?
Item number 40 was extracted for DNA, but after quantitation, there wasn't a sufficient amount of DNA to move forward, so I did not attempt to do any DNA profiling.
And what was item number 40 described as?
A contact swab of non-blood area of rear of driver's seat.
And is this the same discussion we had with regards to the last item? With not enough DNA, so then you stop it at that first step?
Correct, after extraction. Sure, after quantitation.
Why don't you at least try and take it through and go through all the steps?
Oftentimes, the quantitation results in a 0, meaning none was detected. Sometimes it results in a null value, meaning not even less than 0 was obtained. So at that point, I'm pretty confident that I'm not going to obtain a DNA profile.
Do you do a control swab or sample as you're going through the DNA process each time?
The DNA processing has several controls during extraction. I have a reagent blank, and this is just a sample of just the reagents by themselves. The extraction reagents that I use will be processed with the samples to ensure that the reagents are free of contaminants. When I do a amplification for PCR, there will be a positive control and a negative control. The negative control is again just a tube of reagents. There shouldn't be any DNA present at the end. And the positive control is a known DNA standard And so after I do my amplification, the negative control needs to be blank, and the positive control needs to generate, or I need to generate the DNA profile from that positive control.
So let's go back. You mentioned reagents. I don't think we've defined that for the jury here today. What is a reagent?
Reagents are the chemicals that I use for my DNA processing.
Are they standard and part of the kit that you were talking about earlier?
There are different components in the amplification kit, quantitation kit. We have different reagents used for extraction. So at every step there are a set of reagents that we use.
And those are all related to the controls as well?
Correct.
So going back, so once we talked about that, let's talk about item number 41. What was item 41 described to you as?
It's listed as blood swab smear from rear of driver's seat.
Were you able to come to any sort of conclusion as to item 41?
I obtained some results, but I reported that they were uninterpretable due to limited data.
What does that mean?
Meaning I obtained the electrocardiogram stage, I've analyzed the ending result of that PCR amplification and deemed that there wasn't sufficient amount of DNA to make any comparisons.
Okay, so I'm going to move on to item number 66. Did you analyze that particular item? And in terms of what was item number 66?
Item number 66 was initially reported as contact swab of rear of driver's side door handle interior.
Were you able to determine what the packaging of item number 66 said?
Yes, the contact swab of rear of driver's side door handle interior.
I'm sorry, on number 66 is which?
Front of driver's side door handle.
So you can't testify as to which it came from.
I'm not sure of the question.
You didn't collect this item of evidence?
No, I didn't.
Oh. So after reviewing the item analysis, did you amend your report to read contact swab of front driver's side door handle interior?
That's correct.
Okay. So going on to item number 42, which is been labeled as item 66 by the Miramar Police Department. What results did you have?
Again, I obtained a DNA profile, but ruled it or determined it to be uninterpretable due to limited data.
Does uninterpretable mean no DNA?
In this case, no. There was DNA present, but it was insufficient amount to make any sort of determination, number of contributors or even comparisons.
Are you still looking back at those same standards that we've talked about previously?
The interpretation of the question samples is done prior to looking at the interpretation of the knowns.
Why is that?
It's to avoid any sort of bias. I want to make my interpretation calls of those unknowns absent of knowing what the known standards are.
Does the computer do any of this analysis or say, hey, it's person A or person B for you?
No, it does not.
Oh. So moving on to item number 43. Is that the last item you tested in this case?
Yes.
So with regards to what was item number 43 listed as?
Swab, rear driver's side door, handle interior.
Were you able to do DNA testing on that particular item?
I did, yes.
Did you develop a profile?
I did.
And can you explain what DNA profile you developed?
In this particular case, I reported out both a 2-person mixture and a 3-person mixture.
And so explain why you would report out 2 different hypotheses.
When I did the initial interpretation of the question sample of this item 43, there was the appearance of a 2-person mixture. After doing a comparison to known standards, And doing the likelihood calculation, the result was essentially unintuitive. There was a lot of contribution being attributed to an individual, but then resulted in an exclusionary likelihood ratio.
So can you explain what that means in a little bit simpler math terms, if possible?
Yeah, essentially the likelihood ratio resulted in exclusion. So after talking with my technical leader, I determined that we both came to the consensus that it would be best to report out or then interpret it as a 3-person mixture and then report out both results.
So with regards to when you're saying it's an exclusion, is there a certain number of loci that it has to not match for you to report it as an exclusion?
When it comes to likelihood ratios, as I have mentioned before, it's doing it's comparing two hypotheses, essentially that a person is included versus a person, an unrelated unknown individual is included. And it does this at every specific location. So going through all of those locations, there's the potential to have 16, 17, 18 locus-specific likelihoods, likelihood ratios. And at the end of it, those are all multiplied together to get the final result. So if one specific location results in a 0 likelihood ratio, but everything else is inclusionary, it's an indication that there's an issue with how the software was set up. And so as an analyst, I would go back and see what the issue was and then rerun this deconvolution and redo the calculations. In this particular case, after doing a visual comparison of the standards to the mixture and then looking at the resulting likelihood ratios, again, I spoke with the technical leader and we determined that there will be best to report out both.
So I'm going to go starting with the alternative proposition on that. Were you able to exclude anyone in the alternative proposition that you put forth?
Mr. Cortlen Henry was excluded.
With regards to the initial proposition?
Cortlen Henry, Anthony Williams, and Jamell Demons were excluded.
Who was included on the initial proposition?
Christopher Thomas was included.
When you were looking at it as 2 contributors, how did you exclude the defendant in this case, Mr. Demons?
How did I exclude him?
Yes.
So again, after doing the visual comparison and then running it through to generate the likelihood ratio, it resulted in an exclusionary likelihood ratio.
When you looked at it again as a 3-person mixture, were you able to make a determination as to whether or not Christopher Thomas was included as a source of that mixture?
Yeah, he was included as a 3-person as well.
And what were the statistics on the 3-person mixture for Christopher Thomas?
The results are at least 8.15 times 10 to the 24th, or 8.15 septillion times more likely if they originated from Christopher Thomas and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
In terms of as to Cortlen Henry, were you able to do the statistical calculations as to whether or not he was excluded on a 3-person mixture on item number 43, swab of rear driver's side door handle material?
Yes, the results are at most 46, and this is an inverse LR calculation because the number was less than 1. So the DNA results are at most 46 times more likely if it originated from 3 unrelated unknown individuals than if it originated from Cortlen Henry and 2 unrelated unknown individuals.
So is your conclusion that Mr. Henry is excluded from that sample?
Yes.
Okay. Going on to Anthony Williams, were you able to make a conclusion as to whether or not he was included or excluded?
I did. He was included. the LR calculation, the DNA results are at least 41.2 times more likely if they originated from Anthony Williams and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
And in terms of the verbal qualifier that you would give for Mr. Williams being included in that sample, what verbal qualifier would you give?
Limited support for inclusion.
Is that the lowest for inclusion?
Yes.
Okay. I believe I forgot to ask you with Christopher Thomas, what verbal qualifier would you give if he is included on that?
It is the highest at very strong support.
And at last but not least, were you able to analyze the profile of the defendant, Jamell Demons, in this case?
I did, yes.
And what was your conclusion in a 3-person mixture as to the results of Mr. Demons being included or excluded?
He was included. The likelihood calculation, the DNA results are at least 2.12 times 10 to the 8th, or 212 million times more likely if they originated from Jamell Demons and 2 unrelated unknown individuals than if they originated from 3 unrelated unknown individuals.
And what verbal qualifier did you give to that particular item of Mr. Demons being included?
There is very strong support for the inclusion.
Nothing further at this time, Your Honor.
If you're ready, you may proceed. Sure. We'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence. Serving no research. Just leave your notepads on the chair. Now you let the order reflect the jury stepped out. Counsel may no longer defend. Mr. Demons, you need a restroom break?
Yes, sir.
Yes, can you arrange that?
Yes, sir.
Thank you. We're on recess.
Hey, welcome back to Law and Crime. So how does this happen? How do these guys that are working so closely together in the rap industry in South Florida, how does this unfold one night in October of 2018? They're all in a car. Maybe the defendant, Jamell Demons, is in that car. Maybe he's not. But somehow, in the end of the night, 2 of his buddies, Anthony Williams, a.k.a. Sakchaser, and Christopher Thomas Jr., a.k.a. Juvy, they're dead. They're literally taken to the hospital a little after 4 in the morning. They left the studio about 2:17. How did all this unfold and what happened? The prosecution says that Demons did it, period. We haven't heard a great story about motive. We know you don't need one. Maybe there was some money issue, licensing. We've heard a little testimony on that maybe Demons wanted all of that money for himself, so he kind of cut out some of the middlemen. And that's about all we know at this point. So we are in the middle of the prosecution's case, and we are hearing DNA testimony that we expect is going to more clearly link these parties and where they were that night. Remember, there's a question as to who was in the car. Were the shots fired from within the car, or were they, as Demons suggests, the victim of a drive-by that night? So all these questions still up in the air, and the prosecution doing their best to get them answered. Right now, Kurt Rhodes on the stands. He's the DNA dude, and he's trying to help this jury understand what happened that night when these 2 men died. Let's go back into the courtroom.
What is that described as? I'm sorry, 24. We just finished 23. Item 24. What is that described as?
The cutting bloodstain on rear of T-shirt, Drew Phil Bennett, CG10.
did you do a DNA analysis on item number 24?
I did. It was interpreted as originating from a single male contributor.
And were you able to make a reasonable or a likelihood ratio as to which individual contributed to that blood stain?
I did the comparisons to the 3 individuals. The DNA results are at least 1.59 times 10 to the 25th, or 15.9 septillion times more likely if they originated from Mr. Thomas, Christopher Thomas, than if they originated from one unrelated unknown individual.
Were you able to?
Mr. Henry and Mr. Williams were excluded as contributors.
My next question. So with regards to item number 25, were you able to conduct a DNA analysis of that item?
I did.
What was that item identified to you as?
Swab, bloodstain, G12, Air Jordan, sneaker E.
Were you able to come to a conclusion as to the source of that bloodstain?
I obtained a DNA profile and interpreted as originating from a single male contributor. Mr. Williams, where all 3 individuals were compared, in comparison to Mr. Anthony Williams. The results are at least 5.3 times 10 to the 25th, or 53 septillion, times more likely if they originated from Anthony Williams than if they originated from one unrelated unknown individual. Mr. Henry and Mr. Thomas were excluded as contributors.
So I want to move on to the next report that you did. In terms of the crime lab and how it works, when evidence is submitted to the lab, is it submitted in batches from the investigative agencies?
When evidence is submitted, we have a submission policy. So based off of the type of incident that's being investigated, there's essentially a number of items that can be submitted. In the cases of homicides, there are typically 10 to 12 items per testing round, is what we call it. We want the investigators to provide the most probative value, the most probative evidence for their investigation first, and then move on after that. With the cases of maybe a non-suspect burglary case, you may only get 2 evidence items worth.
In terms of limits on homicide cases, is there any limit to the number of items that can be worked?
There's no limit as far as I know. Again, it's worked in a series of samples so that 100 or 150 items aren't submitted all at once. Again, to try and have the investigator determine which would be the most probative evidence for the investigation.
And in terms of your role in that process, do you know the underlying facts of the investigation as it's progressing?
Sometimes yes, but mostly no. I'm typically just assigned the case. There may be some communications between the unit supervisor and the investigator as to why more evidence is being submitted or reasons why the investigator is requesting more evidence.
Okay. In front of you, there's a stack of items that have already been admitted into evidence. If I may approach on it.
Yes.
We've talked about a few already here. Do you recognize the green sticker on this item that's already been admitted as State 58? Please.
Yes.
And how do you recognize that?
On the back, it has my laboratory number, my initials, and all the item numbers as they were submitted to the laboratory.
And do you then assign the individual numbers that we talked about?
Yes, the numbers are assigned based off our record-keeping system. They're a sequential number, so the first item gets number 1, and then sequentially down the line.
Okay. Moving on to what's been placed into evidence as State 53. Again, do you recognize that item?
I do. Again, it has my laboratory number, my initials, and my item numbers marked on it.
what's been previously admitted into evidence as State 33? Do you recognize that item?
I do. Again, it has all my markings on it.
Okay. As to what has been admitted as State 46?
Yes, again, the items are marked and my limitations on the evidence.
Okay. And as to item States 32, did you ever get this one?
I don't think so.
So the answer is no.
No, I do not, because my markings are not on here.
Okay. As to what's been admitted as State 26, have you reviewed that item?
Yes, I have.
Is that
I've marked it and put my laboratory item numbers and my initials.
So I'm approaching with what's been previously marked as State GG for identification purposes only. Okay, I'm showing you what's been previously marked as State GG for identification purposes only. Do you recognize that item? Please. It is open.
Yes, it has my markings on it, case number, item numbers, initials.
Did you analyze the items inside of that package?
Yes, I did.
Okay. Hold on just a moment. So showing defense counsel, it's been marked as State triple T. Correct. Showing you what's been marked as State triple T for identification purposes only. Do you recognize that item?
I do. It again has my information marked on the outside.
And did you collect that item?
No, I did not collect it.
Is that an item that you analyzed?
Yes.
Okay, and we'll come back to that. Thank you so much. So all of the items that we're looking at here, Mr. Rose, are packaged in paper bags.
Or manila envelopes, please.
Why is that?
The investigators use these types of evidence packaging in case the evidence is wet. It helps to allow air to get through the package to dry it. One of the things that will cause issues, degradation, is essentially having a biological stain remain wet, and mold, mildew, and bacteria will grow on it and potentially destroy any DNA that's present.
Is it important to keep DNA in a dry environment for preserving it?
Yes.
Is there limits on the temperature range in which the DNA is kept at the evidence vault?
There's no limits. The evidence vaults in laboratories are about 60 degrees, maybe 65. We do have freezers that we have old cases. So as long as the evidence is kept cool and dry, and being frozen is cool and dry, the DNA will persist for decades.
In terms of if the DNA is heated, would that cause degradation to it?
Yes. Heat, moisture, and sunlight are three of the main factors that will cause degradation and essentially destruction of the DNA present.
So why don't they just keep it in plastic bags?
The plastic won't allow any air to get through to the evidence, and it will basically cause condensation if it's moist. If the evidence is moist or wet, which will then lead to the mold, mildew, and bacteria growing.
Can one person's DNA change to become someone else's?
No.
How does it not? Does air bring other DNA into those bags and samples?
No.
So going back now on to item number 26 that you processed. What was that identified as to you?
Swab from Yellow Jacket.
And there's another number that you list in your notes and reports of an 81. Where is that number coming from?
The first number, 26, is the item number that is generated in the laboratory when I am doing inventory in my inventory system. The 81 is the agency number as it's submitted on the prior receipt.
So going on to item number 26, did you analyze the swab of the yellow jacket as it's described?
I did, yes.
And what were your conclusions on that particular item?
The results were interpreted as a mixture originating from 4 contributors.
So were you able to make determinations as to
Jury entry.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, evidence, his counsel, and assistant state attorneys. So, ladies and gentlemen, the jury, witness remains on the stand. Counsel, this is your opportunity for cross-examination. If you're ready, you may proceed.
Thank you, Your Honor. I'm going to say good evening to you.
Yes, good
I feel like it's nighttime today. By any chance, do you know George Bellow?
He is the unit supervisor for the firearms section.
Yeah. He gave us an education on firearms, and you've now given us an education on DNA. So he said he would give us some type of certificate. So I expect you also to get some type of certificate on DNA. But in any event, when did you perform your first DNA testing? The date, please.
May I refer to my notes?
Absolutely. Feel free at any time.
My initial examination of the first evidence was on January 23 of 2019.
2019.
Correct.
And that's when you analyzed or examined various items that came out of a grade G. That was water bottle, some sneakers, I think, a yellow jacket, a Gatorade bottle, item 27, I think you identified.
For this particular date, it was items 16 through 25.
16 through 25, okay. On 123 of 19, you examined a water bottle, a spent casing, Gucci sandals, and a blood stain on front of a t-shirt and a blood stain on the rear of the t-shirt. And also a blood stain on an Air Jordan sneaker, correct?
That's correct.
That turned out not to come back to this young man right over here, correct? Mr. Demons. I'm going to call him Jamell. It's easier. Okay. Is that correct?
At this time or later?
Later.
Later. May I refer to my report?
Absolutely. And give us a date that you did that,
Absolutely.
please.
So on January 25th of 2022 is when the comparisons were made to Mr. Demons, and he was excluded from all those items.
That was January of what?
The report was issued on January 25th of 2022.
I'm sorry.
I did my analysis on January 24th, the day before.
Okay. That was approximately 3 years after he was arrested. Did you know that?
I did not.
Then you analyzed, did you not, item 26, a yellow jacket, a Gatorade bottle, correct?
Yes, that's right.
And what date did you examine those items?
That was on August 24th of 2021.
August 24th, you said?
Correct.
Of 21. That was 2 years approximately after he was arrested. Did you know that?
I did not.
And those came from inside the Jeep. Did you know that?
I did not.
And those did not match Jamell, correct?
That's correct. He was excluded.
Then you received some additional items, correct?
Yes, that's correct.
What was the date that you received the additional items?
They were received on multiple days.
Okay, give us the first date you received additional items, please.
I began processing the impact filter on January 5th of 2022.
That was approximately 3 years after his arrest.
The cutting of the headliner, which is item 34.
When did you receive that?
I began processing on January 28th of 2022.
Okay. Also about 3 years after his arrest.
Objection, counsel's testifying.
I thought it was a question. Restate it. Restate your question.
Did you know it was approximately 3 years after he was arrested?
I did not. Additional items were submitted. These were items 40, 41, and 42. Those were processed on April 25th of 2023.
April 25th of 23?
That's correct.
Did you know that was after we started this
Objection,
trial?
Your Honor, improper.
Excuse me. Watch from sidewalk.
Sir, did you know that when you received the blood stain on the headliner, that was after this trial started?
I did not know.
But you started that in April 25th of 23? Just 2 months ago?
The headliner was, that was prior.
Oh, I'm sorry. The item that you received on April of 23 was what?
Those were the contact swab, non-blood area, rear driver seat, the blood swab of smear from rear of driver seat, and the contact swab of front driver side door handle interior.
Okay. And you did not know that was after this trial started, correct?
I did not know.
And none of that came back to the DNA of this young man, Jamell, correct?
Correct. It was deemed uninterpretable, as well as one of the items I did not attempt to generate DNA profile because there was insufficient amount of DNA.
Do you know what the delay was in sending that evidence to you?
Objection, outside the scope, speculation.
And did you receive any other items in 2023?
Yes, one last item, item 43.
And that was the door handle of the rear door? Is that correct?
Correct. Yes.
And did I hear you correctly that you first ran a test and it did not come back matching or belonging to or contributor to Jamell?
That's correct.
And did I also hear you correctly then you discussed something about your software with your supervisor?
With the technical leader, yes.
And then ran another test and had a 3-person contributor?
That's correct. Yes.
And all of a sudden it matched or it was labeled as Jamell may have been a contributor?
That's correct.
What date was that, sir?
That was on June 1st, 2023.
Approximately 3 weeks ago?
That's correct.
Who requested that,
Objection,
if you know?
What's the objection?
speculation, outside the scope.
Well, as far as outside the scope, so if he knows, he can answer.
Who submitted that item to you 3 weeks ago?
It would have been Miramar, the investigators.
Miramar Police Department?
Yes, I can look at my
Feel free.
submission. It was submitted by a Miramar investigator. Mark Moretti.
Moretti.
Who was listed on the submission form.
And that was the only item that supposedly matched Jamell's DNA, correct?
I believe so. I can look back just to confirm it.
Please do.
But I do believe that is an accurate assessment. Yes, there was an item with the inclusionary likelihood issue.
Could you tell these folks when that DNA was placed on, supposedly, on the door handle?
No.
It could have been placed a week.
Objection, speculation.
Sustained.
How long can DNA stay on an item?
The DNA can persist on items. Again, as I mentioned, heat, light, moisture can cause it to degrade or become unusable. But if DNA is deposited on the surface, it can last weeks, months, years, kept in a nice, cool, dry environment.
Did you know this Jeep was stored in police custody in a safe, dry area?
I do not.
May I have one other question? One other moment, excuse me. Thank you very much.
Is there any redirect?
Yes, Your Honor. Mr. Rhodes, is it unusual to receive multiple submissions over the life of a case?
No, it's not unusual.
Does the date in which you work a particular item have any effect on the results you report on?
No, it does not.
As to the likelihood ratio on item number 43, who was included in that particular item?
For both propositions, Mr. Thomas was included for both the two-person and three-person contributor propositions. Under the two-person proposition, Mr. Henry, Mr. Williams, and Mr. Demons were excluded. Under the three-person proposition, Mr. Thomas, Mr. Williams, and Mr. Demons were included.
And with regards to the time of collection of that swab, would that be indicated on the box that it is found in?
Sometimes there are indications on the collection. I can look at the card receipt. It may, I'm not sure if it's a newer one or an older one, but I can look at the card receipt if you'd like.
Okay, and that would be item number 67, what's been put into evidence as states 33. Latex or not?
Yeah, latex.
And so item 33 in evidence, is that item number 67 and you're labeling here?
Yes, that's right.
What was the date and time of collection according to that specific item?
So it's dated at 10/26 of 2018.
And the time?
1736.
Okay. If DNA is stored in an optical environment, will it persist forever?
I'm not sure about forever, but it will persist for decades.
And in terms of if it is collected on a cotton swab that is dry and sterile, is that a ideal place to perpetuate DNA storage?
Yes.
Nothing further.
I have one or two questions based on that, if the court will allow me.
Sure, go ahead, sir.
You indicated it's not unusual to get multiple submissions of evidence.
That's right.
Do you know why it took 5 years to submit that exhibit to you to analyze?
Objection, Your Honor. Speculation.
He knows he can answer, do you know?
I do not.
Thank you.
Counsel, is there anything else to this witness?
No, Your Honor.
Is he excused?
Yes, Your Honor.
Thank you, Ms. Step Counsel. You're excused. Ladies and gentlemen, my understanding is that's all the witnesses we have for today, and so we'll see everybody back tomorrow at 9 a.m. Remember the admonition, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in the presence of certainly no research, just leave your notepads on your chairs. Thank you, ladies and gentlemen. Thank you. Thank you, sir. You're excused. Anything to discuss, counsel?
Yes, Your Honor. We'd like to do a sidebar. My computer screwed up.
Sidebar?
Yes.
And the jury got it.
Are you? Because of the cameras, I think it would be prudent.
That's fine. No, sidebar.
Thank you.
So cross-examination continuing in the Jamell Demons case. It is the DNA expert Kurt Rhodes, and I'm telling you, I'm here with Rich Schoenstein and Anna Yum. In the first 2 minutes of the cross-examination, Anna, I really felt like I learned more than throughout the entire direct examination of this witness. The key points, all of these things he tested were not connected to Melly, and the testing was done 2 to 3 years after he was arrested. Give me your take on that.
Absolutely. Talk about starting off cross-examination with a bang. I mean, there was a big contrast in terms of what the jury saw on direct examination versus what the jury saw on cross-examination. And keep in mind, we've only seen, like you said, a couple of minutes, and already he's starting out with the strongest points, which were everything he talked about, all those items that you talked about, item 26, 27, what have you. Well, it's not connected to my client. And the fact that there was that long duration of the 3-year period before it was tested, these are very wise and very strong points that he's making from the beginning. They always say primacy and recency when it comes to cross-examination. And he is starting off with a bang, and he's starting off strong.
So I'm going to ask you this last question. I know I've got to kick you loose here. At this point in the prosecution's case, you're the prosecutor now. Are you feeling good about your case?
At this point, I'm thinking to myself, maybe there are certain questions I should have asked on direct examination that could have brought the jury back. Again, I'm sure the prosecutor is seasoned. I'm sure the prosecutor knows her case like the back of her hand, and she probably knows that these were weak points for the prosecution. And so it's going to be interesting to see how she ends up doing her redirect examination once the defense attorney is done with cross-examination. I'm sure she's thought of these issues, and it's just a matter of time to see how she's going to address them and how she's going to rehabilitate the witness when it's her turn.
Yeah, and sometimes you know what the weaknesses are, and you get it out there, you deal with it, and you move on as quickly as you can. But certainly the cross is pointing out what appear to be some of those weaknesses. Okay, I'm going to thank and excuse you, Anna Yum. Thank you so much for being here. You were definitely most courteous, so you get to go first. We'll see you next time here on the network. Rich is going to stick around, keep working on that manifesto, Rich. We're going to go back into the courtroom now for more of that cross-examination.
Sir, did you know that when you received the blood stain on the headliner, that was after this trial started?
I did not know.
But you started that in April 25th of 23, just 2 months ago?
The headliner was, that was prior.
Oh, I'm sorry. The item that you received on April of 23 was what?
Those were the contact swab, non-blood area, rear driver's seat, the blood swab of smear from rear of driver's seat, and the contact swab of front driver side door handle interior.
Okay. And you did not know that was after this trial started, correct?
I did not know.
And none of that came back to the DNA of this young man, Jamell, correct?
Correct. It was deemed uninterpretable, as well as one of the items I did not attempt to generate a DNA profile because there was insufficient amount of DNA.
Do you know what the delay was in sending that evidence to you?
Objection, outside the scope, speculation.
And did you receive any other items in 2023?
Yes, one last item, item 43.
And that was the door handle of the rear door? Is that correct?
Correct, yes.
And did I hear you correctly that you first ran a test and it did not come back matching or belonging to or contributor to Jamell?
That's correct.
And did I also hear you correctly then you discussed something about your software with your supervisor?
With the technical leader, yes.
And then ran another test and had a 3-person contributor?
That's correct, yes.
And all of a sudden it matched or it was labeled as Jamell may have been a contributor?
That's correct.
What date was that, sir?
That was on June 1st, 2023.
Approximately 3 weeks ago?
That's correct.
Who requested that,
Objection.
if you know?
What's the objection?
Speculation outside the scope.
As far as outside the scope, so if he knows, he can answer.
Who submitted that item to you 3 weeks ago?
It would have been Miramar, the investigators.
Miramar Police Department?
Yes, I can look at my
Feel
submission.
free.
It was submitted by a Miramar investigator, Mark Moretti.
Moretti.
Who is listed on the submission form.
And that was the only item that supposedly matched Jamell's DNA, correct?
I believe so. I can look back just to confirm it.
Please do.
But I do believe that is an accurate assessment. Yes, there was an item with the inclusionary likelihood.
Could you tell these folks when that DNA was placed on, supposedly, on the door handle?
No.
It could have been placed a week.
Objection. Speculation.
Sustained.
How long can DNA stay on an item?
The DNA can persist on items. Again, as I mentioned, heat, light, moisture can cause it to degrade or become unusable. But if DNA is involved.
Adjourned till tomorrow. When can I expect these?
They are digital. I think they'll probably take until at least Monday. So if you want them in hard copy, they are, I think I'm conservative in saying 400 pages. Now, so it's clear, it's not 400 pages like a deposition transcript. It is 400 pages, and it's going to be more like look like a cell phone. And there might be 5 or 6 messages per page. So while it sounds very voluminous in number, it's not as bad as 400 pages would sound normally.
And this is what you shared with defense counsel.
Yes, they have the copies as well.
Thank you.
Digital.
Thank you.
We're adjourned.
The 3-person proposition, Mr. Thomas, Mr. Williams, and Mr. Demons were included.
And with regards to the time of collection of that swab, would that be indicated on the box that it is found in?
Sometimes there are indications on the collection. I can look at the marker receipt. It may, I'm not sure if it's a newer one or an older one, but I can look at the marker receipt if you'd like.
Okay, and that would be item number 67, what's been put into evidence as states 33. Latest or not?
Yeah, latest.
And so item 33 in evidence, is that item number 67 And you're labeling here?
Yes, that's right.
What was the date and time of collection according to that specific item?
So it's dated at 10/26 of 2018.
And the time?
1736.
Okay. If DNA is stored in an optical environment, will it persist forever?
I'm not sure about forever, but it will persist for a decade.
And in terms of if it is collected on a cotton swab that is dry and sterile, is that a ideal place to perpetuate DNA storage?
Yes.
Nothing further.
I have one or two questions based on that, if the court will allow me.
Sure, go ahead.
You indicated it's not unusual to get multiple submissions of evidence.
That's right.
Do you know why it took 5 years to submit that exhibit to you to analyze?
Objection, Your Honor. Speculation.
He knows he can answer, do you know?
I do not.
Thank you.
Counsel, is there anything else to this witness?
No, Your Honor.
Is he excused?
Yes, Your Honor.
Thank you. You may step down, sir. You're excused. Ladies and gentlemen, my understanding is that's all the witnesses we have today.
Sometimes it's really just the question you need to get out there in front of the jury. Do you know why it took X number of years for you to get this material? Objection, it's speculation. Yeah, the witness probably doesn't know, but now the jury's asking that same question. Rich Schoenstein is here. He's been just writing notes copiously. I didn't even know what that word meant until I saw him doing this. So, first of all, my first thought, Rich, is redirect was helpful maybe in dealing with some of the delay in getting the materials, but I want to get your thoughts on that and other things. But let me squeeze in a break here first, because I know once you get started, it's very difficult to stop you. So take a break, and we'll come right back. For me, Michael Bryant, hey, try to do the right thing. We're going to continue our coverage of this trial as it continues in Florida. Have a great evening. See you next time right here on Law&Crime.